Hey guys, we have day 5 of the Brendan Banfield trial. That is the au pair double murder affair trial. The state rested yesterday, and we're going to have the defense call witnesses. They said they have 3 ready to go that they think will take up the whole day today, but they're also going to have 1 or 2 extra witnesses in case they need to call them. I want a digital forensics analyst person. Just give me that, finally. Hope everybody's doing well.
Do we have any preliminary matters before the jury comes out? Yes. Could you put your microphone on for me?
I have a motion.
Yes, your motion?
Oh, you're on mute.
Your Honor, this is a motion to dismiss the trial pursuant to due process requirements of the 14th Amendment of the United States Constitution. For the Commonwealth's knowing use of false testimony tainted the trial and must be dismissed pursuant to Napue versus Illinois. I have the cases, Judge, and I can submit those to you. I've given some to counsel. Unlike a motion to strike where we're talking about the sufficiency of the evidence, now the defense is making a motion to dismiss under Napue versus Illinois. This is incumbent upon the moment that you realize what the violation is. And as of yesterday, when the Commonwealth closed, with no detectives, with no evidence relating to the digital forensics, which no evidence relating to the catfish, which has been what they've said all along. It was at that point when they rested that this became incumbent upon me to make this motion. Usually this motion is made in conjunction with a Brady request that's not complied with. It stands for the proposition that if the government knowingly uses false testimony, the trial is tainted, not just for credibility issues, and must be dismissed. In this case, and actually in Napue, the government failed to correct the testimony of a witness co-defendant who stated he was given nothing in exchange for his testimony when the prosecutor knew he was to receive favorable treatment from the sentencing court. This knowing falsity was enough to taint the trial, requiring reversal. For this, a bit of background is required. In September, the Commonwealth gave me a list of probably 65 witnesses. That was the last filed witness list with, that was probably when Mr. Clean was still on the case. There was no, pursuant to the discovery order, any witness list filed for the Commonwealth. It was only when I reached out that I was able to get a list of some names that they potentially might be using, of which Detective Miller, who's the digital forensic detective, was not on there, nor was Detective Bryant. In fact, there were very few police witnesses other than Detective Leach, who we did hear from. As the court notes, you've had this case from the beginning. You've seen the battles for Brady material, which we know were violated because ultimately what came was concluded to be Brady and was known to the Commonwealth back in November of 2024. In fact, even before that. Speaking specifically as to the things that were known or should have been known, is Detective Miller, for Fairfax County digital forensic expert at the time, did an executive summary that was in the October timeframe.
I can't wait to hear from him.
He says that Christine Banfield, he concluded that Christine Banfield never lost control of her devices. And it was she who was reaching out to Mr. Ryan and others on BDSM websites, thus thwarting the theory that the defendant was part of a catfishing scheme to lure Mr. Ryan to the Banfield home to set up a double murder. Detective Miller's report was sent to be peer-reviewed as the chain of command did not like its findings. That peer review was concluded and they concurred with Detective Miller's report. This was known a year before Mr. Banfield's arrest and coincided with Juliana Perez Magalhaes' arrest. During the almost 1 year that Juliana remained in jail, Juliana's counsel requested 2 continuances and never secured a digital forensic scientist. And it's unknown if he knew about Detective Miller's conclusions at the time that he decided to take to advise his client to take the actions that she's taken. When the co-defendant decided to accept the reduced plea for time served and her mother counseled her to take the plea and blame it all on Brendan, There was a highly unusual event for Fairfax County wherein the lead prosecutor for this case, Eric Klingon, questioned and interviewed Juliana in the presence of her counsel and some police detectives. In that video interview, she gave a statement in which multiple occasions of her version did not line up with digital forensics and could not have occurred. Detective Miller was then pressured by.
This is why it was so critical to point out on cross with Juliana, which he did. It was a long cross, but if you missed it, it was very critical that John Carroll caught Juliana not being able to identify the same things that she intentionally identified as being sent by Brendan Banfield while she proffered during this interview with Eric Klingon and law enforcement officials. She intentionally identified 5 specific messages and said Brendan sent these, and it would have been impossible for Brendan to send those, which it's a different issue than, oh, I just don't remember something that happened a year ago. It's her lying to get a plea offer, ink drying.
The detectives in the case to alter his findings to fit Juliana's story, to which he declined and prepared his summary for the homicide unit. He was then transferred without a request to the child exploitation unit. It can be concluded that as of October 2024, the police and the Commonwealth attorneys knew the evidence did not support the catfishing theory. When in October 2025, when she gave her first recant, there were police and prosecutors in there, yet the prosecutor was the one that was questioning. The absolute unprecedented upheaval of the homicide division has been well documented and is directly related to this catfishing theory that was pushed upon and also by the unsupported evidence. At the defense motion for bill of particulars in September, the court asked, is this still a viable alternative for the Commonwealth to prove catfishing, and the Commonwealth committed to that. However, as the evidence ends yesterday, Judge, we have nothing but Juliana Perez Magalhães. That's, as to the motion to strike, I understand the court's position, but these findings and the evidence to support the finding that the Commonwealth knew or should have known is it within every aspect of this case at this point. This is essentially a lack of candor issue, Judge, with the court, and it's in violation of Virginia State Bar Rule 3, which requires candor with the court. Rule 3.8 requires the Commonwealth be the minister of justice, not just an advocate. Further, 3.8 requires a prosecutor to withhold indictment if there is no probable cause. At the time of Mr. Banfield's indictment, the police knew about Detective Miller's findings, and Ms. Perez Magalhães had not changed her story and accepted the Commonwealth's plea deal. These ethical requirements have not been met. But more troubling is the presentation of false evidence by the co-defendant. It is analogous to a prosecutor presenting the testimony of a victim in a rape case knowing the DNA exonerates him but doesn't present it. This known falsity denies the defendant a fair trial. This should be dismissed pursuant to Napue versus Illinois as violative of the 14th Amendment. And there are additional cases, Judge, which I have for your review, which are closely aligned with Napue, which is the seminal case.
Yeah, I'm familiar with those cases.
Paul Miller.
Thank you, Mr. Carroll.
I want to hear from Miller.
Would you?
That's fine.
Oh, yeah, the state gets to respond. What
Yes,
are they
ma'am.
going to say?
Thank you.
Thank you.
Your Honor, counsel has highlighted the Commonwealth's witness list containing 65 people, most of whom we did not call. I expect the same to be true of defense, and that is the nature of a case. When we want to make sure that we do not limit ourselves should evidence be required, we list a witness on that witness list, which is provided to the court well in advance of trial. In this matter, we called the witnesses that we believe presented the evidence clearly to the jury. We have presented the physical evidence collected, we've presented the DNA analysis, we've presented the blood evidence, and there is no requirement
That's not the
that we
issue.
call a lead detective to present a narrative
No.
when we in fact have.
The issue is that what Detective Miller found and the various statements given by Juliana means that Juliana's testimony at this trial were false. And now that the state rested their case yesterday, since that was the last opportunity, they could have said, hey, let's correct this thing. We have a duty of candor to the court. Juliana said something that was knowingly false, and we're aware that it was false because we're aware of this evidence, blah, 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 or we know of her prior statements and how things just couldn't add up the way she was testifying. And I really think this hinges on those 5 messages she identified and using the digital devices. The motion to dismiss, the basis is now that the state is rested, they have exhausted their chance to correct false testimony. And right now the state is getting up here and addressing sufficiency of the evidence, which isn't the issue of this motion. But let's see, maybe that's just how she's starting it off, and maybe she'll get to it. And I think the judge is going to be like, let the jury hear it, because it seems like the defense is going to call Detective Miller,
the person who was in the room, to present that narrative. In this case, counsel argues that Juliana Perez Magales presented false testimony. That's a matter for the jury. Counsel simply doesn't like what she said. That doesn't make it false. At this point in time,
that's also not
Judge,
exactly how it
there's any
works.
merit to this motion, and we would ask you to deny.
All right. Anything further?
No, Your Honor.
All right. I am
Call the
familiar with the
witness.
Napue cases and their prodigy. The Napue cases are a little different from here because in those cases, they were based on a prosecutor's failure to correct testimony that he knew to be false. That's not what we have in this case. There's no evidence the Commonwealth is using false testimony. It's just the weight of the co-defendant's testimony that does go to the jury. I don't have any Brady violations at trial at this time, and none have been alleged. The Commonwealth has presented their evidence, which has survived a motion to strike, but I cannot find any violations of the 14th Amendment. At this time, the co-defendant did provide testimony as to a catfishing theory. The way the Commonwealth puts on their case is up to the Commonwealth. I don't have any evidence or showing that the Commonwealth has used any false statements, testimony that they knew to be false. So therefore, I'm going to deny your motion, okay?
I do not think Judge Penny is going to go with the recommended sentence for Juliana, because she's basically like, well, the issue here is the state. We don't know that the state knew she wasn't telling the truth and that she was giving false testimony.
Thank you.
All right, yes, sir. Are you going to start with the evidence, the exhibits?
Yes.
Okay, that's fine. Have we gone over them?
Yes, we have, Judge.
Okay, and do you have an agreement as to which ones you don't
There are
object to?
several that the Commonwealth would agree may be admitted. There are equally as many that the Commonwealth would object to.
So we'll just go one at a time? Is that the
Probably for the
easiest?
best.
Okay, all right. We ready for the jury then?
Judge, the Commonwealth does have a request.
Okay.
Our expert who testified yesterday, Iris
Oh,
Dallygraph, she has flown home, and we are asking that she be permitted to watch
No.
his expert's testimony through
Oh.
the live feed so that she can then, if recalled
If
in
you have a
rebuttal.
rebuttal. Any objection to that?
No.
Okay, no objection, so
Thank
that's
you.
fine. Thank you.
They're
All
going
right,
to
we're
bring
ready for the
Iris
jury.
back. They're going to bring Iris back. That's the witness we watched most of the day yesterday, guys.
Okay, sure. Yep.
Oh, wrong banner. Yep, so I think this might actually, I mean, this is going to go into week 3 for sure, even if they didn't do a rebuttal, because I think the defense is going to take all day with 3 witnesses, and then they have more after that. At least that's what they predicted yesterday. So if there's a rebuttal, this might end up being a 4-week case with the no Friday courts.
Thank you, ladies and gentlemen. Again, the Commonwealth has rested. The defense will start their case. I believe Mr. Carroll would like to start with submitting some evidence that was referenced in the Commonwealth's case, but he did not present to evidence, so he wants to put that in evidence now, okay? So we'll go through those exhibits.
Thank you, Your Honor.
First defense witness. I want Dr. Miller. I mean, Detective Miller. I don't know why I said doctor. Let me lower this because he yells into the mic when he starts talking. He's like, hello. Oh, we have a sniffle.
Harry, can you see that on the screen?
Yes.
Okay, that would be Exhibit 1. I'd move that into evidence.
Judge, we don't have a
We
display.
don't have a screen.
I'm sorry?
We do not have it on our screen.
Should be on the witness screen. Is it showing now?
No, ma'am, it is not.
Great start.
Can you see it on your screens over here? Yes, you can see it. You can see it in your back screen? There's something wrong with your monitor then.
Okay, we'll just step back.
Okay, that's fine. If that works. We can get, you're attached. You can, it might just be a plug, but. All right. Okay, any objection to defense 1?
No, Judge, there's no objection to defense 1 through 9.
Okay, all right, so defense 1 is in evidence.
Your Honor, I'd ask that that be published to the jury?
It is.
Oh, okay.
Well, finally, we have letters.
Your Honor, sorry.
Oh, no, we're going to read them.
Is counsel intending that the jury read each of the 73 letters?
We do not
73.
have time for that, Mr. Carroll.
Okay.
They'll have them back when they deliberate.
Do you want to read it? I'll pause. Let's read the whole thing because we can skip the lunch break. Okay, so it says, babe, I miss you with all my heart. It's so painful being away from you. And it just got worse and more painful. It's so hard for me to fall asleep. I try to close my eyes and picture you right there next to me, as if you were. It makes me feel better, and at the same time hurts a lot because I know you are not here. The day takes forever to pass. An hour feels like 24 hours. That's why I call it a slow death. Inside, it's just like an eternity. I keep thinking of you all day and night, and like to hum that song you don't like and don't really know the lyrics. LOL, because in case you didn't know, babe, I'm crazy about you. Well, I would be lying if I can't, I don't know what that says. I could live this life without you. If I say I could live this life without you. And I feel that song, I don't know for how long they will keep me away from you, but it won't change anything the way I feel about you. It will just be killing me daily with a sad face. And then I think he's going to read the highlighted
Your
part.
Honor,
We're not have time for that, Mr. Carroll.
Okay.
They'll have them back when they deliberate.
Oh, I like how this display. Oh, for me, it displays in 2 rows.
And this is defendants
cute.
2?
The little love letters,
Too.
All right, no objection from the Commonwealth.
violins. Hey, official infusions from the past. Judging by the handwriting, I feel like it's Juliana because it kind of seemed like girlier handwriting,
that-
but who knows? Who
Defendant
knows?
3, Your Honor?
3, no objection from the Commonwealth.
Oh, should I read the highlighted part? What do you guys want to do? Because I forgot. They said that they were going to do this in the morning before the witnesses are called.
No objection from the Commonwealth.
So we might end up hearing the stuff read twice. Do you want to read everything just because they might only read the highlighted part? This one says, I decided to write and send by mail since it's easier and Faster? The letter is for all of you with all my love. And I think it says, hi, Mom, at the top. It's been a long time and we've been apart. The first time being here, it's hard, painful, terrifying, scary. And it's not even the fact I'm here, of course. It counts a lot. But what hits me hard is being away from you guys, from everyone, not having anybody here to give me a warm hug, hold my hands, not getting any something. God knows my heart is broken. God knows how many times I sit in my mattress, if we can call it a mattress, and cry. Something horrified, how terrified I feel, how scared I am here, and it makes me more terrified thinking of what if they don't let me go home for now or so long? What am I supposed to do? I said it something? How disturbing my thoughts have been recently. I would rather to die than live in this pain. It's just too painful for me. But I want you to know how grateful I am to have you as my mother-in-law and friend. So this is to Tess, Brendan's mom. You are the best I could have asked for. I hate the thought, Court TV logo, something been having in here, the thoughts that I've been having in here. But if it doesn't work out, if they don't let me go, oh boy. Oh, not getting any affection is what that other part said. So I think they're just going to read the highlighted part. So let's read the whole thing.
Exhibit 5.
All right, no objection from the Commonwealth.
Exhibit 6.
Again, no objection in evidence.
But it looked like she crossed out Mom too. All right, so this one has maybe others had dates and I didn't see them, but this looks like November 21st, 2023. So this would have been about a month after Juliana was arrested. Remember, Brendan wasn't arrested until 2024, September 2024. Says, babe, I feel so sad today. It was a hard day. I thought I had court, and even knowing my chances to go home is little, I still expected to hear something. I'm sorry I'm not there to spend Thanksgiving with you guys. I want to believe I'll be there for Christmas and New Year. I really hope so. I already cried a lot in here today. I just feel desperate to go home, to be with you again, or if that is not possible, I don't want to live this. I don't want to keep living, keep going. I would rather get myself sick or something worse to happen to me than living without you. And I mean it. I've been thinking a lot about it. It hurts me a lot seeing the days, week, months passing, and I'm still here and I can't see or be with you. I can't talk to my family in Brazil. That's terrifying. The days here, I just want this to be over in one way or another, a good or a bad way. It's terrifying when they lock us in our cells for no reason, for nothing, and I can't talk with you at all. I'll never understand why they treat us like something I can't read. We are not doing anything to them. Being here is already a punishment, so... And I really mean it. I think that in October of 2024, when she has she's hospitalized, she has a health crisis, I really think that's something that comes from emotions. And I think we heard a little hint about Eric Klingen and the law enforcement officers going to speak with Juliana right before that happened. And I don't know if we're going to get information on that in front of the jury, but I really, really think because the article in the news from that same time period is when Eric Klingen is talking about statements from other women that Brendan had affairs with. I really think Juliana got the word that in 2024, Brendan was messing with other women. Or at least that's what the prosecution was telling her. So she got sick. She flipped. That's my opinion. And reading these letters, even though this is from 2023, kind of taking me further there.
Exhibit 7.
Again, no objection.
Exhibit 8.
All right, no objection from the Commonwealth.
Exhibit 9.
All right, again, no objection from the Commonwealth.
All right, this one looks like December 4th, 2023. Hi, babe. Well, this letter is just in case if I don't make it again through my bond hearing or even my preliminary hearing, who knows. I really hope I make it, though. Make it through. I want you to understand what is going on, and this is the only way, so you can also understand why I'm so afraid. Well, they arrested me for the obvious reason, right? But they want me to cooperate against you because according to them, I know more than it's being said. And they say they know more than I think they know. I know a few things they have related to you and to me. I said before that I'll be basically talking for both of us since they have me here. They've said about fingerprints on the it looks like the letter K, and then camera of the neighborhood that shows our driveway. Statement, which we didn't see. We didn't really see that, did we? Statement or someone that saw us together in February. So they say I know more than I told them. At the police station on October 13th, they showed me our pics from last year, my shoes, the something of other girls on your phone that you had. And they said, you are not the only... Oh.
And I think Exhibit 10 is where
Right. If you could put it on.
I'll show it.
Yeah, if you could put it on the screen, please, so I can see it. Okay.
Yes, and
All right.
Judge Commonwealth objects as this is an incomplete exhibit. It identifies itself as being one
man.
of 3 pages. Only 2 pages are present. The last sentence on the second page clearly indicates there is more to come that has been eliminated from the
Do you have the
exhibit.
third page to this?
I don't have it with me right now, Judge, but she's identified this as something that she wrote. She's identified, nothing's been excluded intentionally.
I understand, but there is a page 3 of 3 that's not there. So at this time, I'll sustain the Commonwealth's objection. If you, at some point, find page 3, we can readdress.
Okay.
No objection to 11 through 15.
Okay, no objection, 11 through 15.
This is 11 year, I'm sorry. Yeah, 11.
All right, in evidence.
This is Exhibit 12.
In evidence.
Exhibit 13.
Okay.
All right.
Exhibit 14.
Oh, so this one has a cute little signature at the top. It says Juliana and Brendan with a heart. With a little love you message on the right hand side, and then it's dated April 14th, 2024, 12 a.m. midnight. Is she writing this at midnight? She's putting a timestamp on a paper. So I know what I had said in the last letter. I know, and we didn't see those. There's presumably other letters. January, February, March. I know what I said in the last letter. I know how I feel about you, about us, and I'm really grateful for everything you've been doing for me, for us. Also, I know maybe you don't share all your struggles, neither do I. I don't want to be vulnerable with you. I don't want to tell you all the time. I cry during the day or every night to go to sleep. I don't want to share the times. Even the deputies call me in the hall to talk because they hear me crying, or because I just stay in my room even when we're not in lock-in and gamble. I can't read what's next. Like the roommates come to me asking, Juliana, are you okay? I don't share when we have video chat, and I try to keep myself, and then that's what it's cut off. This to me sounds like Brendan is not giving her the warmth in response in the letters, and she's got to emphasize, like, everybody else notices I'm hurt. So, acknowledge me.
All right, in evidence.
Oh, there's a little more. No. Let's see.
Exhibit 14.
All right, in evidence.
Oh, yeah, we're not going to do that. Okay. Also, I know maybe you don't share all... Wait. We read that. Keep myself quiet about it. I don't... want to cry. All right, this is just getting too blurry at the bottom. I don't want to tell you over and over again how I tried my insecurities, or I had my insecurities about you, my thoughts and insecurities, something longer. There you go. I can't read all of that, but she's talking about her insecurities.
Exhibit 14.
All right, in evidence.
And then another page, it's going on to page 2 that says truly and forever yours. Whenever this is over, and I owe them a lot after so long, after everything that happened, I should be with them. That is not fair to them what happened. That's not fair. That's to pull that trigger. I didn't consider them. That is not, and it's underlined, fair. It shouldn't have never happened. Like I always say, I don't regret you at all or everything we have done and lived together. I really just hope I have the chance to be with them again back home. I really do. I can't stand the thought of not being with them anymore for my own mistake. If I understand right, you said something about that's what I want or something. First, that's not just what I want. I want to read the whole thing.
And exhibit 15.
15 in evidence.
All right, so this one, there's a song lyric at the top. I think it says I'm a little bit what? And then it says, the letter says, sometimes I just think to myself, like, I can't believe I'm facing life in prison for someone? For someone? Oh, like for someone else. Then things weren't supposed to be like this way, right? But people are stupid, including me with a smiley face, and make mistakes, act without thinking. That's all I did. When was this dated? So then who's she talking to? I want to see.
15 in evidence.
We're going to have to hear. I wonder if that's to like a family member or friend. I forget what her friend's name was. Paula.
I believe that was it for the agreed exhibits.
All right, 16, if you could pull it up. And what will the objection be for 16?
Same objection, Judge.
Okay.
This appears to be 2 pages of a longer letter, while this one does not identify how many pages were originally contained. The last sentence on the second page is cut short, so there is
All right.
clearly additional information that was not included by defense.
If you could go all the way down, Mr. Carroll.
No, I need that one. I want to read that one.
All right, so I'll sustain the objection again if you can find the rest of
Okay.
it. That's fine. And then 17,
And Judge, Commonwealth would not object to 17 through 41. I'm sorry, 17 through 42.
so can we just enter 17 through 42 in evidence instead of showing it briefly?
That's fine. I wasn't certain.
That's
sure.
fine by me, but I just want to make sure you're comfortable with it. But they'll have
I'm
all of
comfortable
these.
with it. Yeah, no,
Okay,
I'm comfortable
perfect.
with
All
that.
We'll
right,
speed through
17
this.
through, I'm sorry, what number?
42.
All right, so 17 through 42 in evidence.
And
And then if you could pull up
43.
43, okay, what's the objection to 43?
Judge, this is a letter that purports to be from a third party to a witness. This is hearsay. It is not admissible. That person has not been called to testify.
All right, any response to that?
Plan to call them.
it's not offered for the truth of the matter, Judge. It's
Then
offered
what
for the
is-
subject matter, I guess.
Then Judge, I would object. It's not relevant.
No, I'll sustain the objection as to hearsay. Okay. That's 43. And then 44, do you have an objection?
Yes, Judge. No, I'm sorry, 44, no objection, 45, no objection, 46, no objection. Our next objection doesn't hit till 51. So
Okay.
through 40, I'm sorry, through 50, no objection.
All right, 44, 45, 46, 47, 48, 49, and 50 in evidence. If you could pull up 51.
And Judge, the objection is that 51 and 53 are duplicates. If he could elect which one he would.
Oh, they're the same?
Yeah, Judge,
Okay,
and I
which
was
which
gonna
one?
identify that as well.
Sure, which one would you like, 51 or 53?
Let's go with 51 and
All right, we'll
withdraw
put
53.
51 and withdraw 53.
No objection then to 52,
Okay,
54,
okay,
through 56. Our next objection is 57.
all right. So 55 and 56 also, and 54 in evidence, 57. That's the one from the producer, correct?
Correct,
So
hearsay.
assuming objection is hearsay?
Correct.
Judge, I'm offering it not for the truth of the matter, but for the timing of the matter.
I'll sustain the objection as to hearsay 57. All right. She already testified to it. They still have that information. 58
No objection, 59, no objection, 60 objection, third party to,
from her mom. Okay,
Correct.
you can pull up 60. So 58 and 59 are in evidence.
60, Your Honor?
Yes, the objection is hearsay.
Hearsay?
Yes.
Once again, it's the timing of it that I'm looking for, but I understand.
Okay, I'll sustain the objection as to 60. We have 61.
objection.
I think it's a motion
It
to
is.
continue trial. Okay, what's the objection? I mean, that's a court record, but what's the objection?
Judge, it's not a court record in this case.
That's true.
And it contains a number of opinions of counsel.
Okay.
That I do not believe have been testified
All right.
to. So hearsay.
All right.
I think it's a judicial document that the court can take notice of. It also shows the timing of what it is that, in terms of the timing of when this motion is being said, it's weeks before her pending trial.
Which she testified to, and you do have evidence of that, but this does contain hearsay, so I'll sustain the objection to 61. 62 is a picture.
Objection, it is actually a video. It's the recorded call and is hearsay.
Okay, all
It's-
right.
it's-
So don't,
I'm sorry.
go ahead.
Do you want me to open it up?
No, I don't need you to open it up. I recall. You had just showed the picture. I didn't allow the video at the time, if I remember correctly.
Right, and
I'm sorry, Your Honor.
Yeah, no, I had just had a picture of it at the time of the testimony. I didn't allow the video at the time.
Correct.
The audio.
Correct.
I think it was an audio file, yes.
And this is an audio file of her negotiating with a producer relating to Hulu, Netflix.
All right, I'm going to sustain the objection then. Thank you. 63,
No objection, Your Honor. Next objection would be to 70.
all right, so 63, 64, 65, 66, 67, 68,
We're almost done, Chad.
69, and if we can go to 70, I think that's a conversation.
And
What's that
Judge,
conversation?
the objection here is to relevance. I'm not sure. It's such a brief portion of a conversation and it doesn't appear to have.
If you have a way to close that for me, Mr. Carroll, I'd appreciate it. I think that closes the whole PowerPoint. If you do that. What was the time frame of the conversation? Do you recall, or do you have it?
Judge, I can pull it up.
I just can't see.
Judge, I don't know why that's popping up.
I'm not
This is the court's computer.
Oh,
I think you have to sign into your account on that computer, but that's.
So Judge, the chat begins on January 9th. It is purportedly between Christine's phone and an unidentified user.
Feel better,
And
Miss
it talks about
Janet.
having had fun that day with Valerie.
Okay, and that's been, the code defendant testified that that was a conversation she had with Christine, correct? And your
I believe
objection
so.
is relevance?
My objection is relevance. I'm not sure where this has to
All
do.
right, how is this conversation relevant?
The January 9th is an important date, as the testimony is brought out. It's the date when the email was set up for the connection with all of the devices.
All right, I'll overrule the objection. 70 is an evidence, overcome its objection. And then
Uh-oh.
71,
Objection, Your Honor. Those are portions of a document. Best evidence would be the objection. It needs to be the
entire
entirety
document.
of the document.
all right, are you able to get the entire document for January, I think it's January 21st, 2023?
We have admitted it into evidence.
Okay. So you already have the entire document in
Correct.
evidence?
It has been
All right, so do we
admitted.
need this then, Mr. Carroll? This is just parts of it,
These were the FetLife communications, Judge.
which they already have in evidence. I can't remember what number their evidence. Do you
Is
have
it
the
all of
number?
them?
I do, Judge. 77 through 79.
Is the entirety of what is
Correct.
parts on this? Okay.
If that's, I'll withdraw that.
All right, we'll withdraw 71. That takes us to 80.
Is Council not offering 72, 73, 74,
I
75?
think we're offering to 71, Judge.
All I have is the 71. Are you not doing 80, 80A, B, C, D?
Not at this
81?
point, Judge.
Okay. That's all I have then, right? Okay. All right, yes, sir, then your first witness?
Judge, I would call Officer Beckner.
Officer Beckner. You might want to check the plugs and see. if
Yeah,
they're-
so it actually clicked on, initially, there was a view of that computer's screen.
It might just be a loose wire.
So I think Officer Beckner was called on day 1.
There we go.
I think he was like the second officer.
Are we good?
Yep.
Okay, good.
We got it. Nope, other way. Just, there you go.
He's the one that searched Brendan Banfield.
Are you doing this one? I don't think there are any questions, so I'm just gonna do it.
Unless there's another Beckner.
Good morning, Officer.
Good morning, sir.
Once I get this video, I'm going to ask you to identify it.
Okay.
Okay?
Thank you,
Sir, can
Touche,
you
for
state
the
your name for the
super.
record?
Zachary Beckner.
Thank you.
Yeah, so you guys remember him? He's the one that like searched in the ambulance with Brendan Banfield and took the 2 phones. I think he also talked a little bit about that he thought Christine was still breathing based on what he heard EMS saying. Touche says the fact that she shamelessly took a woman's husband in her own house, posted it on the internet, helped kill 2 people, and says all I did was something stupid with a smiley face. Danger to us all.
Sir, do you see that?
People do crazy things for love,
picture on the
man.
screen?
Yes, sir, I do know.
Do you? Sorry.
I'm just sorry, is this a video that's already in evidence, or is this video that you are?
This is, so there's, Judge, I'll just tell you, the Commonwealth moved in first 6 minutes
Okay,
of
so
this video,
this
and
is-
this is going to be a continuation
All right,
beyond
so
that.
this, what would you mark it as your exhibit then?
I think we're at 84, are we?
We are, let's see. 82, if you want to go in order.
Let's go in order, yes.
Okay,
thank you.
82, okay, thank you.
Sir, I'm going to ask you to look at that picture and tell the ladies and gentlemen of the jury if you can identify what you see there.
It appears to be body cam footage, sir.
Okay, and was this the body camera video from your body cam?
I believe so, yes, sir.
Okay, and this was on, what date was this on?
February 24th, 2023.
Okay, and this is the, what if anything are you doing as you go in?
From this, I'm about to enter the house.
Your Honor, he's identified the video. Can we publish this to the jury?
You want to admit it into evidence?
Oh, yay, we get to
Is it
watch
under
it.
seal?
I think
Maybe.
it is
Okay.
because of the graphic nature of it.
All right, so 82, any objection, 82 under seal? All right, 82 in evidence, under seal.
So we'll get to listen, I think, but not watch it.
Anybody else downstairs?
We watched some of this on YouTube.
Hold down, somebody hold down.
Brother, they're saying one of the patients is outside now.
So somebody's outside. In the back? Anybody else outside? Who else is outside?
Nobody's outside.
Anybody over here?
In here.
Here, ma'am, stay here, ma'am. Hey. Stay right here. Who is the shooter? Who shot who?
Brendan, he's an officer.
I got a blowout kit if you need it.
Bring it up.
Is there anyone else in the house? You need kids in the house?
Ma'am, I need you outside now.
What do you need?
Get medics in there now.
Scene's cold for medics.
He grabbed my arm. He grabbed my arm when I started to come.
Sir, at this point, had you engaged in any duties at what you're seeing right now in the video?
Could you clarify what you mean by this?
What were you doing? What were you asked to do? What did you take it upon yourself to do?
We were trying to locate a chest seal in the medical kits that we carry in our cruisers.
Okay, and that's something that you had with you?
That's what the black bag is that I sat down on that bed.
Okay.
Get it, don't do with him. I don't know where he shot at. Who's that chest wound seal? I need it from the cap here now. You got stabbed by him, so watch him.
I have one.
Guys, chest seal. Now.
We're looking for it, buddy. We're looking for it. Get gauze out.
Up this way.
Upstairs. Hey, Chris, seal over and I'll get it right now.
Just stay right there. Stay right there. There's another one behind you.
Hey, open this up for Balmer.
Yeah.
I got the other one for him. Okay, go.
What do we need? Someone check for a pulse for the guy behind me.
Yeah. Zach, go
He's
ahead.
breathing, so.
We got one guy up here, gunshot wound, one female, multiple stab wounds.
Can someone do this for me?
I don't have anything.
Kind of tied up now. Up this way. Just go in the car. Just in the car. He's in the bathroom, up here.
I don't have a pulse on him.
He got on that. Multiple stab wounds on
I
that.
don't have a pulse on him.
Where's the gunshot wound?
I believe they've already established.
I'm not entirely certain, sir.
Let's check.
One male with a gunshot wound.
Chest.
Okay. Hold this down. Let's work on her, okay?
Sit in the tub. Sit in the tub. Sit in the tub.
The tub.
You need another chest seal?
Yeah, whatever you have.
Whatever you. Hey, get another ALT, get more blowout kits.
Okay, Liberty down to Fort Lee, okay.
Anything else that you know?
Covered by Bravo, and Preston County Court.
I don't know. You shot in the head?
Shot in the chest.
It's a lot of blood. It looks like it's probably from a lung.
No need for canine or helo at this point. Canine 10. Yeah,
I don't even know what to do.
Firearm.
Just leave it. Just leave it. Where is it? Alright. Okay.
Yep.
Since we got this kind of wait for medics, can you talk with him?
I don't have a pulse.
Stand by 1 second.
Medics expediting, or where are they at?
I can go home. Guys. Hey, do you have a pulse on you?
No, not at all. What do you need?
Go ahead.
Multiple stab wounds on her.
Go ahead. Start going. Who's most viable, you guys know? She is. Alright. Multiple stab wounds to the neck. Where is he?
To the right, we have a pulse, multiple stab wounds. To the left, you can see the other gunshot wound.
Alright. Who's still breathing?
We're here.
Don't know if it's one on the left side.
Okay, she's still breathing?
We can feel blood moving.
We can see her. You can stop him if you're trying. Yeah, we're gonna get her.
He's gonna be away over there.
Yeah, this. Is she breathing over here? She's breathing. That's why we're moving. Grab him, take him downstairs. I can't feel a pulse. You can't feel a pulse? It's hard to feel. Are you hurt? Stand by. Sorry. Nope, there's no pulse wound, dude.
Nothing? There's nothing.
What do we need?
I think that guy's gonna be definitely DOA for this shot. I mean, we can. I think that might be obvious over there. She's gonna come over here. This is my way. I don't know.
Oh,
What do you want to do? You want to grab that and go?
this is his house, that's his wife. Don't know who this is.
She's done.
All right, that's fine. I don't know. You want to get a rhythm on that?
Yeah. You want to? I got the monitor. It's right there behind you. You have it? Okay. So where is she? Grab the guy out there. Get it down. This is not Balmer's.
There was two on the bed when I came in.
Okay, this one's got blood on it. So stay with him. I'm not sure if he doesn't know.
This one's got blood on it, like the gun.
I'm gonna wait till we're done.
You don't know that guy. You know him. Yeah.
I'm just trying to figure out where's the gun currently.
On the bed.
Firearms right here.
Leave them right where they are, if that's where we found them.
We moved them away.
All right, that's fine.
They were on the bed boat. We have a knife right here.
You guys are good.
Yeah.
Knife.
Hey, Sarge.
What's up?
Do you want us to escort him outside?
Yeah, right now they're working, so we're just gonna wait one more.
So, hey, we're not working.
I'll get him out.
So once they, is she
Alright.
gonna be okay? You let them work through it?
Want to move her and go?
Yeah, that's just move her and go. Alright. Get you downstairs. Okay.
Alright, we're gonna move you.
Very close to where I stood her down.
Got a knife here.
Yeah. Is there kids down there? Zach, kids around the way. Kids are outside. We're gonna clear the rest of the house.
Okay, someone's gotta go with them.
Okay.
You guys want me to go with them?
If you want to go with me, that's fine. Zach, stay here.
All right.
You're with me. We're gonna check the rest of the house. What are we doing here? He's just saying we're gonna make sure no one else is hurt in the house. Okay. All right. We're gonna get something down there.
Sir, that's the video that you previously watched, the Commonwealth's case, correct? Up to the 6-minute mark?
Yes, sir.
Okay, was your body camera continuing beyond that?
Yes, sir.
Okay, and approximately how long did you, were you escorting Mr. Banfield that day?
Correct. I escorted him out of the house to the ambulance, rode in the ambulance with him to the hospital.
Okay. Your Honor, that clip was identical to what the Commonwealth did. I have the longer clip, and I'm just going to switch that out right now so we can go from this point and continue on with the clip.
So 82 should just be your second part?
Yes, yes.
Okay, so we'll keep this, what we just watched will stay as the Commonwealth's exhibit, and then now 82 will just be what you're going to play from here on out?
Yeah, from 6:42 on.
And you'll have a separate file? You have a separate file for that? For
Yes,
me? Okay.
I just have to.
Okay, so 82 will just be that separate file then?
Okay.
Okay. I assume there's no objection to the continuing of the body cam?
No, ma'am, and just for clarification, what we just watched was Commonwealth 6.
Number 6?
Yes.
Okay, so that will stay at Commonwealth 6, and then whatever we're about to play now will be 82, and I assume there's no objection to the rest of the body cam?
Correct.
Okay. So 82 will be in evidence. Under seal.
It's 'cause you disconnected it.
We're gonna get something down there.
Alright, guys.
Somebody get behind you.
PA was really,
Sir, do you recognize that as being continuation of the video?
Yes, sir.
Okay, thank you.
So she's gonna go up to, obviously, that's gonna be the closest one to that. He's obviously gonna
Hey, can you check him out?
Yeah, I got more units here, we'll check him out.
He's starting to break down a little
Stay sorry, I'll just do walk through, okay?
What did you say the other day? Okay. The striker there! We're gonna have to get him out of here.
Yeah, I know.
Can you give him a second? Don't touch anything else.
I'm not. Let me change my gloves out. We can get him out of here. Knife's there, guns are on the bed. I got you.
We're gonna take him and stick him in a freezer.
Yeah, I gotta hook him up, guys.
He's having a breakdown.
Yeah, just give him a second.
I gotta put him on the monitor.
Yeah, go for it. Is she what they? So the fire department, they take over at this point. We're kind of just here. Is she breathing? So again, they're down there. What I want to do is get
Just
you
watch what
downstairs,
you're
get you
kicking,
outside
please.
the accident. All right. Does that work?
I know what you gotta do. I'm just.
If you can't walk, we can wait a minute. Give me a minute.
Now, was that you saying, watch what you're kicking?
Yes, sir.
Okay.
The knife.
And was that directed toward anyone in the room there?
It was directed towards the firefighter that you saw with the face covering on, the mask.
The one who came by you to your right?
Correct.
Okay. And was he tending to the scene over near Joe Ryan?
Correct. He was hooking him up to leads.
Okay. And was there distortion of how it looked before he?
Objection, leading.
All right, I'll sustain as to leading if you want to rephrase.
When you said stop kicking, what were you referring to?
He had kicked some blankets out of the way.
Okay. Do you remember the colors of those blankets?
I believe they were purple.
Purple? Okay. Were they the only blankets or towels that were in that area?
I don't remember, sir.
Okay. You just remember him kicking?
Correct.
Okay. Do you remember if he kicked anything else in the crime scene?
Not that I'm aware of, no,
Okay.
sir.
He stopped after you?
After I told him to.
Okay. Thank you.
Yeah, just giving you some fresh air right now at the glove, okay? So we can get you outside.
You got gloves on?
Yes.
Can you help him? Just be with him?
Yep.
Now, you're holding Mr. Banfield, my client, at that time. What was the reason for you to hold him?
He was unsteady on his feet, sir.
Okay. Did you hear him say anything or relating to his ability to walk?
At that point in time, no, sir.
No, sir?
No, sir.
Oh, okay. But you, sometime later on in this video?
Correct.
Okay. Thank you.
Whenever, what's your name?
Brendan, Banfield.
Say, with Vienna?
Easy. I'm sorry, say it again.
So you with Vienna?
My office is in Vienna, correct. Did you call my office?
No.
I need to call my manager at some point.
It's the least of our worries right now, man.
We're just gonna get you in a cruiser outside in the air where you can breathe. You're okay, okay? You're not hurt?
I don't think so.
We'll check him out when we get him over to the car.
Nothing but I'm looking this way.
You have an awesome automobile there.
Watch out, watch out.
Step off into the grass? Yep.
What's wrong with your right leg, sir?
I don't know, maybe just nervous.
Okay.
I'm going to be calling medics 436 to Reston Hospital.
Take some deep breaths, all right?
You need to sit down somewhere now. Is there a way to get an update? Right now.
They're handling everything from here. He doesn't think so. We haven't had a chance to really do a full inspection quite yet. If you guys want to check him out.
Yeah, we can do that.
He's just a little unsteady on his feet, though.
We can go put him in the ambulance.
All right, let's do that then.
We're going to go ahead and check this gentleman out in the back of the ambulance, okay? We'll check this one, make a
Officer Beckner, had my client complained of any physical ailments other than having difficulty walking?
Just whatever he said was going on with his right leg.
Okay.
That was it.
And when you said you were going to go check him out, was there anything that caused you alarm that caused you to want to have him checked out?
I just wanted to make sure he was okay.
Okay, thank you.
Where's my daughter?
I think she's out there with them, sir. Is there anybody else in the house other than your daughter and the other female?
So she's an au pair nanny.
Okay.
She lives with us.
But it's just the two of them, correct?
Yeah.
Okay.
And my daughter.
Just one sec, we're gonna hit around this other door here, alright? A little bit of blood on you, I have to sit here, okay? Right here.
tie it as crease as you can.
Yeah.
Is anything bothering you right now?
I feel unsteady.
Okay. Were you hit with anything? A knife? Anything?
No, I took the knife. I took the knife from him.
Okay. All right. So you're not hurt anywhere. Is that not your blood, correct?
I think it's.
All right. You want to slip this jacket off for me so we can evaluate you real quick? I'm gonna have you kick your other foot up for me.
Yeah,
So you
I
can
think
get
it's
off.
yeah.
Hey, Hunter Bravo. Scout 800 Bravo.
That might be a bag in my car.
Take the pressure, all right?
Info's going to be set up at Stablebrook Way in Silver Court.
Officer Beckner, do you know who took possession of the jacket when it was taken off of him?
Officer Hugh.
Officer Hugh?
Yes, sir.
Okay, thank you.
I'm just gonna take your watch off for now, all right?
That's fine.
So I can see. I give it to the officer standing behind you. Where'd all this blood come from, do you know?
I was holding her neck.
Okay.
Do we have any crossings that need to be covered?
511
Is there a way to
Bravo,
get an
I've got
update
one
on
up at
They're
House
taking
Tavern
her
in
to the
front of
hospital right now. They're
Grangeville.
not gonna have much of an update. They're gonna take her to the rest of the hospital, okay? Yeah. I don't see any wounds on you. I'm just gonna check you out. Would you like to run up to the hospital?
Can I be with her?
They're gonna work on her when they get there. You wouldn't be able to see her immediately anyway. If you do choose to go.
Yes, I want.
Hey,
I want
downgrade.
to be with her.
Okay, then we'll take you up there for evaluation then, okay?
Sure. What's gonna happen to my daughter?
That I'm not sure. That's a
As
question
of
for the
right now, I
officers.
believe she's sitting with one of our officers until we figure out what all is going on.
Take her back.
Say again that last crossing.
Hey, Doherty, it's going to be Drainsville at 8:50 to 9:20, right there in front of the Kiss and Ride.
Guys, get squeezed real tight. Alright, perfect. We'll take all that off then. Take it off there. Okay. Take this off for you, man. So just to confirm, nothing's bothering you right now, right? Physically, you weren't injured at all.
Anything hurting you at all, man? They're trying to find out so we can make sure we get you help too.
Yeah, door's pulling out of here. You guys.
We're going to need his,
No, you're good. You're good. Take your hands down.
That's fine.
If not,
you're not going to be able to have him in the hospital anyway?
yeah, let me have the wiper.
I have cuffs.
Okay. What department are you with?
Department of Treasury, Internal Revenue Services.
Okay.
And I got
It's okay. Those can stay for right now. That's fine.
Zach?
Yeah.
So before you roll, let me make sure they decontaminate what you have on you, okay?
Okay. I don't think I've got anything directly on me, but, hey, Derek.
Yeah.
I've got mags in his watch. If you want to hold on to this.
What was that?
I've got mags in his watch. I'm going to go with them to the hospital. East Department,
a bag. I don't have an answer to that right now. I wish I did, but I don't. I'm sure they'll get you an update as soon as they can. The question is, would you like to go with us or would you like to go with the police?
It doesn't matter.
Okay.
If I can be with her, that's what.
Just use one of the medics have, one of the bags the medics have.
You know what, though? I know that there's going to be interpretations like this is legitimately a panic attack or I think he's faking it. But you know what I think is interesting? The state didn't want to play this part. I think that's particularly interesting. And I know that's not intrinsic to the content of the body cam audio itself. But I think it's interesting that the state didn't want to just play this in full, even though they discussed what was happening here. And they could have played it. Also, shout out to Dolly Talk coming in here with the raid. We are listening to, this witness was on the stand during the state's case in chief. The defense has now called him as a witness in their case in chief. It's the first defense witness. So re-listening to some body cam audio, and we've gone longer than the clip, the portion that was played by the state. Also, huge shout out here to Sheriff Chuck turning some people green. Big thank you here. Always super generous, gifting so many memberships and turning the chat green. So big thank you. And EDW Raptor with another 5. Look at that. We've got 10 new gifts today thanks to Sheriff Chuck and EDW Raptor. Thank you, EDW Raptor. So we are here. We are here. We're hearing some stuff for the first time. And I know I'll try to tell the chat when the audio has completed for anyone that doesn't want to listen to it.
What is he looking for?
Just a plastic
assuming so,
bag.
Zach, did we?
A what?
Plastic bag.
Just right now, did we search them?
No, I haven't searched them yet.
You want to stand up?
Sorry, man, it's fine.
I have.
You're good.
Sorry.
I know.
That's fine. Yep.
I'll leave his badge on him.
You know the procedure, we apologize. It's fine.
Knives or anything on it?
No, that's my cell phone. Work cell phone. And personal cell
And
phone.
you're with the
Treasury.
Okay.
Did you get him a bag? A bio bag? Do you have a bio bag?
Yes.
Anything on that side, Terry?
Yeah,
He's going.
Yeah, that's what he did. Yeah, he's back if you want to
I think there's a couple.
He's treasurer special agent.
Officer, is there a policy about searching someone who goes in an ambulance, or what were the circumstances that caused that search?
We were just trying to confirm he didn't have any further weapons on him, sir.
Okay, after he told the fireman that he had the mags?
I believe that's what he said to him.
Okay.
Zach, you gonna go?
Yeah, I'll ride with him. That's fine.
My badge and wallet is in my jacket.
Your badge is clipped on your brother. We're gonna leave it on you, okay?
All right.
My credentials.
Okay.
Yep, that's fine. Just go ahead. You can sit back down. You're all right.
I'm gonna calm him down.
Okay.
I'll calm him down in the hospital.
Okay.
You're gonna be in the ambulance?
Yeah, that's fine. Unless Zach, you
What would
see
you-
my iPad right there. Yeah.
Zach, you got gloves on? Put his here. Put his stuff in here.
I'll follow you guys down too, so.
All right. Whoever's driving my car, that was acting.
We'll have to figure that out later.
Sir, was yours the Glock 19 with the TLR?
Mine has the light, yeah.
With the light on? Okay.
My other gun is my personal weapon.
Oh, that's the 43X?
Yeah.
So both those are yours?
Both of them are mine.
Okay, the ones that we saw on the bed, correct?
Correct.
Okay, thank you, sir.
Where do you guys need me at?
It doesn't matter to me. You can probably sit in the captain's chair right there if you're going to ride with us.
He's gonna go.
I'll ride with
Okay.
you. Yeah.
Just for evaluation.
You guys
Yeah.
are good? You
Okay, sure, good idea.
Yeah.
Okay, BLS good,
Yeah.
absolutely.
If you guys don't need anything else,
No, we're good, yeah, go ahead.
we'll head out and we'll take the EMS captain, plug you up, and meet him at rest.
Okay, yeah, command's terminated, so I'm out of here.
All right, yeah, we're good then.
All right, and we're gonna roll over to Reston Hospital then.
Okay, sounds good.
All right, we're good, Zach. 2 to Reston. All right. You going with me?
Yeah.
Are we good to go or?
Yeah. To my knowledge, I'll double check real quick.
20 Bravo.
What's your first name?
Brendan. BREND.
Hey, are we good to transport him to the hospital?
Last name?
Banfield. BANFIELD.
What's your date of birth?
2/23/85.
Hey, LT or Givens, are we good to transport to the hospital?
Any underlying medical conditions? Upper blood, hypertension, and any cardiac issues? Take any medications for anything? Any allergies to any medications? No. besides you think they were injured?
I don't know, man, to be honest with you. I don't see why it would be an issue, but I'll hold off for right now.
Alright.
No way to get him up here.
No, not really. He's get to the hospital. I wish I had more for you, but I don't. Hospital can't tell me anything like that over the phone. They know you're coming and they know your wife.
That's my wife.
They know your wife is there. So I'll be ready for you when you get there.
Right now, she's still over there. From what I understand, sir, she's there with the other officers that are still on scene.
Are they going to tell her?
I mean, as of right now, there's really no other information to explain to her. I don't think they're going to tell her anything. It's kind of a delicate matter, and I don't think anybody wants to upset her currently.
She's only 4.
Yes, sir, I understand that.
Zach, copy on one.
Go ahead.
And the gentleman that you're with, do me a favor, once you get all this information, give me a call with that, please.
Direct. I don't have my phones on me. Spell your last name for me, sir.
Yeah, I got it on your pen just
Okay. Appreciate it, brother. You're with the IRS, correct?
reported. MTV reported. You don't have to see the event. Stay one way.
Okay, they actually sound like they're... Oh. They're turning a lot more, which makes me think they're getting closer to where they're gonna stop.
I apologize. The hazard is on the channel. 10-1, Central Channel, Clipper, receive traffic.
You okay with walking in? We'll head out because we're here, okay?
Yeah.
All right, I'll have you step back out this side door that we came in.
Yes. Go, sir.
Step down there. Yep.
Just wait right here for us. We're trying to find out what room to put you in.
Can I see her?
No, not yet.
Any voters on channel 3 or 5?
Just take a seat on the bed for me.
He just said that she didn't make
I didn't hear what he said, so.
The cot and stuff probably needs to be switched out.
Can you have someone check with him again?
Okay, what is the nature of the incident?
Check what?
The status of his wife, ma'am.
Hi, sir. My name is Dina. I'm one of the doctors here. Your wife has died.
Wow, that was cold. What? That was cold. That caught me off guard. And I already know she's dead.
Okay, what is the nature of the incident?
Check what?
The status of his wife, ma'am.
Hi, sir. My name is Dina. I'm one of the doctors here. Your wife has died.
This is important.
Oh, I have like a chill from how she said that.
Where's the other?
Where's what?
She's still at the scene, sir. She's with the other officers.
Would you guys be able to ask someone else to bring some tissues? That's been nice.
This is where he gets snotty.
Okay. We're still burning. Just a heads up. Body cams are still on.
Okay.
It's okay.
Just yell at me. I'll get out of your way.
What's up, Lauren? They said he wants to be evaluated, so. Okay, no problem.
That's, in the audio, that's Brendan crying. That's the noise we're hearing is Brendan. And a bunch of beeps.
Do you want, just for a napkin?
Crazy.
Were you there at the time?
Yes.
You were there at the time. So is there any part that I can help, I can explain what happened when she arrived here, but you were there and it sounds like there was a lot of blood loss.
Yes.
And so I think that she died of blood loss. Her airway was actually okay. I'll call the medical examiner, of course, and we'll do an autopsy and make sure we know for
Yes.
certain. But
I was trying to apply pressure.
yeah. I mean, those were enormous wounds, and it's not.
There were so many.
Yes, and the neck is not compressible, so
airway
it's
was
not
okay.
possible really to stop all the blood loss. And her airway, it seems like, was in the midline okay. She was able to be intubated. Everything that was possible to be done was done for her right away. You did a wonderful, you did everything that was possible. It's not a survivable injury.
It sounds like the same voice. It sounds like the same doctor voice, so I say yes. Not we did a wonderful.
Is someone with her daughter? With her daughter?
Yeah. We still have officers at the scene with her.
Okay. Just want to make sure that she's safe.
Yeah, she's safe. Yes, ma'am.
She's only 4.
Yes, sir.
These for him. And did you get hurt, sir?
I think so.
Are you certain? Did the person come after you at all? Did they hit you or?
I think he put his arm on me at one point, but I don't think I'm hurt.
Yeah, sure. You have tissues here. You want to wash your hands? Probably probably feel better after that. So
Officer, is this the situation that the Commonwealth asked you about when you were originally on the stand?
About him washing his hands?
Washing the hands?
Correct.
Yes. And you weren't advised by anybody in your chain of command to not allow washing hands or anything like that?
At that point in time, no, sir.
I'm sorry?
At that point in time, no, sir.
Okay.
I'm the first person in here today. I'm so sorry for your loss.
My wife is interested.
You wanted to be checked out medically, right?
That must be his parents. He kind of looks like him.
And I have a bracelet with your name on it. Brendan Banfield.
Yes.
Would you like me to call our chaplain? Would that be possible?
Yes, please.
It doesn't sound like you guys letting, the person struck him once, but no injuries that we need to do imaging or anything like that for.
Verify that his right leg's okay. He's been having some, said it's been feeling weird.
Okay. Since this morning or before?
No, since this morning. I think I'm just.
Would you be able to sit down for just a second? I'm just going to check your vital signs and make sure everything's
Can I have a
okay.
tissue?
Yeah. Would you like me to get you scrubs to change into?
Yes.
Hey there. You got it. Okay. So I'm just you're gonna feel a squeeze on your left arm. I'm just getting your blood pressure real quick, okay? I'm gonna check your oxygen level over here. So what's been going on with your right leg since this happened? You feel like it's hard?
It's like I'm having spasms right here.
I see. Okay. And where did the person hit you?
I only remember my arm.
Okay. Okay. Once you change into the scrubs, I'll just look you over there. But I see that you're walking and bearing weight. If anything, it's a bruise, or like he said, you have a muscle spasm because of the stress. I'm gonna hurry your fingers. Try and get a hold of it. I'm gonna let you get changed and get settled, all right?
You want to get them? You can get them right.
It's that ambulance? Yeah. Okay, you already switched out the linen and stuff on the cot, is that okay? Or?
I guess so. Okay.
How much do you weigh on here? Are you having any pain or hurting?
You're good.
So, Officer, is that Officer Balmer that was with you?
Yes, sir.
Okay.
Your daughter and a pair have been taken to headquarters, so they're both accounted for. They're okay, so. Yep.
I'm gonna have to step out. I have to go get bags, phone, and all that.
It's all right there.
When he changes.
Yep.
So I'm gonna see if I have any paper bags.
All right.
Can I call my mom?
At this point, we can't let you do that, because we still have to investigate exactly what happened. Once the detective shows up and kind of talks to you, that's when we can let things, they'll kind of explain a little bit more in depth. We're not gonna ask you any questions about what happened, but what we do have to do is, take photos of you, in the clothes that you have on, so before you change in the hospital gown, and evidence, so, we're gonna do it, and there's no easy way to do it, but kind of the easiest way possible, so, I'm just gonna have to go get my county phone so we can get everything documented, and then basically it should be sending the detective out to kind of come and ask you what exactly happened, because we're not gonna have you go over it numerous times and then let them do it all, okay? I understand. Okay. I'm gonna go see if I can find some.
I know. I got you.
My wife's parents are on their way to my house some point today.
Like Officer Balmer told you, man, as soon as we're able to, we'll let you make phone calls.
Yeah, I don't know what time they're coming.
Okay.
I know they are coming, but I don't know what time.
Okay. I understand.
Hi, sir. Hi. Fucking scrubs. Ready to change it.
You said someone needs to take pictures?
Yes, sir.
Before they change?
Correct.
Okay.
He's out, gonna go grab his county phone. Mine's all back in my cruiser.
I figured. I didn't know if you guys need a brown bag.
I think he's getting one, but if you have one, that would be awesome. Just bear with us for just a second.
Just blowing my nose.
Yes, sir. No, I understand. Balmer, the TR staff has brown bags if you can't find one.
just have them get a couple because we have to individually bag it.
Direct.
Is Valerie at least with Juliana?
I believe so, yes, sir. I don't see why they would have them separated at this time. Hey, boss. Can you see if they can bring me a couple brown bags, the paper bags?
Okay.
Thank you. Thank you.
I'm Zach. Do you want copy receipt?
I'll have some water.
I'm gonna see if Cranston's gonna be coming this way soon, so we don't do it on the phone, but if not, text on caption is gonna be the way to go.
Appreciate it, bro.
Good evening.
Gotcha.
Yeah, cool.
I gotcha.
See what happens. So we have Cranston detectives coming out, and they'll be the ones to take all the photos and all that instead of us doing it on phones. So that way, they're on the way now, so they should be here in the next couple minutes.
I understand.
Okay. Do you need like a bottle of water or something?
I think someone is getting
Yeah,
it.
I think I'm just grabbing it for him. You have any other questions for us I might be able to answer right now, man?
Do we know who the person is?
I don't think he's been identified yet.
I can honestly say that we would not know that information. And at this point, even if we did, we probably couldn't get that information to you.
That's fine.
That'd be the detectives that would let you know that.
Start with another unit. This is going to be an EVP call.
Yeah.
10-4, 331 Bravo. Can you start?
My name is Betty.
Okay.
I'm a patient advocate, also chaplain, guest services. Yeah, is there anything I can do for you right now?
Can we say a prayer for her?
I'm sorry.
Can we say a prayer for my wife?
Say a prayer for your wife. Absolutely. And what is it?
Christine.
Christine?
Yes.
No, we have Cranston detectives who take photos and well, they'll be here in a few minutes.
She's got some.
Thank you.
Do you have a specific faith community?
This Episcopal.
Gracious and loving God, come before you today in great distress. And Lord, we ask that you be with Christine and with her husband here. We ask that you surround her with your love, that she might feel that and know that you are with her. Lord, we ask that you heal as only you can. We don't always understand your healing ways, but just ask that you be with her. And be with her husband now in such distress. Watch over him. Surround him with your love. And let him feel the warmth of that love. To carry him through not only today, but days and weeks to come. Lord, for a family of friends who can support him this time, please let them open their hearts and arms and provide that loving support that is so much needed. And this we ask in your name. Amen. We say the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread. Forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, forever and ever. Amen. I give you my card. And I'm here all day. And I'll be glad to come down whenever you need me. And just ask me. Do you have no tissues?
There should be a few boxes of them around here for him now.
I'll be glad to come down anytime. You have a lot to process. Need some time alone, but you want to see. Will you call me? As I say, I'm here all day.
Thank you, Matt.
Mr. Banfield?
Yes.
My name is Mike Canganiel. I'm one of the detectives. My colleague, Detective Bryant back there. And Detective Hansel. I'm so sorry to meet you under these circumstances.
And sir, is that the entirety of your body-worn camera from that day?
Yes, sir.
Okay, and so did you manually shut it off when the detectives came in?
Correct.
Okay, and then uploaded it into the system?
Yes, sir.
Okay, thank you. I don't have any further questions.
Any cross-examination?
Good morning, how are you?
Good morning, ma'am.
Just a couple of questions. Initially, when we started this video, we started with the portion that the Commonwealth had previously played for you, where you entered the scene. Counsel asked you about your duties, and you responded that you were, at that point in time, working on trying to get a chest seal on Mr. Ryan. Is that correct?
We were trying to locate a chest seal for the female at the scene.
Okay. Were you the first officer to approach Joseph Ryan?
That day, I believe so, ma'am.
Okay. And Did you place a chest seal on Joseph Ryan?
Eventually, yes, ma'am.
Okay. You didn't observe any blood coming from Joseph Ryan's chest wound, did you?
None until after I did CPR.
And his hands were folded over that wound, is that correct?
They were across his chest.
All right, when you made it to the hospital with Mr. Banfield, he was not treated for any injuries to his leg, was he?
No, ma'am.
Or any other part of his body?
No, ma'am.
Okay, thank you. No other questions.
Any redirect? All right, is he still subject to recall, or is he done? Is he subject to recall, or?
No, ma'am, thank you.
All right, you're free to go. Thank you.
Thank you, ma'am.
All right, ladies and gentlemen, we'll go ahead and take our 15-minute recess. Just again, do not discuss the case and do not do any outside research, okay? Thank you.
We get to time travel. But yeah, this makes sense why the defense knew it's going to take all day for 3 witnesses.
All right, so we'll come back at 11:55 then. Is that fine? 11:55, thank you.
All right.
All right, so there we are. We are caught up. So, I mean, it was the chat that noticed. So the doctor is the one that says, wash your hands. And also very bluntly said, your wife is dead. You know, a lot of that was drive time. A lot of crying. The poll we did in the chat, is Brendan legitimately crying? We had 3 choices. Yes, in court and the hospital has 44%. Only at the hospital has 21%. And then no, not in either context is 34% with 90 votes. So pretty split. You know, I think when we were watching, myself personally, the first day when we saw like the tissue, I was like, come on, is he trying to make it apparent to the jury who seems to be sitting on the other side of the courtroom? Is he like doing this thing with the tissue to make it visible to the jury that he's upset by this? I think it was a 911 call that he was doing that. We were hearing the 911 call. But I do think, without a doubt, he was legitimately crying. Now, maybe he was crying just because he killed somebody and didn't realize how traumatic that thing could be. Or he's crying because his wife is dead. Could be a lot of things. I don't really think there was much for the state to cross on. But I think it's kind of, I don't know. I think it's a little bit pointless for them to focus on how he didn't have anything wrong with his legs. I mean, people faint when they're upset. It's not weird to me to think that somebody that's freaking out about something, whether they're freaking out because I'm going to get caught for murdering somebody, or I'm freaking out because somebody just barged into my house and killed my wife. I can imagine someone being shaky, especially if they just made you sit in a tub. You know, I'm 5'9". If I were to go sit in a tub, I'd have to have my knees bent. Like, it wouldn't be the most crowded scenario, but it wouldn't exactly be comfortable. And then you've got to stand up. So, I don't know. I think that's a bit nitpicky from the state. They're trying to point out, like, oh, he was faking it. I don't know. I think them trying to say that he was faking the thing with the leg is exactly why they didn't want to play the full part of this body cam where he's washing his hands at the hospital. Because hearing all that crying for so long would go against the idea that he had a calm, collected demeanor, and he planned this all out, and he has no viable defense, he has no remorse. So I think considering the cross-examination questions in conjunction with the state's decision to talk about the washing of the hands, but not just play the part with the washing of the hands, kind of tells a bigger story about the prosecution. That's my take on it. That's my read on it. So, yeah. Or stress after unaliving an intruder. I mean, yeah. So, and what else did we have? I mean, this was the same officer we had on day 1. He's not subject to recall anymore. But there were several other witnesses that were subject to recall. So I'm curious if we're going to get other familiar faces today. And it seems like we're starting with, like, I think the defense was wise, quite frankly, to put something on that calls the state's bluff as far as their willingness to present a complete case, but also showing something that could humanize their client. So if Brendan doesn't end up taking the stand, well, we've gotten to hear a little bit more from him besides, I'm an officer, I shot him, which is kind of what we heard, and go downstairs to open the door, which is really all we got to hear of him in the 911 call audio, where he just appears from the background all of a sudden. So I think it was a very good move on the defense's part to play something that could humanize their client, especially if he doesn't plan to take the stand. Other than that, you guys know I still want my digital forensics. Somehow, some way, somebody's got to get up here and tell us. And I think it's going to be Detective Miller, because he's the one that made the conclusion in October of 2023 that Christine never lost control of her devices. So maybe that's who we've got next.
Just before the jury comes back, I just had a question I had Shannon. On that video 82, it starts, there doesn't seem to be anything that needs to be under seal, because it starts
after
with him facing the bathroom and they walk out. If you want to review it.
I don't believe anything would need to be under seal.
I mean, we can review the very beginning, but you're just going to have just that
Yes.
exhibit for
Yeah,
81.
We're going to make sure that it's
Just
where we started.
Where you started.
I think that's fine.
Okay, all right, so we won't have that under seal, okay?
I agree,
We can just
Great
confirm
Granny.
when we get it, yes. All right, perfect. All right, are we ready for the jury then?
Yes, sir.
Okay.
Because in my world, it could be possible that Brendan and Juliana are both innocent, and Juliana made the decision under the pressure of the state and being incarcerated. Let me get out of here. I can't do this anymore. The notes that we were reading from 2023 already suggested possible suicidal thoughts. So is it that far-fetched to imagine that somebody innocent might do something to get out of a situation where they might be considering taking their own life? And not for nothing, but it explained why she might not have such, she didn't really have much emotional affect on the stand as far as, Christine, someone that you knew and spent a lot of time with, is no longer alive and something crazy happened to her. It wasn't just like she passed away. She was brutally murdered.
All right, your next witness?
Your Honor, Officer Balmer.
Officer Balmer?
Yes.
Okay.
All right, I don't think we had Balmer on the stand, but we heard mentions that he was first on the scene. Right, I don't think we had Balmer. Let's see if we recognize his face.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
I can't get over the state should have called a digital forensics person. They just should have.
Good morning, Officer Balmer.
Good morning.
I think he's new.
I'm going to play a clip for you, and I want you to identify it first, all right, before we play the whole thing, all right?
Yes, sir.
We can't see anything on the screen.
This is not showing. I think we may have solved it.
Yes, you have.
Looking at that picture before you, sir, can you identify this video?
Yes, that's my body cam video.
Okay, and this is from February 24th?
Correct, 2023.
From time to time, I'll stop and ask questions, but otherwise, I'm just going to have you watch, not the entire one. Yours goes almost an hour like the previous officer, correct?
I believe so.
Okay, we're going to be quite a bit shorter.
Do you want to mark it as?
Mark it as Defense Exhibit 83.
Okay. And is you asking to admit it into evidence?
Yes, we are, Your Honor.
All right, any objection?
Judge, I don't believe so. It would indicate if he's going to jump around, I'm not entirely sure.
But do you object to the admissibility of? Yeah. Okay, so that can be an evidence. Is it?
Yes.
I don't know what it is, so does it need to be under seal?
Yes, it does.
Okay, so video body cam under seal in evidence 83. Okay.
Shot someone. There's a 34-year-old female that got stabbed by someone, and then he shot him. He doesn't know the person that he shot, but he's on the ground. 50 Bravo is the ground. You know.
Oh, no.
Why does it sound like someone saying? It sounded like someone was singing along with the siren.
Zach, come on, kid. Right, there we go.
Go ahead.
Can we figure out if they're inside or outside or where they actually are?
10-4.
Officer Balmer, that's the radio traffic relating to this incident that you're responding to?
Yes.
And you're gathering information as you hear that radio traffic?
Yes.
Okay, thank you.
Got it on the shoulder, boys. God, you people. There we go. Come on, figure it out.
Bravo, the patient is unconscious. Apparently she was stabbed in the neck. She's upstairs in the bedroom.
Sorry.
And the subject that was shot is in the bedroom downstairs.
Where's the shooter?
Let me ask.
Be clear for Fairfax 1 star.
10-4.
Oh, I forgot we can't speed it up because we're caught up.
52 Bravo.
50 Bravo.
Whatever units have shield, make sure they not put a radio so we know who he has.
Tank, we don't have time for a
Units with a
shield.
shield advised.
5 Bravo.
Alright, so they don't have time for the shield. So because it's a shooter situation, they're saying we don't have time to go get shield equipment.
5 Bravo. Ensure the caller put the firearm down and ensure the response is on page.
Okay.
10-4.
Guys, you gotta go a little bit faster, huh?
So apparently the caller doesn't know the subject. Then the caller's trying to help the female with the...
Now, at this point, is what you're hearing on the radio the only thing that you know about this?
Correct.
Okay, so there was nothing prior to you starting up your car and going?
So typically what happens is when we get sent a dispatch, it does come to our computer. However, when scenes like this happen, we try to get them as quickly as possible, so most of that information comes over the radio, yes.
Okay, thank you.
You guys gotta drive a lot faster and better.
On 5 Bravo, Fairfax down is due to the wind.
What wind?
What wind?
Damn it, Zach. Go, Zach.
And just so we're clear, the body camera begins on what prompt?
So it can be activated one of a few ways. In this situation, it activates when the emergency equipment goes on, or you can activate it by pushing it twice.
Okay. And in this still, you're at the residence?
I'm just arriving, yes.
Okay, thank you.
Yeah, you got one? Where's the shooter? Huh?
Shooter's helping the woman right now from a radio. He doesn't know the man that he shot.
Which house?
1330.
Not 52 Bravo, there's 4 of us at the door.
10-4.
Yep. Well, I got voices inside. Let's do something quick. Stack up on me, I guess.
That's Juliana.
County police, call out. Where's the...
So if you guys remember this part right here where we hear Juliana's voice, remember at the end of the 911 call, she's like told to go downstairs and make sure they can go in through the door. So that's what we're hearing right there.
County police, call out. Where's the gun at?
It's probably like 808.
He's up here. He's an officer too. So he just didn't know this is going on.
Anybody else downstairs?
No.
Where's the
My
shot?
his daughter is downstairs. He's just
Who else? Just us?
Yeah, she's just sorting out his daughter.
Guns on the bed. Guns on the bed.
9-1 Bravo, they're saying one of the patients is outside now.
Sir, is that the first time you've encountered my client, Mr. Banfield?
Yes,
And he was tending to his wife at that point?
it appears so, yes.
It appears so.
Somebody's outside. All right. Watch out. We got him. Catch up. Jesus. Dude, give me a,
What can I do to help?
chest seal. Give me a chest seal. Yep.
Bring it up. Anything I can do to help?
What else was she stabbed? Is there any other stab wounds? Tank, come
She got
here.
something on her hand. It looks
Take.
like she got something. There. You do it there. Just stand right here. Yeah.
She got multiple stab wounds to the neck. Okay. Secure those guns.
Ma'am, I need you outside now.
She's breathing.
What do you need?
Get medics in here now.
Seems full.
And sir, when you said that, you were talking about Christine Banfield's breathing, correct?
Correct.
Who shot?
9-1 Bravo.
You shot? Okay.
He grabbed my arm.
Who did?
He grabbed my arm when I started applying.
Okay. Someone get with him. I don't know what he shot at.
Who's that chest wound seal?
I need it from this neck right now. She got stabbed by him, so someone watch him. Guys, chest seal, now.
We're looking for, buddy. We're looking for it. He called out.
Up this way.
Upstairs. I need chest seal on her and how's everything right now?
Just stay right there. Shoot her. There's another one behind me. You can open this up for Balmer.
Yeah, I can't do anything with this right now.
Go.
Can't do anything with this right now.
What do you mean?
Someone check my pulse for the guy behind me.
Yeah.
She's breathing, so.
We got one guy up here, gunshot wound, one female, multiple stab wounds.
Can someone do this for me? I got one hand kind of tied up here. Up this way.
He's still in the tub. He's in the tub.
He's in the bathroom, up here.
Where do you have chest seal?
On her neck. Multiple stab wounds on her neck. You ready? As soon as I let go. Come here, ready? 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 We missed one. Chest seal.
Get another one.
Give us one hand.
There's another half.
Ready?
Go for it. Yep. Hold the door. Don't work on her, okay? Jesus Christ. Just fucking hold pressure. Just sit in the tub. Just sit in the tub.
You need another chest seal?
Yeah, whatever you have. Just whatever you got. Hey, get another ALT, get more blowout kits.
Is it already accounted for? Is everybody okay?
Is there anything else that we know of other than this?
This one and the guy behind me.
On this female.
I don't know. I do not know.
No,
She might have defensive wounds to the hand, but.
Everybody's accounted for? No need for K9 or helo at this point? K9 10.
Yeah, that's right. Thank you.
Securing firearm. Just leave it. Where it is.
Tank.
Yep.
Since we got this kind of wait for the medics, can you talk with him? Shoot him.
Stand by 1 second.
Medics expedited.
Do we have a pulse on anybody?
I could feel him breathing.
Hey, do you have a pulse on him?
No.
No pulse?
CPR,
Okay.
CPR on, go ahead.
Multiple stab
Do
wounds.
CPR on him.
Yeah, if you don't have anything, start going. Start doing it.
Alright, who's the most violent, you guys know?
This one, she has a pulse.
Alright,
Multiple stab wounds to the neck.
thanks. To the right, we have a pulse, multiple stabbings. To the left, you do CPR with a gunshot wound.
I felt the pulse when I was holding the neck.
Alright, we have multiple chest seals on the neck. We don't know if we have right here.
We don't know any
Multiple
other.
stab wound to the neck.
To the neck?
Chest seals.
Yes.
Don't know if we actually have it.
Don't know if it's one on the other side. We don't know.
Okay, she's still breathing. We can feel blood moving. We can see her. We can see her cheek.
You can stop doing CPR on him.
You guys good?
Yeah, we're gonna get her.
Okay. Get down. New wrist.
Yeah, this.
She's breathing over here.
She's breathing. That's why we're moving her.
Grab
him. Take him downstairs.
I can't feel a pulse.
You can't feel
Oh my God.
It's hard to feel.
Are you hurt? Stand by.
Sir, did you have anything to do with moving any of the firearms?
I did not.
Did you see who did?
I do not recall who did.
Okay.
Sorry. No, there's no pulse wound, too.
Nothing?
There's nothing.
What do we need? I think that guy's gonna be definitely DOA. I mean, we can.
So
I think that might be obvious over there. Just no place over here.
Oh.
What do you want to do? Do you want to grab that and go?
We're done. No, this is.
Don't know who this is.
She's done.
All right, that's fine. You want to get a rhythm on that?
Yeah. I got the monitor. It's right there behind you.
You have it? Okay.
So where's?
This is not Balmer's.
Nope. There was two on the bed when I came in.
Okay, this one's got blood on it. Yeah. So stay with him. He might, I'm not sure.
He doesn't know.
Yeah. I'm gonna wait till they're done.
Yeah. You don't know that guy at all? No, no. Yeah. I'm trying to figure out, where's the gun currently?
There's two on the bed.
Firearms right here. Leave them right where they are, if that's where we found them.
We moved them away.
All right, that's fine.
They were on the bedroom here though.
Where do you want
We have a knife right here.
You guys are good right there. Hey Sarge, what's up? Do you want us to escort him outside?
Yeah, right now they're working, so we're gonna be.
So,
I'm not sure. We're not working. Well, we'll get him out. Fuck, she's in PEA.
So once they, all right.
we're going to work for him.
Just move her and go?
Yeah, let's just move her.
All right.
Get you downstairs. Hey, very close to him, escort him down.
Yeah.
Is there kids down there? The kids are out of the way. Go try outside.
Sir, you accompanied Officer Beckner to the ambulance and all those sorts of things?
So when I In that situation, I believe what you're trying to ask is, was I in the ambulance with him? Can you clarify?
Well, so at some point, and we just watched Officer Beckner's video. I just want to make sure you went out of the house at the same time he did. Is that correct?
That is not correct, no.
Okay. Did there come up a time where you met up with him at the ambulance?
Yes.
Okay. And then your body-worn camera was essentially the same after that?
Yes.
In terms of the hospital and all those sorts of things? Okay. Your Honor, that's the 12-minute, 36 seconds. That's defense exhibit number 83.
Okay, so you'll
And
crop it for me to 1236?
Yes.
Okay, to 1236. All right, thank you. It's in evidence up to 1236 then.
I don't have any further questions for the
All
officer.
right, cross-examination.
Good morning, officer.
Good morning.
Afternoon, I apologize. When you entered the room, Mr. Banfield was on his knees next to Christine Banfield, is that correct?
Yes.
Okay. But Mr. Banfield wasn't using that blue towel we see to staunch the bleeding from her neck, is that correct?
Objection to leading, Judge.
It's
It's
cross-examination.
cross-examination.
I do not believe he was, no.
Okay, and he wasn't using the nearby blankets, correct?
Correct.
Okay, and he wasn't using the sheet?
Correct.
Okay, thank you. Nothing further.
All right, redirect.
No, here.
Okay, is this witness subject to recall?
No.
Is he subject? Okay, you're free to go. Thank you,
Thank you,
officer.
ma'am.
All right, your next witness?
Your Honor, I have a video that Ms. Sands and I have talked about that Judge, I think the witness that we need for this video is not here right now,
Okay.
so we'll just
Next-
move on.
Next witness?
My next witness is LeAnne Singley.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
Bear with me, Ms. Singley.
Yes.
Ma'am, can you please state your name, spelling your name for the court reporter?
Thank you.
Sure. My name is LeAnne Singley. First name is Lee, capital ANN. Last name Singley, SINGLEY.
And what is your particular professional discipline?
I'm a forensic scientist.
Okay, and what areas of forensic science do you specialize in?
So currently I work mostly in bloodstain pattern analysis.
Oh,
Okay. And can you tell the ladies and gentlemen of the jury about your background and your training in bloodstain pattern analysis?
Sure. I guess I'll start with my educational background. I have a bachelor's degree in biology and a minor in chemistry from the University of Pittsburgh. I also received a master's degree with a concentration in forensic science from the University of Florida. In 1987, I was hired as a forensic scientist in the Pennsylvania State Police Crime Laboratory. So I'm just entering now my 39th year in forensics. I spent about 17 years at the State Police Crime Lab and received some training regarding various areas of forensics, but in specific to bloodstain pattern analysis, I started my education in that in 1993. Afterwards, I've had basic and advanced training. I've had training in the math and physics of bloodstain pattern analysis, fluid dynamics of bloodstain pattern analysis, the interaction of blood on fabrics, so a fabrics training class, and other conferences and training opportunities that I've had throughout the years.
Now, ma'am, do you hold any titles on boards or anything like that relating to your professional associations?
So I'm a member, currently a member of the Organization of Scientific Area Committees, which is a federally convened committee that is assisting the bloodstain pattern community in setting down guidelines and standards of how the discipline should be performed. I've been part of that group for a number of years. Prior to that, there was a similar group that was convened federally called the Scientific Working Group on Bloodstain Pattern Analysis. That began in 2002, and I was a member from the inception of that committee up until that committee was replaced through the Organization of Scientific Area Committees, otherwise called the OSAC.
And groups like the OSAC and the previous organization, what's the intent of those?
So as I stated, the intent is to bring together subject matter experts to help to develop guidance documents, standard documents on how the discipline should be performed, or the training requirements that are necessary, other features of it. And it's not the only forensic discipline that does this. DNA does this, fingerprints, documents examination, they all have committees that are addressing those issues.
And is this all designed to have uniformity in terms of how it's being practiced?
I'm sorry, can you repeat that?
Are what you just described, is that designed to have uniformity of how bloodstain?
Yes. I mean, the idea is that we would like all areas, all agencies or entities that perform this discipline to have a framework to which everybody will perform it the same way, or at least similarly, have the same standards that they would use to do what they do. Initially, Swigstain had a large international involvement, so it wasn't just the United States that was offering information into into this committee and into these documents. There was a large international component as well.
Okay, and Swigstain, the company that was the predecessor to OSAC, that stands for Scientific Work Group, Stains.
Yeah, so it's Scientific Working Group it was on bloodstain pattern analysis, but they shortened it to Swigstain.
Okay, and did you have any role in running that organization?
Well, as I mentioned, I was a member from its inception. In 2002, I served as the Quality Assurance Committee Chair for a number of years within that group.
And ma'am, have you ever been qualified as an expert to testify in court regarding bloodstain pattern analysis?
I have.
How many times?
So specifically to bloodstain pattern analysis, I'm not sure. I've testified over 90 occasions on various areas of forensics. Greater than 10 of those are bloodstain pattern, maybe more.
And have you ever been qualified in Commonwealth of Virginia?
I have not.
Okay, have you ever done work within the Commonwealth of Virginia with police organizations?
Yes, I've conducted training for the Virginia State Police on a number of occasions in bloodstain pattern analysis.
Okay. Your Honor, I'd move Ms. Singley in as an expert in bloodstain pattern analysis.
Any objection?
No objection.
All right, so moved.
Ms. Singley, you had an opportunity to see Ms. Groff's presentation yesterday, correct?
Yes, sir.
And you actually know her, correct?
I do.
Through your various affiliations?
Yes, sir.
And were you able to, in arriving at, well, let me show you a few things and see where we go from there. Your Honor, can we show that to the witness?
Yeah, it is shown to the witness.
Okay.
If you can make it a little bigger, it might help her.
Yeah. Not that.
If you double click on the file name right there, you have No, you're having the same problem.
Judge, this is the court's PowerPoint that's coming up. I don't know.
The court's PowerPoint? Meaning like their like Microsoft Word suite product license or what? If you can't beat them, join them.
Well, ma'am, did you have an occasion to review items in this case?
I did.
And if items of evidence relating to this case?
Yeah, so I received photographs, so I didn't actually have the physical evidence, but I did review photographs and videos and things of that nature that would expose me to what was evidence, turned out to be evidence in this case.
Okay.
Ask about the shadows.
Your Honor, I think I'm going to have to switch the computer just because of that PowerPoint thing that pops up. Can I have a 5-minute recess?
No.
Oh, Penny. And the chat goes wild. Yep, she said no. I mean, they could do lunch.
Ma'am, are you able to see a picture on your screen?
I can.
Did you have an opportunity to review this item as part of the evidence that you reviewed?
I'm sorry. Judge, have we identified the photograph?
No, I think it's defense 80, at least that's what it was marked yesterday.
83, I believe, Judge, is that?
80.
80? Okay.
Yes.
Ma'am, I'm going to have you look at what has been marked as Defense Exhibit 80. Have you seen that?
I've seen photographs of this item before, yes.
Okay, and what is it that you notice when you look at this item right here?
It's a knife. It looks like to be stainless steel, like a chef's style knife, and there appears to be transfer bloodstains or some irregular shaped bloodstains along the knife and the blade.
Now, in talking about bloodstains, is there a uniform terminology, or were there attempts to have uniform terminology as to what bloodstains are and varying other descriptive terms?
You mean the actual terms we use when we're writing reports? Yes, the organization that I mentioned to you earlier has set down standard terminology that we would use in the course of writing reports or training, or even just discussing bloodstain pattern analysis. And so that has been published.
And or is that how you find, do you find that the terminology is uniform amongst bloodstain pattern analysis?
I mean, the goal, that is the goal, that it would cause uniformity, and it has definitely helped since that terminology has been utilized or has been written and published. To say that everyone is using it correctly or abiding by that terminology, I can't say that for sure, but
Take a
I
dig at
can
Iris.
definitely say that.
Take a dig at Iris.
The ends have sort of, the end result has been what we had hoped it would be, and that is to cause the uniformity of that terminology across the discipline.
Now, did you have an occasion to also analyze or look at other aspects of evidence, like the forensic science reports and things like that?
Yes, when I do a bloodstain pattern analysis, the The discipline itself is the study of the size, the shape, the distribution, location, appearance of bloodstains. But in the course of the bloodstain pattern analysis, we also have to include or consider what we call task relevant information. So information that is relevant to the bloodstain pattern analysis, not necessarily extraneous information, but those things would be like the autopsy report or medical reports if the individual wasn't deceased, or the DNA reports or other forensic laboratory reports that will help to actually include or exclude classifications and ultimate interpretations at the end.
Now, ma'am, if you look at the picture, there's a specific circle relating to an area of that knife that you've just identified.
Just for the record, you had marked that as 80A yesterday.
80,
the one with the circle.
80A, yes, thank you.
That's what you
identified as Defense Exhibit 80A. Do you see that?
I do.
And do you recall,
Iris?
do you recall any analysis that you reviewed relating to that particular area of this knife?
Yeah, this is the area of the knife that is at the base of the blade where the handle meets up, and it is one of the areas that was sampled for DNA analysis.
Okay, and did you observe any findings relating to that?
Yes, this area of the knife had DNA. The DNA of Christine Banfield and Joseph Ryan could not be eliminated from that sample.
She's using...
And were there any others?
Out the gate, she's using the proper terminology to describe this DNA analysis, which Iris did not.
That were excluded from that sample?
I believe Brendan Banfield and Juliana were eliminated.
Okay. And is that what you're referring to? The next page?
Yes, sir.
Okay, and that's...
Your Honor, I would object. This is not...
Well, I mean, he hasn't entered anything into evidence yet, but...
Understood.
And I don't know what this would be marked as. Okay.
ADB?
You already have.
Or 80...
you have ADB, ADC, ADD, 82, 83.
I'll go 80E.
80E. All right, he hasn't entered into evidence yet. He's just showing the witness.
And what do you see this is, ma'am?
It's the results of the bloodstain, the DNA report that addressed this area of the knife.
Okay, and that's a report that you reviewed in your analysis?
I did.
And this is a portion to highlight that particular statement?
Yes.
Okay. And ma'am, is this also from the report?
Are you going to mark this something?
80F? Did you have a chance to review that?
Yes.
Okay, and is this also a report that you reviewed, a portion of it?
Yes.
Okay, and what does that tell you?
Again, it's indicating that Christine Banfield...
Your Honor, I would object to the witness reading from a report that has not been admitted into evidence and is not the complete
report. Okay, I'll sustain that objection.
That's fine, Judge. And ma'am, did you have occasion to review the Office of the Medical Examiner's report relating to Joe Ryan?
I did.
Okay. And what, if anything, did you observe in your analysis relating to the pictures from the Office of the Medical Examiner?
Well, I looked at the photographs of Joe Ryan at the autopsy examination, and in part of that, I was able to review the injuries that he sustained.
Okay. Now, the topic of self-wounding came up with Ms. Graff yesterday. Is self-wounding something that is often found in knife injuries?
Your Honor, objection is to leading.
Well, I'll sustain as leading if you want to rephrase.
Okay. What, if anything...
What, if anything?
Do you find as an expert in knife-related wounds?
So in knife-related activities, investigations that involve sharp instruments, so knifings, things like of those nature, we often see the assailant, it's not uncommon for the assailant to self-wound. during those. In fact, when I'm training individuals, it's one of the things I train law enforcement investigators to ensure that they look to areas of the crime scene that may be further away from the victim's bodies to find an isolated blood drop or things like that. So we know this to happen, and it can happen in various mechanisms during the activity that's going on in terms of the criminal investigation. But it's not an uncommon occurrence.
Okay, were you able to note where the injuries were in your examination for Joe Ryan?
It was on his left thumb, I believe.
Anything, did you observe anything else?
I think it was a puncture. It was listed as a puncture wound.
Okay. Now, is that the puncture wound that you're talking about?
I'm sorry, I can put it back on.
Sorry.
What, this?
This would be 80F.
It was 80B yesterday.
80B.
Okay.
So this photo here that you have now.
This is 80B.
The wound was listed as a central cut puncture of the palmar aspect of the left thumb, and that is what's being depicted here.
Okay. And if ADF, Judge, would that be the next in line?
You have one marked ADC, which I had put down as finger of Joseph Ryan, and I'm not sure if that's the same picture that you used yesterday when you're showing the other expert.
I'm not certain either, Judge. What's the next one, ADD?
Well, we'll do ADC. I mean, we can make this ADC, that's
ADC,
fine. You haven't
yes.
entered it in evidence yet.
What's crazy is Judge Penny asked John Carroll at the beginning of today, like, do you want to deal with like the 80 A, B, C, D? He's like, no.
So, ADC.
And ma'am, is this a picture that you've observed in your analysis of the documentation relating to this case?
Yes, these are part of the autopsy photographs.
And is that the same injury that you've previously discussed and identified?
It's on the left. Yes, it's in the same location.
And what is that picture of, ma'am?
It's another photo of a different orientation of the thumb.
Okay, so the same injury?
What do you
It
want
appears to be, yes.
What we want to mark that as?
I wish we could see it, but remember yesterday we saw like
you have
a
an E,
little
and you have an F.
C-shaped kind of clotting on Joseph's hand, thumb. And also there was like a lack of blood between his fingers as if they were clenched.
The body, so let's just go through. What did you review, or did your review include body-worn camera?
It did.
Okay. Were you able to review body-worn camera to determine if there were any injuries to Brendan Banfield's hands?
Yes.
Okay. What, if anything, did you find?
Well, I reviewed the video, the body cam video that took him into the ambulance, and they specifically looked at his hands for injuries, and I guess it was an EMT, whoever was in the ambulance with him, it indicated there were no injuries.
Okay. Now, ma'am, if you could take a look at the screen. This is the full Office of the Chief Medical Examiner report. Have you had an opportunity to review that?
There's nothing on the screen. There's nothing on the screen.
Why didn't I put a Judge Penny emoji? Let me fix that.
Towards indulgence.
Better use the court's indulgence sparingly. He really does need a Kokomo. No. Hey, J Money. They could have just done lunch and then had this witness up. Because local time is 12:41. But, you know.
Court's indulgence still.
Mavhog says, I want to help him.
Is it?
Oh my God, they're
Is
laughing.
it showing up on your screen?
It was when he was there.
Yeah, I know. I think I'm touched the wrong one.
No. Oh yeah, I forgot. They wanted to call a different witness, but they weren't here yet. You're right, you're right. Dang, and he really tried to, he's like, I have another witness. Tried to keep it moving.
Okay. Ma'am, can you see, can you see the picture on the screen?
I can.
Okay. And you
Hallelujah.
recognize that?
This is the DNA report.
Okay. And I'm going to scroll down. Is this the area down here where the cursor is that you previously reviewed?
Yes.
Okay. And that informed your conclusions as to the blood stain near the handle and the handle juncture?
Yes.
And ma'am, can you see this on your screen?
I can.
Okay, and you've reviewed this. This is the report of June 9th, 2023 of the Office of the Chief Medical Examiner?
Yes.
And I'm just going to scroll down. Ma'am, looking at where the cursor is on the screen, is that what informed you as to the exhibit previously?
Yes, this is an area that describes additional injuries.
Okay. Now, did you have an opportunity to review a report from DLI, a private laboratory?
I did.
Okay, and in that report, can you tell the ladies and gentlemen of the jury, what was the sample that they were providing?
So in the DLI report, there was a sample that that was collected by them on the area of Joe Ryan's jeans. That was the waistband, I think interior and exterior waistband zipper, and I believe the button area. But the significance of their sampling was that in their report, they stated that the sample was taken avoiding staining, meaning that they were not trying to collect staining, they were trying to avoid stained areas of that part of the jeans.
Okay, and what?
This is a really important piece from yesterday that I felt like Iris got a bit contentious with. So Iris Dialygraph. And what they're saying now is they intentionally, because obviously if someone's blood is all over, you're going to have a mixture. Their DNA could contribute to the mixture from the swab if there's blood staining. But she's saying we intentionally tried to avoid where we saw the blood. That way we would have better confidence. Not, she wasn't the one that did the testing, but the individual that did the swabbing, they intentionally tried to avoid the stain so they could have greater confidence in the results without it just being explained by blood after the fact being spattered over. This is very good for the defense. This is very good for the defense.
What would you say
the state has
about
to rebut this?
Avoiding the staining and still having a laboratory analysis? What are they looking for?
Typically, they're looking for a DNA source that's not coming from staining. So touch DNA, or sometimes they'll do it just to determine who the wearer is of an item of clothing, or sometimes they'll do it just to see if somebody touched that area, that they're curious if they can find the DNA from that individual.
Okay, and do you recall the results of that report?
I believe the results of that area, that included DNA sources from Christine Banfield and Joseph Ryan, but Brendan and I believe Juliana were both eliminated.
Okay, so let me kind of shift gears here about bloodstain pattern analysis and what
big
you
for the
do
defense.
when you first start out doing it in a case.
You mean my general methodology of how I do an approach? So when I get a case now, and currently I get a case, I want to know as little information about the case as possible. So I try to limit whoever is requesting it from me to just the information that I need to know in terms of the bloodstain. So typically that might be like how many individuals were injured, or if there was more than one deceased, more than one bleeder, what their injuries might have been, things of that nature. And then I will get whatever materials are provided to me. I start looking through the photographs, determining what I can say or maybe not say about certain pattern types. We call that the characterization. We characterize them, as I mentioned, through the size, the shape, the distribution, location of the stains. We look to see how they might correlate with each other. And then we begin or attempt to list a classification or classify them in what might have caused them. So earlier I talked about those characteristics, and I think it's important to understand that bloodstain pattern analysis is answering a very different question than DNA analysis. DNA is answering the who, the BPA, the bloodstain pattern analysis attempts to answer the how. So how the bloodstains got to a location. So once I've done that initial preliminary classifications or some idea of what I believe this might be coming from, I'll then incorporate in things like the autopsy report, DNA analysis that will help us to refine that classification, maybe eliminate some things that I might have kept in the running in terms of a classification. Then at the end, we discuss what those classifications mean in terms of the DNA and what we might be able to interpret in terms of individual events or things that happened at a particular crime scene.
Now, can you see the picture that's on the screen there?
I can.
Okay. Your Honor, I would
while he struggle
identify that as
buses.
Defense Exhibit 84.
While he struggle buses with the next exhibit, so some context from the state's expert witness yesterday about this same DNA with the button. Like, we're shifting into a different topic here, but going back to the DNA profiles, the button on Joseph Ryan's jeans, the zipper. Yesterday, when they asked Iris Dallygraph, the state's witness, John Carroll says, well, my understanding, or they asked about, what did they find? And Iris said, my understanding is they found DNA profiles. And John says, did you read that report? That's the report that we just had LeAnne Singley talk about. She said, I think I did. Then John asked, the request for the analysis was not for bloodstains, but for contact or touch DNA. Is that right? And Iris answered, I don't recall specifically. Maybe we can rewatch that tidbit during lunch.
4?
I believe it's already the Commonwealth's Exhibit 173, is that correct?
So Judge, the original picture was admitted as Commonwealth's 173.
Okay.
His manipulation of the picture to show the cropping side by side with the original is not.
Okay, so,
specifically neither of those.
all right, so what number did you want to
I
make?
think 84 was the next one.
Yes, okay.
Ma'am, can you describe what you're seeing there on the screen?
Yes, this is the left forearm of Joseph Ryan, and bloodstains that were on that left forearm.
Okay. And did you create this side-by-side comparison?
I did.
And what was the intention of that? What were you trying to show?
Just it gives an overall of the arm. You kind of see it in that perspective, and then just I put a square around the area that I cropped so that you could kind of see it how it related to the arm in total.
Okay. Your Honor, can I move that in as Defense Exhibit 84 and publish it to the jury?
Any objection?
No objection.
All right, 84 in evidence.
Can you describe what you're looking at for the ladies and gentlemen of the jury and what it is that you do in analyzing something like this?
So first, let's start with what I do when I'm analyzing something like this. Again, I know I'm sounding repetitive, but I look at things like the size, the shape, the distribution, location, and certainly take into consideration the target surface. We know that that has a profound effect on what we see. So we have to think about that when we're looking at things like size and shape, because it can change depending on what the target surface is. This target surface was a bit unique in the sense that it was a forearm that had quite a bit of hair on it. So it provided a different surface than, say, a flat table or even carpet. It tended to have an influence on what we were seeing.
Now, what is it that you can say about this stain pattern?
So I just described what I saw here, which was a linear series, so a series of some irregularly shaped drops or stains that were located on this arm. I did not use the word drop. I used a series of irregularly shaped smaller stains, because if you look at it closely, the stains themselves are almost three-dimensional in shape, because they in areas were clinging to the hair on the arm. So it distorted what we can see in terms of its true shape and true, like even the size of it. It was, well, there's no measurement in here, so we really don't have a true size.
We didn't hear about hair yesterday and the impact.
In determining what exactly this stain is, you would want measurement?
Well,
you would check out what the surface is?
Yeah, I mean, we don't always have measurements. Sometimes they're not there, and we can use things in the area that can sort of inform what our size might be. But I don't have a true size. I did call them smaller because they appeared smaller compared to things around it in the area. But yeah, I mean, certainly the more information you have, the more data we can use to then make a classification.
Based on the information that you had relating to these stains, is it possible to make a classification?
I did not make a classification, and this target surface did not lend to classifying these stains to a specific mechanism.
Now, let's switch gears a little bit. In terms of how blood falls on things, can Can you opine as to what kind of pattern would be created if someone put blood onto a surface?
Put blood on how? How are you, I mean, touching a surface? If it
Holding blood and dropping it?
If an individual had, say, blood in their hands that had enough volume for it to release, like if it were to just drop to the ground, we would call that a splash pattern. So it would be a large volume of blood that is falling due to gravity. It's not, you'd have to be careful to not include their hands swinging, because if their hands swing in that process, now you have cast off, which is blood being released
Cast off.
from
There
an
you
object
go.
in motion. If it's just merely
This is so critical for the defense because the state wants the jury to hear and conclude that the only explanation for those droplets, these circles on Brennan Banfield's jean leg, is because it's cast off from when he's stabbing Christine Banfield in the neck. He's the one doing the stabbing, and that there's no other way that that could have been caused. And here we just had, I've talked about it, couldn't it flick? We've talked about it in the chat, but now we're having an expert say, well, here's this thing that you would expect would cause cast off. Very, very critical. I'm glad they called a separate expert, like a counter expert, and didn't just try to cross the state's expert on this.
Can you opine as to what kind of pattern would be created if someone put blood onto a surface?
put blood on how? How are you, I mean, touching a surface? If it
Holding blood and dropping it?
If an individual had, say, blood in their hands that had enough volume for it to release, like if it were to just drop to the ground, we would call that a splash pattern. So it would be a large volume of blood that is falling due to gravity. It's not, you'd have to be careful to not include their hands swinging, because if their hands swing in that process, now you have cast off, which is blood being released from an object in motion. If it's just merely falling onto the surface, then you would get a splash pattern. And that usually will then have sort of a apparent area of where the volume of the blood is. And then because that parent area was created with blood sort of collapsing into itself, it'll create satellite spatters around that area.
Okay, and
This is interesting.
have you?
I wish, like, I hope the state learns from this presentation and understands how critical the terminology is. So right out the gate, this defense attorney, John Carroll, was like, hey, do you guys try to use the same terminology? And I was hoping for a little quip there. The witness politely said, we try to aim, that's the goal, is using uniform language, right? There is a big difference if I say I was coughing versus I was hacking. Like, sure, they both might be a cough, but you would get a very different impression if I said someone was hacking. They were hacking a lung out versus just they coughed for a second. So words are important even if they seem similar. And yesterday I thought it was confusing to follow some of the descriptions of the witness, and the state didn't do a great job of laying out the concepts and making them concrete. And when there's a difference, even if it's a minor difference between two similar words, explain that to the jury and ground us in what exactly you're talking about. And now in a minute here, we've gotten the distinction between a splash pattern, which is falling due to gravity, versus cast off, which involves some sort of momentum from a movement from an object. So if you're swinging your arm and liquid flies off, that would be cast off. And right there, I understand the difference now.
Worked with those kinds of patterns?
Yes, I mean, I make up mock crime scenes for my training, so I've created them myself by doing that.
Now, is it plausible for someone to scoop up blood and carry it to a deposit somewhere?
I'm sorry.
Objection leading.
All right, I'll sustain as to leading.
What, if anything, Well, first of all, let's just talk about how would one scoop blood?
I don't know how you would do that.
Okay.
You mean scoop it up from something like, I mean, it's a fluid. I think it'd be difficult. It's not like you can, like you have a dustpan that you could, you know what I mean? When I think of scooping in that nature, I just think in terms of if I had spilled something on my floor in the kitchen, I wouldn't be able to pick it up with my hands, if that's what you're asking me.
Okay. If does the surface that the blood is on, does that, I mean, you're saying you don't know how it can be scooped, but does the surface matter?
Yes, I mean, yeah, I mean, if you have the blood on something that's porous and absorbent, then there would be less blood that you'd be able to even scoop, if you will. If you know what I mean, there would be less blood. You wouldn't be able to access it because it would be soaking in to an absorbent surface.
Okay. Have you ever experienced in blood stain pattern analysis someone scooping blood and pouring it in another place?
No.
What would be the difficulties of that if that were to have happened?
Well, I think getting it into your hands to begin with would be a challenge, and then transferring it.
Your Honor, I would object at this time. Calls for speculation. She's just testified that she's not had any experience with any scooping of blood, so I'm not.
Speculation?
I think her expertise in blood spatter analysis
I think common
gives her an
sense.
opportunity to opine as to how it could be done if it was.
I'd say
I'll
common
sustain
sense.
that, for that question, I'll sustain the objection if you want to rephrase.
Based on your experience.
Blood as a fluid.
The reason this is important, guys, is because John is countering the idea that they tried to ladle blood and throw it on Joseph and or Christine to make it look like they had killed each other, had been fighting with each other.
Is it possible to pick it up?
It's supposed to sound ridiculous.
Pick it up on, yeah, I mean, I think I think the difficulty here is, of course, you can touch blood and it picks up onto your fingers, right? Like if you, as a transfer stain. I think the fact that it's a fluid, the challenge is that if you're trying to collect and keep it in the confines of your hand, the first part is getting it into your hands, and the second part is not having it seep back through your fingers, out of your hands. Does that make sense? So the only thing I can use to describe it is when I'm making a mock crime scene, sometimes we'll put blood in our hands and make an impact pattern from it. And just putting small amounts in the hand, it's difficult to contain it in the hand, even in doing that, right? So that's about the closest I can get to having an experience of what it's like to actually, and that's when we pour it into our hand from, a
This
cup.
is gold.
This sounds a little.
Do you guys see why this is gold? She's basically saying even when we intentionally and calmly try to stage a scene in a controlled environment, we cannot just scoop up this liquid and throw it all willy-nilly. And this is the witness carrying this. This really isn't the attorney carrying this. This is the expert witness carrying this. But this is critical because the idea that you can just scoop up blood that's been laying, it's either on a carpet or on someone's clothing, or maybe on the edge of the bed sheet. How would you be able to pull and gather this liquid from these fabrics to be able to splatter it around? And that's the state's theory. The ridiculousness that we're listening to, what are they talking about scooping this up? It's the state's theory. So
We do this because we use real blood when we do
the red
training.
cups.
So I know what it's like to have blood in the hand and trying to work with it in that way.
Oh, that's
it's a
interesting.
challenge.
Okay. And what, so just to follow through with your example, what is it that you're trying to show when you would do these trainings?
So all I'm doing is, or me or my co-trainer will put in there, because we're going to ultimately smack it to create an impact pattern. And by putting it in your hand, you're able to place your hand in a mock crime scene to kind of mimic where somebody might have been beaten or something like that. So we're using it as a training tool for that purpose. It was just an example of the challenge of keeping it contained within the palm of your hand.
Okay. Now, going back to your review of the evidence in this case for purposes of blood stain pattern analysis, did you see anything that indicated that Joe Ryan not being involved in the stabbing?
Oh,
Leading?
Yes, I'm sorry, objection, leading.
All right, I'll sustain as to leading.
Okay. What indications, what if anything, do you look at to
What if
determine
anything?
if someone's involved or not involved in an incident dealing with stabbing?
I think maybe I would like to answer it in the methodology of how I look at a bloodstain case. Once I've evaluated the pattern types and come to some classifications and come to some interpretations of how they might relate to each other, I might be asked, or sometimes I'll even have information like I might have had in this case, to look at it and think of it in terms of statements that were made, or in that we had information from the body cams that I had when I was looking at that. So when I do that, I can kind of evaluate the evidence to see if there's anything that sort of doesn't seem to align with one way or another, or some things that, not necessarily that do, but more looking for the things that might raise, quote, the red flag, like kind of go, oh, this doesn't seem to align with that. Maybe I need to do some more exploration or find out more information about that. So that's what I did in this case.
Okay, and did you, and it sounds to me like you're looking for things that rule someone out and things that stay with the possibility of being one of the people there.
Yes.
Okay. In your pattern analysis, bloodstain pattern analysis, did you find anything that would exclude Joseph Ryan as being involved in the stabbing?
Objection calls for a final conclusion, goes to the...
If you want to approve.
Yes, please.
you tried to do it yesterday. Yeah, this witness is like, the state's theory sucks. And I still think the most critical thing that we got here was the clarification on that, the swabbing, the intentional swabbing, which is really coming from the lab. It's not an opinion from either one of these expert witnesses. It's just, she looked at the report and is letting the jury know that the DNA swabbing was intentionally done to avoid the blood staining.
Ma'am, you had an opportunity to listen to Ms. Graff yesterday, correct?
Yes.
Now, in terms of your discipline of blood stain pattern analysis, is it your experience that everything can be labeled based upon an analysis?
Oh,
Judge, objection is leading.
What, if anything?
I'll sustain the objection. Go ahead.
Yeah. What, if anything, is your experience as to labeling every aspect of spots, even if they're not tested?
I'm not sure what you mean by labeling. You mean classifying them?
Classifying, sorry.
I'm sorry, state again. So what is my experience regarding whether you can classify everything in a crime scene? Oh, no, many times we can't classify certain stain patterns because of some of the things I already mentioned. It could be the target surface, the amount of stains that we have, the other data that isn't just available for us to form that classification. So that's not uncommon. And we can't really classify every single bloodstain. We don't attempt to in many cases.
Iris
We
did.
could be doing it a long time if we tried to identify or even address every bloodstain that's at a crime scene.
Okay, and in listening to her testimony yesterday, did you have any agreement or disagreement with what she said about certain bloodstains?
There were certain bloodstains that I did not provide a classification for that she did.
Okay, and are there any in particular that you're speaking of?
Well, the forearm stains was one area. The 4 irregularly shaped stains that are on the forearm, she provided a classification for as being drip stains, and I did not.
Okay, and why did you not provide a classification?
Again, as I stated, the target surface here really distorted or what we were able to see
It's
to get
cylindrical.
that sort of well-formed circular stain that you would be looking for to be able to say that it's a drip stain from the exclusion of all other mechanisms. Because once you've classified it as a certain mechanism, you've excluded everything else. I didn't feel there was enough information here for me to do that. And this target surface, it would be inappropriate, I believe, to do that because the target surface was not ideal for being able to do that.
Now, if you didn't have enough information, would it be possible after the fact, which is what it was?
Objection is deleting.
All right, I'll stay in the leading. Is this a good time to take our lunch break?
Yes, yeah.
Okay, all right, ladies and gentlemen, let's go ahead and take our lunch break for an hour.
Over the
Please
lunch,
discuss
learn
the
how to ask
testimony with
better
any-
questions.
Discuss the case with anybody, and don't do any outside research, okay? Thank you.
So what this is getting into, and again, I think the witness is doing the carrying here. The witness is asking for the clarification on the questions. But hey, compared to what Iris testified, you watched Iris's testimony. That was the witness yesterday that the state put on. Iris said that blood is objective. Can you always classify everything? And this witness says no. And when you classify something, that's saying that every other possibility has been
Again,
excluded.
since you're testifying, you can't discuss your testimony with anybody this time to include the defense team, okay?
Okay.
All right, that's fine. So we'll come back at 2:05. You're going to make sure all your technology is ready for the afternoon.
I'm
To
gonna-
include your exhibit numbers, please.
I was actually going to just talk to your clerk and make sure that I had all of the.
All right, and make sure you
Piecemeal.
get it straight. And
Yes.
you don't have to be a hero. I do take paper documents if necessary, you know that. right?
Judge, I just can't do that. I'm a technology guy now.
Oh,
So you're
no.
saying,
No, no,
okay.
no.
2:05, okay?
Thank you.
All right.
They have like a 40-ish minute lunch. All right, so I think what I want to do, and I've got to take a second to cue it up. So, yeah, I personally think that Iris was very confident in saying blood is objective. This is what the blood says yesterday. She did not want to let down on that. She said it twice. This witness is saying, hey, the target surface, especially when we're talking about the forearm, another issue is going to be the neck, which is cylindrical as well. It's a curved surface. There's also body hairs. You know, we heard this witness talk about the impact body hairs can have on the way blood might land on what you think is skin. Well, it's not just skin, it's skin and body hairs. And now the target surface and the motion of something dripping, is that drip because of the way that the blood matter itself traveled and came into contact with that surface? Or is the drip caused by the fact that the arm is curved in nature? So, you know, to me, this is a much more, I don't even want to say it's a better scientific approach. It just seems kind of like common sense. You know, you couldn't exclude that the curvature would have an impact on the way that the blood, the liquid, would ultimately form and shape once it made contact with that surface, as opposed to if it had been a different surface. I think it's a good look for this witness to say, hey, you can't just say blood is objective. And you can't just say my analysis of blood is objective because blood is objective. So, yeah, the ink blots thing, I think that's a good, kind of an interesting comparison there. Adventure Aaron says, Shaq, Kokomo, save us. So what I think, do you guys want to rewatch this part that I keep saying I think is the most important. It's really not about blood spatter. It's Erin's saying here, okay, now that they're on break, what does she mean that the lab intentionally avoided testing the pants zipper and button for blood? So remember, when it comes to the pants zipper, the button area, the profiles, DNA, it could not exclude Christine or Joseph, but Brendan and Juliana were excluded. The state's theory is that the scene was staged. So even if Joseph Ryan was a patsy and might have unbuttoned his pants before he walked into the room to a woman that he thought was Anastasia and then she wasn't, it doesn't really make sense that Christine, that her DNA is like inside the zipper area. Because even if you would put your hand to press away, would that really explain it? And the other thing that I was thinking about before these witnesses testified was, well, what if their DNA is there because it was a chaotic scene and blood was just all over? Like, it would make sense that Christine's DNA could be in this area because her blood was all over the scene. So now we heard about it yesterday, but Iris pushed back on it and she just said, well, that's not what I said. I said I saw blood stains. This witness is asked about the same DNA report. And I'll run back what Iris said, but I did, let's see, DNA report. I did put it in the chat, my notes on what had been said yesterday. Let's see. So Iris had said, my understanding is they found DNA profiles. John Carroll said, well, did you read that report? The DNA analysis report. She said, I think I did. John Carroll had said the request for the analysis was not for blood stains, but for contact or touch DNA. Iris said, I don't recall specifically. John says, well, you spoke about blood transfer stains. And then I wrote that Iris says that she said she saw a transfer stain near the back of the button. Defense then asks again if she's aware the testing wasn't for the blood stains. Iris says she testified about seeing stains. So this is where she's saying, well, that's not what I said. But the key issue was that it's not the blood that was tested. And today we got the clarification with this witness that the lab, this is from the lab report. This isn't like one of the bloodstain people just saying this. The lab says that they intentionally swabbed the clothing and avoided the bloodstained areas. That way they could have more confidence that the DNA profiles that they were getting, the mixture that they were testing, they could have greater confidence that it wasn't being contributed to the mixture because blood had spattered onto that same area. So is it 100%? Like maybe there's blood transfer that they can't see just because it's not a visual stain. But I think it's very helpful to the defense nonetheless. So, yep. No, that's exactly why it's important, Erin. Honestly, I assumed it was blood on the zipper and button area. And I think if we were to revisit like the chats on, I think day 2, we might have started talking about that. Maybe it was just day 3. Where we had, no, I think it was day 3 with the lab techs, and then we get that stipulation at the end. Right, was that day 3? Where did we get that stipulation? Okay, yep, so day 3, that's when we had the stipulation, the presence of DNA. Remember, this is the thing that the 2 lab techs don't testify about this. The state just stipulates that there was presence of DNA on the zipper and button that could not exclude Christine. That was the very end of the day on Thursday before we had the long recess. That makes it more interesting, doesn't it? That was the same thing that the state stipulated. Huh. Yeah, and Touche says, I know it was only audio, but those cops sounded chaotic. I don't trust that they didn't spread DNA of both victims. I mean, you have them yelling at the firefighter to stop kicking things around. Like, oh, goodness. So I don't know, if you guys want to go back and rewatch that part from Iris's testimony, I can pull it up. It's going to take me a second because I'd rather find like a keyword I can search in the court TV transcript and pull it up without me in it. Because I think I probably paused and commented a bunch yesterday too. So in the meantime, do you guys want to run a little bit of closing arguments from Uvalde? And I'll come back, like, 'cause it's only like 5 minutes that we're gonna watch. I'll come back at 5 minutes before they come back from lunch. We'll cut off the closing arguments and we'll watch that bit from Iris. And if you missed it this morning, the state asked for permission for Iris Dallygraph, their blood spatter expert witness, to watch a live stream online of this expert's testimony because they have her ready to come back as a rebuttal witness. So yeah, that's all that screams to me, Aaron. They did not want the defense getting into that testing. So, all right, let's do that. And do you guys, so do you guys have a preference for what you want to watch? I know everybody loves the defense attorneys in Uvalde, so do you want me to go right to that? Or do you want to watch the state to see if how they argue this? To me, it could go either way. What would be more interesting to watch in a short period of time? So quick vote in the chat if you want to just start with prosecution's closings or try to jump right to the defense. Or TV. Yeah, and good point. So even if the DNA was transferred, Brendan and Juliana still didn't open his zipper. So that part, at least, can't say that part was staged. I love having Erin in the chat for more than just her knowledge. I think she's very funny too. But here Erin says, supposed to do 2 confirmatory tests on staining that appears to be blood, then qualitative testing to identify the areas most likely to produce a testable sample, then quantitative to get the profile. Maybe that's kind of like the catch-22 the state was in. Like, if we want to go and criticize and try to find a flaw, like, again, it's that role reversal, right? If the state had tried to poke an issue in the testing specifically related to this button area and the methodology, are you sure it was a clean test? The type of thing you would expect a defense attorney to do. Well, then that could also, parachute out, and that same type of criticism could start applying to all of the things you do want to rely on from this same lab report. So I feel like they probably didn't want to call into question whether they did this part really well, the best that they could, because it would have been not good for them to say that they did this the best that they could. And if they didn't do it well, it hurts them to highlight it because that same didn't do it well could apply to every other thing that they tested. And Angela says they could have used his hands to put on his pants for staging. I don't know if you can really manipulate a zipper that way. Maybe it's easier to take off. You kind of, maybe like a zipper, you could just pull the cloth and it'll do whatever. I don't know. I've never tried. I don't have that experience. So, funny enough, I think Court TV is playing. So this is the Court TV feed for the Uvalde Day 11, and they're currently looking at what we just watched. So let's go backwards. And nobody's answered. I just have a yes, please. Yes, please. Yes, please. And I'll be watching the closing arguments as a recap over, I don't know, probably Ian Runkle. I hope he gets, if you guys didn't hear, YouTube did a takedown on Ian Runkle's stream yesterday. I hope he's gotten that sorted out. When I was watching, he pulled out an airsoft gun and said, YouTube, this is an airsoft gun. And he was live for a little while longer, so I'm not sure if that was actually the cause. Or if they were just very delayed in doing so. But apparently his appeal was shot down in seconds, even though the appeal is supposed to involve a human review. So, yeah, do you guys have a preference? I think this is the prosecution closing queued up. Oh, or maybe it's jury charges. Oh no, let's skip that. I'll watch that on my own time.
Again, signature line for the foreperson and a line for the printed name of the foreperson. Identical identity documents.
Oh, hold on, let me boost him because I think he's going to be quiet with no microphone.
Abraham Lincoln said that it is much the duty of government to render prompt justice against itself as it is to render the same against the people. What he was saying was, we have a government comprised of prosecutors and police officers whose job it is to render justice against citizens when they violate the law. And that's what we're accustomed to. Prosecutors and police officers working together when someone has violated the law so that they may be held accountable, so that we may have peace and dignity in our state. But Lincoln reminded that no one is above the law, that those in government can also violate the law. And when that happens, it is the government's job to also render justice against those they work with.
This is horrible.
And so on May 24, 2022, when 19 children were slaughtered, and 10 others were injured, Texas Rangers from all over the state came to Uvalde, Texas, investigated the crime scene, talked to witnesses, analyzed the case for up to a year. And after analyzing the case, one of the members of the government has been brought to you for justice. But ultimately, in our country, in a democracy, it is the people that decide your government. You do that by electing officials. You do that by sending letters or requests to have the law changed. And when one of the members of your government violates the law, you decide whether or not that is acceptable. Because make no mistake, the 12 of you will set the bar for law enforcement in these situations. If it's appropriate to stand outside hearing 100 shots while children are being slaughtered, that is your decision to tell the state of Texas. And by the same token, if that is not appropriate, that is not how we expect officers that are charged with the duty of protecting children to act, that will also go out from the courtroom. The judge has told you that your oath was to render a true verdict according to the law and according to the facts. He has given you the law, and it is that same law that we discussed in Fort Dyer some 2 weeks ago. You recall we talked about this is a special statute because we're dealing with a special group of people. We're dealing with children under 15 years of age, and so we're expected to act differently when we're talking about children that are frail, can't defend themselves, 15 years old or younger. And in this law, the law of child endangerment, none of us are allowed to endanger a child. None of us can point a gun at a child, put them in danger, put them in harm's way. But there is also the protection that if you have a duty to act, you can't stand by while the child is in imminent danger. If you have a duty to protect the child, you can't stand by and allow it to happen. We talked about the people that have a duty. Parents have a statutory duty, and police officers have a statutory duty. And those two sets of people cannot fail to act when a child is in imminent danger. And so the charge in this case is that these 29 children were in danger. Not just danger, but imminent, immediate, close at hand danger. And that there was a man who had a duty to act, who failed to act. And that failure to act, he was aware or should have been aware that that placed those children in danger. But we're also very specific about it. How is it that he failed to act? He failed to act after being aware that shots are fired, being told the general location of the defendant, of the gunman, having time to respond. He failed to act by either engaging, distracting, delaying, or even attempting to do those things. And also being aware that shots were fired and being advised of the general location of the shooter and having time to act and having been trained in that active shooter training. He failed to follow his training to respond by advancing toward the shooter until after the children in 111 and 112 had been shot. That is the obligation the state has to prove to you beyond a reasonable doubt. two other quick mentions of the law that the judge has given you that I'm afraid we may not have discussed in detail on voir dire. The first was that the defendant must engage in a voluntary act. The first was on causation. We talked about when you have child endangerment by omission, there can be two people that can be held responsible. The person that is causing the danger and the person that has a duty to prevent that danger failing to act.
I'm just going to object to this one. There's concurrent causation is on his board, but not in the charge.
I'm not discussing that. That's just now what we do that. Chapter judge, and I just didn't point it off. I didn't say concurrent cause. I talked about what we talked about in the law.
Okay. I'll really objection. Go ahead. Ladies and gentlemen, I just noticed the clerk brought to my attention, we were working on that charge yesterday. Your date's wrong on it. It's 21. It's January 21, the last page. So it says 20, but it's 21. You know that. Go ahead.
The second issue is voluntary. The defendant must engage in a voluntary act. That's as opposed to an involuntary act. An involuntary act, I believe we talked about during jury selection, is, you know, if you stumble and knock somebody over an embankment and they're injured, that wasn't a voluntary act on your part because the wind blows you into somebody. You're not responsible for that kind of conduct. If somebody swerves into oncoming traffic and hurts somebody, that certainly looks like you should be responsible for that conduct. But what if it was the very first time you'd experienced a heart attack and you lost control of the vehicle? That's not a voluntary act. That's an involuntary act. You're not responsible for that. But if you make a decision to seek cover and ask for cover as opposed to going in and stand by while people are actively injured and killed, that is the kind of thing that's a voluntary act. It is defined in the statute. And finally, on mental states, there were 4. Intentional is not really something to discuss. Nobody believes that Adrian Gonzalez meant for this to happen, wanted this to happen. But the other 3 deals with their level of awareness. Knowingly means simply you're aware that by standing by, it's reasonably certain the children will be in danger. Aware is reasonably certain. Reckless is 1 degree lower than that, and that is not that you're reasonably certain the conduct will happen, but reasonably certain that there is a risk, a substantial and unjustifiable risk that the children will be in danger. But there's still an awareness. But in addition to that, there's criminal negligence, in which the law is simply, you should have been aware, based on all those circumstances, that by you failing to act, the child was at risk. So that's the mental state. Not that he intended it, wanted it to happen, but at minimum, he should have been aware that by standing there, hearing 100 shots, he should have been aware the children were in danger by his failure to act. And so then we move into, and beyond the law, into what the state's case was. And it's pretty straightforward. This is not the order we put it in, but this is just the order I drew it up, because training is a big part of who Adrian Gonzalez was. And you have the training that he trained others, because that tells you what he knows. And it also tells you a lot about what the state has done before you got here. In that lesson plan that was introduced into evidence, it tells you that amidst active shooting, the state of Texas stepped forward and required active shooter training for school police officers. And that active shooter training includes stop the killing, stop the dying. And it's not terribly complicated. The training is go to the gunman, advance toward the shots. Pretty straightforward. Not complicated, not hard. Go to where the gunfire is. That's what the training is. We brought you evidence that Adrian Gonzalez taught the class that said, advance to the gunman, stop the killing, stop the dying. Even if you're the only one there, solo entry, you've got an obligation to go in. Why? Because in our state, we have a priority of life. Innocent civilians, their priority of safety is above the police officers. The officer going through this training is aware that the safety of the innocent is above the safety of the police officer. And in Adrian Gonzalez's training, he says, the citizens have a right to expect that. And if you're not willing to do it as a first responder, find another career. Adrian Gonzalez is teaching his fellow officers, take your job seriously. It's okay to move aside. It's okay if you're not up to that. Let somebody else step in that is up to it. Because as citizens, we have the right to expect that. When we call for help, we have the right to expect somebody that has put on the badge and put on the gun and put protect and serve on the side of their car will do that when we call. Because if they're not willing to do that, where are you? What are you left with when you're in danger? Who do you call? And so Adrian Gonzalez, armed with this training, The next thing we spent a considerable amount of time on was the shot count. The casings along the west side, the casings along the hallway, the casings in 111, the casings in 112. And why did we spend all of the time on that? Because it's the state's position that each shot was noticed to Adrian Gonzalez to advance toward the gunfire. Each shot was important to those 19 children and those 10 survivors. Each shot. But the shot count, also as we did that, and obviously if you have this kind of slaughter, there's going to be blood, and we apologize for that. But the blood also tells you a story of children engaged in this, doing as they were trained. To hide in the dark.
Thank you, Leapfrog Leap. Ian Runkle's stream is back up. Good news.
Did the defendant have time to act? We brought you videos, the funeral home videos, as well as the hallway videos, as well as dispatch, to tell you what he was aware of, when he was aware of it, and what was going on as he stood outside the 4th grade wing for 3.5 minutes before he made his first move, before he moved forward. We also brought you the defendant's statement. And the defendant's statement, I think, clears up almost the entire case. That is what he told the Texas Rangers shortly after this happened. If you're worried about whether or not he had notice and whether he had time to act and what his decision-making was, listen to these words from Adrian Gonzalez. He's over there. He's over there. He's wearing black. I say where? I hear shots going off. Hear sounds coming from behind the building. I get on the radio and say, shots fired at Rob's school, and give the location and where he is. Trying to get from the front of my vehicle to the back of my vehicle. There's only a tree in a building. She tells me he's over there. She's pointing, saying he's over there. He's dressed in black. I say where? She says the teacher's parking lot. I want to say I saw a black car at the end, and then I hear the rounds going off. When Melody Flores says he's over there, the teacher's parking lot, I hear the rounds going off. Some evidence of auditory exclusion. He tells the Rangers, as Melody Flores is telling him where he is, he hears the rounds going off. She goes, he's over there by the teacher's parking lot. Then I hear the sounds going off. I heard 7 to 9 shots while I was inside the building. The coach said parking lot in all black. That's when I heard the rounds start going off. I never saw him. I never went to the school until I got coverage over here. Then I made entry. I heard like 3 or 4 gunfire. When Pargus was the first one I saw, I told him to come to me for cover because he has a bigger unit. But he deterred and went to the other area. I knew there were kids in the class. That's why we didn't fire and hit the kids. I'm responding because they are saying the guy is running to the school. I didn't respond to the accident. That's a PD traffic. I'm going over there because they are saying the guy is going to the school and has a gun. Yeah, that's why I'm going to the school. And so the question is, if Melody Flores is telling him where he is, he's in black, when did she tell him that? Do you really suppose that someone who risked her life to go tell the kids to get inside the door, that is that worried about those children, that turns to run, that when the police officer gets there, doesn't immediately say what she told you she said? He's over there, he's in the parking lot. Where? And she points. And then says, we've got to get in there. And isn't that consistent with what human beings do? Look at Gilbert Lamone's. When he sees children in danger, just as Melody Flores sees kids in danger, what does he start saying? Get in there, get in there, get in there, get in there, get in there. Repeats it over and over and over again because of the urgency of the children being in danger. And Adrian Gonzalez decides to go to the back of his car, call Mariano Pargas because he's got a bigger unit, and says, I'm not going in until I get covered. We proved to you the children were in danger. And I know that was a horrible thing to have to experience. But each one of those children deserved to be revived. And you needed to know that those 60 shots in rooms 111 and 112 before Adrian Gonzalez entered, those shots ended those kids' lives. This was over before he went in. A lot of blame for a whole lot of officers. This was over. while he stood outside. And we anticipated that the defendant would say I was confused regardless of what he said in his statement. And so, certainly gunfire can be a confusing thing. But we brought you teachers that experienced that gunfire. And the teachers told you that experiencing that gunfire, they still put their kids first and they follow their training. Kids first, follow the training. Melody Flores did it. Miss Deming in room 104 did it. Miss Ogburn in 102 did it. Miss Robin did it with her children. And Mercedes Salas said, not till I get my kids out. You can talk about confusion, but their priorities were where they needed to be. Children first. I'm going to talk about the defendant's evidence, or the defendant's case, let me say. We started very early on that Monday, but he didn't have time because it was too far. It was 45 seconds over there. So we brought you evidence that somebody that covered almost that same distance was able to do it at a jog in about 11 seconds. It was further than that, given 15, 18 seconds, but it certainly wasn't 45 seconds. And then there was the representation. There were no shots fired toward Melody Flores. There's no evidence of that. And so we brought you the evidence of 8 casings on the side of the parking lot, the shot into room 24. Well, those 8 shots were accidental discharge by a man bent on killing kids. He just made an accident, swung his gun around, and fired those shots, not toward Melody Flores, but toward that window. And so we brought you the casings. One picture shows 3 of the casings, which you remember the FBI agent said we had to go back several times, and so there's 2 more markers that are additional. There's 5 casings. There's 5 shots in the glass, and 5 shots directly across up into the, not 5, but shots shrapnel up into the ceiling and down into the floor. So where are those 8 casings being fired? If we have those 5 taken care of, as well as in one room 104. Well, we have room 24. And so they tell you, well, that could have come out of room 111. So we brought you evidence that it was circular or almost oblong, saying that's the wrong angle. But more important than that, there's a piece of conduit running up the building. That bullet would have to pass through without leaving a mark. That evidence about Melody doesn't know what she's talking about is so you don't trust Melody Flores. And if you have any hesitancy on Melody Flores, go back to the defendant's statement where he said she told me where he was, what he was wearing, and then I heard the shots. We had a lot of information about slicing a pie and how long that must take. No way you have time. You got to get over to the side of the building and slice the pie. You can't do it quick. You have to do it slowly so you don't put yourself in harm's way. There's no evidence Adrian Gonzalez got to a point where he could slice the pie. And we had evidence from their expert that said, slice the pie, how about taking a quick peek? You have cover, you have concealment, the gunman can't see you, you just peek around from a safe position. Well, it wasn't really covered. Well, it's not covered from the south side, if the gunman's over there. Adrian can see that way. It's not covered from the west side, if the gunman's over there, he's not over there, what Adrian can see. But it is covered from the northwest side, where the gunman is firing 6 shots. While Melody Flores is telling me he's over there. Echo, Adrian did tell the Rangers that there was an echo. So from his spot where he's standing, he's got to find out where that shot's coming from. And he can see on the east side it's not coming there. He can see on the south side it's not coming there. He can see on all directions except behind the building where Melody Flores is telling me he is. That's where it's coming. Not only that, but when Coronado runs up and he hears those shots within 2 seconds, he's saying, shots fired, get in the building. And Adrian Gonzalez knows which building to go to. And Paige knows which building to go to. And they go to the building where the shots are fired and have been firing for 3.5 minutes. Well, let's talk about the doors, the responsibility of the doors. The doors would have slowed him up. Yes, the doors would have slowed him up. He had an AR rifle that penetrates glass. The glass is right next to the doors. He could have weakened that glass within a matter of seconds. It would have slowed him up 2 or 3 seconds to go through that door. You look at rooms 111 and 112 and you see the shots there surrounded around the window. May have slowed him up another couple of seconds if the door is locked. But we're not talking about a couple of seconds. We're talking about 3.5 minutes, number one. Number two, the charge of endangering a child means you have to be aware the child is in imminent danger when you fail to act. And that unlocking, that failing to act, failing to lock the doors, did not happen as the gunman was firing the guns. The children weren't in imminent danger, immediate, close at hand danger when those doors were locked. Their failure to act at that point was not at the point where the children were in imminent danger, nor is there evidence they had a statutory duty to act. And in this case, let me say, there are adults we can be very disappointed in. There can be police officers we're very disappointed in. I don't know how you feel about everybody, all those people. I'm not proud. This is the case of the state of Texas versus Adrian Gonzalez and the facts against him. And is he going to be held accountable for his lack of action? And so we concentrated our case on the facts against Adrian Gonzalez. It's radio dispatch's fault because they didn't give significant enough information. They just said, wreck, man with gun, shots fired. They didn't say if he was shooting at the school or not. That's important information we should have known. But their expert got on the stand and said, wreck, man with a gun, what does that say? Not a lot. A man can be with a gun, but not be all that dangerous. But what about shots fired? His testimony was, then it gets real. What does that mean to a police officer, shots fired? Then it gets real. Then on your way over there, you got time to know, I'm facing somebody where there's shots fired. It reduces the confusion about the preparation. Shots fired. This is real. I've been trained. Shots fired at a school. Not the information in school. Shots fired. Well, I've been trained. I may not have done it. I've been trained. I may have to go in solo. It was the police administration's fault because they didn't assign a person to each school. I suppose that statement is really, if they had assigned somebody, as long as it wasn't Adrian Gonzalez, that would have been different. The defendant's case, then we move to the other police officers, Page, Hill, Sauceda, Coronado. And I'll ask you to look through your course charge and find where it says evaluate the conduct of Page, Hill, Sauceda, or Coronado. You're here to decide one case. But we're glad to talk to you about these officers. Page, the funeral home tape alone shows you that he shows up 2.5 to 3 minutes after Adrian Gonzalez is there. That, along with the raw videotape, shows you that he entered the building in 30 seconds. He shows up, there's shots going on, he assesses the situation in 30 seconds. He's acting. He's acting. Not failing to act. Hill, you recall that it's Hill's responsibility because he was called to Old Carrizo Road. He goes to Old Carrizo Road. He arrives there after the gunman is already inside the school. After the 16 shots from outside have already been fired. On the other side of the school. The testimony was there was radio chat about setting up a perimeter. So it sets up a perimeter. Because here's what officers do. They get dispatched and they act. And when they get there, they assess a new set of information and they act. And after he sets up the perimeter, then he joins other people. And yes, the testimony was 25 minutes before he goes in. But Rudy Gonzalez tells you that once those hallways get full, it become dangerous to overflow that hallway. So you find other things to do. Well, if there's a perimeter, doesn't that count for Adrian too? Adrian got the call to set up a perimeter and he goes there, so be it. But then you gather additional information. And that is 16 shots being fired outside, 24 shots being fired in the hallway, 60 shots being fired in classrooms, and a teacher saying he's over there, you gotta get him. And you respond after you get the additional information. Sauceda shows up 30 seconds after the gunman has started shooting. The gunman shooting into the glass, into the classrooms. That's before Sauceda gets there. Halfway up, you notice when Sauceda gets there because the bag is dropped. And then shots are fired. 6 shots are fired from behind a long row of cars. You're talking about him having an instant. in which the gunman, we know, is hurrying the last part of that trip. We know the gunman is not firing into the building at that point. He's firing somewhere else. They think they're taking shots. If it's behind the vehicles, there's school classrooms with glass windows. If it's to the south and west, there's a man in dark blue or black. Permission to fire. Being careful. And then getting in his car and acting and following his sergeant to the end of the corner where Coronado says, I believe that's a second. Also, jogging to find the gunman. He's acting. When Coronado arrived to the sound of, he said he was receiving gunfire. The man at the funeral home is telling me, I think he says 2 or 3 the building. He's the officer that came that is used to these being bailouts, and maybe it's a road rage, and that's what he's used to doing, whereas a school officer is used to protecting the school grounds. And so he's thinking this is a road rage, and the guy's shooting at us because he doesn't want us to get him. So he goes around to cut him off. But in going around to cut him off, he's acting. He's acting to stop the shooter. You may not like his decision, you may not be proud of his decision, but he's acting. This is a failure to act case. And you know that he's acting because he jogs, he's looking for the gunman. And when he hears shots fired, he acts within 2 seconds. Get in the building, shots fired, and he goes in. He acts. And then the defense brought you evidence of the challenges that Adrian was facing. We start with tunnel vision. That's the whole issue about whether or not Adrian Gonzalez saw the gunman in the parking lot. We have no trouble with the concept that he had tunnel vision and focused on the lady in the beach. This charge does not start with Adrian Gonzalez arriving at Rob Elementary. The charge starts specifically with, after hearing shots fired, after Melody Flores, witness number 1, which you can conclude now is Melody Flores, told him the general location of the shooter, and then having time to act. That's when the case starts. So he has tunnel vision. Okay. Auditory exclusion? Perhaps you didn't hear the shots. Then why would you tell the Rangers when Melody Flores told me where he was, I heard the shots? How does that happen? This was really complicated. Complicated set of facts I have to decide on. Complication, the training is you hear shots, you go to the gunfire. He heard shots and Melody Flores was pointing where to go to the gunfire. There's nothing complicated about that. He's wearing black. He's over in the teacher's parking lot. Go to the gunfire. Perimeter. Why didn't Adrian get to set up the perimeter if Hill gets to? Why didn't Adrian tell the Rangers? I heard I was supposed to set up the perimeter. That's why I set up the perimeter. That isn't what he said. He said, I waited for cover before I was going in. And finally, this is an issue of stress. And this is my closing remark. I'm sure you're tired of listening to me. That was a dark day. For 29 families, it was extremely dark, and they still wait justice. And I can't let that darkness. But I can say this, there were some bright spots. In that stress, teachers put their kids first. In that stress, kids made ways to try to defend each other. In that stress, kids comforted teachers. In that stress, kids came first. Adrian Gonzalez had a duty to put the kids first. And he called. Okay.
Proceed, John. Yes, sir, please.
The monster who hurt those kids is dead. That monster is dead. And we told you from the beginning. And it is one of the worst things that ever happened. And I told you, the first time I stood up here and talked to you, I told you that you were not going to be the same person when you come out of this. And nor should you be. Nor should any of us. Witnessing horror the tragedy, the loss, it's immeasurable. It's immeasurable. It's unthinkable. That loss is unthinkable. Their loss, it's unthinkable for any of us. You know, I told you guys that I have a 4-year-old, 1-year-old. And, you know, we told you we're from San Antonio. And obviously, you know, I want to go back and see him on the weekends after the first week. I went back. And the first thing I did was my 4-year-old came downstairs and I hugged him. Right? And hugged him. Started crying. Asked Gary, you know, trying to, so he doesn't see it. He said, "You sad, Daddy?" I said, "No, I'm happy. I'm holding it." Because I know what a privilege, doing this case, I know what a privilege it is to hold that child. I do. Right? I know, I can just imagine what it's like to not be able to do that. And I can imagine the pain, and I can imagine the anger. I can imagine wanting to put somebody in that chair because I can't put the monster that did that to my child in that chair. I can imagine that. And I can imagine putting pressure. And I can imagine them responding to the pressure. And I can imagine them putting him in that chair. Him and only him. In that chair. To try to pay for the pain. To try to somehow this could cover the immeasurable and the immense loss. And so after I saw him on Friday, we have to come back here that Sunday after the first week. And Gary, he comes and picks me up. That's kind of what we've been doing. So my son comes out and he says, "You're going to go help that man?" That's what we told him. That's the reason I'm not here. I said, "Yeah, no, I'm going to go help that man." Adrian Gonzalez. Because he needs my help. He needs our help. Because they, the government, the power of the state, has decided that he has to pay for the failures of that day, for the mistakes that were made that day, and for all the pain that they feel. And it's not right. Because the person that they plucked out and put in that chair, that person showed, we showed throughout this trial, that person was acting. He was acting. He was trying. And what I hear from the prosecutor, what I hear from the state, and what you've heard this entire time, what you've heard is that they will massage all the facts, they'll twist them all into a pretzel. That every one of these officers is fine, he's not. They'll twist it. Well, look who acted. They acted. Well, Adrian acted. Well, he didn't act the right way. They acted. Well, they didn't act the right way. Well, yeah, but he didn't act the right way, and he didn't know exactly what was going on, and he remained. Well, yeah, but Adrian remained in the hallway. Adrian remained in the hallway after he got shot at. Well, yeah, he remained in danger at that point, but before that point, he remained, and he didn't know what was going on. Every fact that they tried to bring, they twisted it around. I'm going to show you. You're going to watch. I'm going to show you what they've done to twist this thing from the beginning to the end. But ultimately, what we're talking about is we're talking about duty, we're talking about burden, and all of those things. I don't want one thing that I'm saying right now to make you believe that he doesn't believe that he has a duty to stop something that he knows is going on. Of course he does. He knows that. He was trying to do it. He started trying to do his duty. You look at some of these other people, no. They're not trying to do their duty. They're trying to stay back. And one of the things that the prosecutor said, he said, "What you do here will tell law enforcement, give them how they respond." I'll tell you what, I agree with that, but not in the way that he's saying it. Because the way he wants you to believe it is what your verdict says is that next time, these officers will make the right choice, the right decision. They will respond appropriately. They will be perfect. But the problem is that the issues here are not that Adrian failed to respond. They're not that he was intending not to engage. So you're not going to fix any of that. Because I'll tell you, and I kind of hope it never happens again. I think we all know that it probably will. But those officers, what your verdict says is not going to make them perfect the next time. It's not going to make them not make mistakes. It's not going to make them not interpret things differently, strangely, weirdly, based on their own experiences. That's not what it's going to do. But I'll tell you what it would do. If you convict them, they're all going to be Randy Hill on that perimeter. There's nobody going. What do? You went in. You convict them. What does it tell all the police officers? It's going to tell them, "I'm not getting in that crowd. I'm not getting in that chair. If I see somebody running towards the school, I'm not going after them, because if I'm mistaken and it takes me to the other side of the building from where the shooter is, and then I can't understand or know where the shooter is, I can go to prison. I can get prosecuted." So what you tell police officers is, don't go in, don't react, don't respond, stay on the perimeter, because Randy Hill isn't sitting in that chair. He's not. Adrian Gonzalez is here. Randy Hill is not. None of those officers are in that chair. That's what you're going to tell them. You're going to tell them, don't do it. And you can't tell them that. I agree with them. You can't tell them that. We cannot have law enforcement feel that way. Feel like if they're not perfect, if they don't make a perfect decision.
All right, guys, we are 5 minutes away from when the court is supposed to be back in session for the Brennan Banfield trial. So we are going to stop there. We got to see a little bit of the defense. I'll be catching all of this on recap. Thank you for the news that Ian has his stream back together. I'll be watching his recap tonight. And I'm sure plenty of people are covering this live right now. I think even Andrea Burkhart was watching this live. I was watching with her this morning before I started this stream. I'm sure she's still going. But I wanted to pull up, before we get back to the defense's expert, the blood spatter expert, this issue of the swabbing, the testing in the button area, the zipper area of Joseph Ryan's jeans. And I've got to walk back my criticism of Iris a little bit because I think it's the state in the way that they're questioning. It seems like the state doesn't want to talk about the DNA report. Remember, this is the same issue that the state stipulated to very quietly and quickly at the end of the day on Thursday. So let's go to the first clip, which is going to be a short bit of questioning on direct. And I'll get my banner up so anyone coming back in now will know that we're rewatching something. Get some captions. So we've got 3 short clips we're going to go through.
You noticed those bloodstains on the jeans?
There's a transfer on the left front of the jeans. There's a transfer on the inside of the jeans waistband at the buttonhole.
Thank you. Did you review the certificates of laboratory analysis submitted in this case?
I did.
And whose DNA profile was present in the swabs of the blood from Joe Ryan's hands?
So notice how they go right to the swab on the hands. So we're talking about the button area, then we go to swab on hands. So we did hear Iris talk about these DNA reports, but at this point, she wasn't actually asked about the DNA analysis in relation to the swabbing in the button area. So I think the state wanted to move on. Didn't want to get too far into that. The next clip that we have is, let's see, about 30 minutes later.
In conjunction with your reading of Commonwealth's Admitted 151, the lab from DLI, about Mr. Ryan's reading. All right, what observations did you make in conjunction with your reading of Commonwealth's Admitted 151, the lab from DLI, about Mr. Ryan's pants and any blood stains observed there?
My recollection of the analysis was that both profiles, DNA profiles from Christine Banfield and DNA profiles from Joseph Ryan were found in stains on the jeans.
All right. Let's talk about them one by one. Specifically, did you examine the area in the photo of the button and the zipper?
There was a sampling from that area that I read the DNA analysis report for that sample.
Okay. And
So she's asked about this area. She goes right into, I read the DNA report for the sample.
all right.
Let's run that back and then watch the prosecutor switch.
Well, let's talk about them one by one. Specifically, did you examine the area in the photo of the button and the zipper?
There was a sampling from that area that I read the DNA analysis report for that sample.
Okay. And that sample of blood, were you able to determine if it was a flow, spatter, or transfer?
The stains on the area of the button and the buttonhole were contact stains or transfers.
So Iris is going with the flow of the prosecutor's question. It is the prosecutor that conflates, and that's how I'm looking at it now on replay. The jury doesn't have replay, but it's the prosecutor in her question that conflates the DNA testing in this area with the blood stains that are visible in this area. And Iris does say, you know, the blood stains. She doesn't go back to talking about the DNA report. So they move on after this.
Looking at, if I may advance to Commonwealth's previously admitted 101.
So it goes on to a different topic, a different area. And then on cross, when John Carroll asks about this, I think this is why Iris was so adamant, like, hey, I didn't really testify to those specific things. Because it's the prosecutor's question.
Now, you referenced a DLI report in your direct testimony. It said it was a private lab that the Commonwealth hired to do an examination. Do you remember that one?
Yes, I remember some of the reports were DLI.
Okay, well, there was only one, and the one was relating to the DNA that was being sought inside Joe's zipper in his button of his pants.
Zipper.
You remember that?
I don't recall it being inside the zipper. It was identified to me that some sample in the area of the button or in that area was in fact sampled, and that they did find DNA profiles.
Okay, and did you read that report?
I think I did.
Okay, isn't it true that the request for the analysis was actually not blood stains? The request for the analysis was around the blood stains for contact or touch DNA. Do you remember that?
I don't recall anything in it that says specifically how it was sampled.
Okay, so, but what my question is you spoke about transfer stains to the Commonwealth when they asked the question. You spoke about inside the zipper where the button connects, all those sorts of things, and you spoke about blood transfer stains, didn't you?
I said on the back side of the buttonhole that I could see in the image transfer stains.
So she did say that. That is what she was saying. It's the prosecution that really muddied the question after their own witness mentioned the DNA report, because she's the one that volunteers in the first set that we watched. You know, I looked at the lab report and the prosecutor was like, no, but the stains. Don't talk about the lab report.
I did not say what DNA was present in those transfer stains, just that there was a report in that area, and I think it was the button side as opposed to the buttonhole side.
But my question is, did you realize that the request for DNA was not for any blood stains? It was for touch DNA around that area that was described.
Judge, objection, facts not in evidence.
Overruled if she can answer.
And now does that objection make more sense? Beyond just being like, you know, I think the state purposely questioned the way they questioned on direct to avoid this very thing that they very quickly and quietly stipulated to at the end of the day on Thursday. So.
Did you realize that?
As I said, I wasn't a party to sampling. I don't know exactly how the sampling was done.
Okay. Well, I guess my question then is, how did it just automatically talk about transfers in that area when that wasn't part of any sort of scientific testing done by the Commonwealth of Virginia or their hired DNA person?
Judge, I'm sorry, I have to object. He is mischaracterizing what is in the certificate of laboratory analysis.
Objection, Ms. Sands.
Facts not in evidence.
Overruled.
I testified that I saw stains, particularly on the back side of the buttonhole.
Okay.
And looking at those stains, identified that as transfer stains.
Transfer stains versus transfer DNA. So different things here.
And despite the fact that the DNA lab didn't deal with stains at all, was that something that you dealt with the Commonwealth in preparation? Is that why you talked about stains?
I identified the stains because I looked at the picture and I saw the stains and I said what I saw. That is a separate issue from any testing that may have been done for DNA in that area.
Now, we looked at the hip stain that you identified.
And now they move on, and you can hear the state whispering in the background. But I really do think, as much as I still have an issue with blood is objective and that whole thing, this is either the state genuinely didn't understand the difference between what the lab actually tested for, and so they didn't understand why their own witness was answering the way that they were. Or, and I think this is more likely just based on the decision to stipulate and not harp on it, and that objection we just saw, they don't want the jury to hear the difference. So I think that was a interesting little throwback. Let me politely shout out Iris for like realizing that there were two different things being discussed here. Although it seems like a cluster F, like if you don't slow it down and piece it together. Back over to live court. Let's see if we have action.
All right.
All right, so we are back from lunch. I really think this is what it is, Banjo. Banjo and Kazooie.
Your next question.
They understood. They wanted to muddy the water.
Ms. Singley, good afternoon.
Good afternoon.
You listened to Ms. Groff's testimony yesterday, correct?
Yes.
Did you hear her discussion of the position of Joe Ryan and the blood, whatever she called it, on Joe Ryan? Do you remember that discussion?
Yeah, you mean specific to his arm? Or is that what you're referring
Specific
to?
to his position on the ground.
Yes, I did hear her talk
Okay.
about that.
Did you agree with that?
That the bloodstains would indicate that he was lying on the ground?
Yes.
No.
And what can you point to in your expertise that would have you arrive at that conclusion?
Well, so I guess starting with, I believe that she mentioned that the stains that were the 4 linear stains that I did not classify, she classified them. So that's where the first divergence was. So then that classification is what led her to say that he would have been in a position lying on the ground when they were deposited, if I recall correctly. So the first part is that as I mentioned before lunch, the target surface didn't lend to classification to start with, and to go on to then determine what that classification would mean in terms of his positioning is the part where it starts by the fact that I didn't believe that a classification could be made. Then to go on further to say what that classification would mean would be why I would disagree.
Okay. And was there evidence that you observed that would have supported different conclusions than that, other than not being able to classify?
So maybe the best way to describe this is to have you understand what a drip stain is in terms of bloodstain pattern analysis. A drip stain is a stain that is formed by gravity alone. So it's not just a circular stain you see on a surface. It's a circular stain that arrived by a passive formed by gravity. So it's not something that happened that's circular from another mechanism, but it just happened to hit the ground at perpendicular, making it circular. It is formed only through gravity alone. So the fact that I didn't classify it as anything was the first part. But then on top of that, if you have just the fact that something is circular does not make it a drip stain. It's one of the features you can look at, but it doesn't mean that it's a drip stain. So there are other mechanisms that when the blood is going through the air, say from an impact, say somebody was being beaten with a hammer. When the blood goes through the air, it goes in a parabolic arc, and if it doesn't hit anything in that trajectory, it will eventually fall to the ground, and when it hits the ground, it's going to look circular. But if it hits the wall on the vertical surface, it's going to look circular there too, because anywhere it hits a perpendicular, it will look circular. But we look at the size of them to kind of help to inform whether it could just be a drip stain, something that just was because somebody was standing over something and dripping blood, or if it was because of another mechanism. So because we didn't have a lot of these features, there was no classification done, because the size helps to inform that, and then the shape itself and the fact that we had this target surface to eliminate any of those other mechanisms, to only say that these are coming from drip stains and coming from above was part of the problem. Going further, if they were drip stains, it doesn't mean that because his arm was this way that he was down on the ground. It just means that the arm was in a position horizontal to where the passive drop was coming. Because people move around, your arm can be in, your body can be in different positions when you do that. So the orientation of your body and where that is in relation to where the blood is coming from is going to be how it will look like on that surface. But it's hard to then say, oh, the person was in this position just because there's something circular here that I think is a drip stain, and therefore, because it's coming from above, he has to be on the ground lying down.
And if you were, as you've indicated in your previous testimony, that you would need more information, what more would you need other than what you just said in order to even make the determination?
Judge, objection calls for speculation.
You mean what? I'm sorry.
Objection calls for speculation.
I'm just asking her what other tools.
Overruled, that's right.
Yeah, I think, I mentioned earlier, same answers as I would be looking at the size, shape, distribution, location, appearance. Those are the features that I look for and determine that this is a drip stain to the exclusion of all other mechanisms. I would want to look for something that would look perfectly circular, that I could see scalloping all around the edges or spining around the edges, or it's perfectly circular on, like, say, a smooth surface, and that it has some size to it that would indicate that it's coming from just gravity forming it. If it's tiny, then, and I see it in terms of other, maybe in terms of other spatter stains in that area, I'm going to presume it's coming from or classify it as something coming from a mechanism that's a spatter-producing mechanism, as opposed to just a single passive drop. So sometimes we can't tell. I mean, we just have to look for those features and hope that if the target surface allows for it, we can classify it.
And in the absence of concrete information, is it appropriate to default toward
Objection leading.
Sustained is deleting.
In the absence of additional information you want, how does one resolve that?
You go back to the higher classification. So if we start at bloodstain, and then we might go to a spatter-producing mechanism of some sort, and then we can classify that either to cast off or impact or expirated blood. If we don't have the features to meet those on each level of that, we revert back to the level that's higher. And so in this case, I just said, these are blood stains, and I described them. They were irregularly shaped, somewhat three-dimensional on the arm.
Okay. Thank you. I have no further questions.
All right, cross-examination.
Good afternoon.
Hi.
So to stay with where we just left off.
Okay.
You're keeping it at the classification level that's up here because you don't have enough information to go a next step. Is that correct?
Yes.
But that doesn't inherently mean that that next step isn't a possibility, right?
You sound like a defense
I don't
attorney.
consider the possibilities, because if I can't go beyond the classification, then I didn't go beyond the classification. There's a reason I stopped.
Sure.
So I wouldn't.
But because you stopped, that then leaves all of the options still available. None have been excluded, correct?
Sounds like reasonable
I mean,
doubt.
every possible mechanism that could possibly produce a blood stain.
Yes.
Yes, I guess, yes.
Yes,
Yeah.
including drops from above.
Yes.
Okay, thank you. Going back for just a moment, you testified regarding the DLI lab.
Here we go.
And you stated that the test sample was the pull from the genes avoiding staining. Is that correct?
I'm sorry, say that again. I didn't
You
hear that.
testified about the DLI DNA lab, specifically that the sample was a swab or a portion of Joseph Ryan's genes avoiding staining. Is that correct?
Avoiding, yes, avoiding staining, yes, I'm
Okay,
sorry.
but did you also read in the report that that sample was positive for blood?
Yeah, so it didn't say it was positive for blood. It said that blood was indicated in the sample. And so what that means is that they did a presumptive test. So that's a test that,
Right, we heard about that from our DNA experts. but-
yeah, so we didn't, the blood wasn't identified in that sample. It was an indication that there was blood there. And I think to clarify that the testing that is used in that instance is a very sensitive test that can pick up blood that you
Judge, I'm
can't
going to
see.
object. I don't think she's presented any foundation for knowledge of how the testing was conducted.
It's in the report, though.
And that wasn't my question.
All right, we're going to ask your question again. Let's go
Okay.
that way.
The laboratory result said that blood was indicated, yes or no?
Yes, that's not what you asked me, though. You said it was found. It was, yeah, the test only said that blood was indicated.
Okay,
And yes.
thank you. That's all I have, Judge.
Okay, any redirect? Is this witness subject to recall?
Wow.
All right, so
I just,
since you're subject to recall, just don't discuss your testimony with anybody, all right?
Okay, thank you.
Thank you.
Your Honor, if I can consult with counsel for
Yes.
just a moment.
I think there was a way that the prosecution could have worked with this, but they should have done it out the gate. They should have done it right away. But they distanced
The
themselves
witness
from
is
it.
not subject to recall.
Okay, you are not subject to recall, ma'am, so you're free to go if you wish. All right, thank you. All right, your next witness?
Yes, thank you, Your Honor. Brendan Miller.
Yes! Oh my God, it's the digital forensics!
Brendan Miller.
Digital forensics! I'm so excited. I was about to eat my lunch. I am gonna wait. I am so excited. You had to self-object. That's crazy. Detective Miller.
Or affirm to testify truthfully in this case under penalty of law. Thank you.
You don't have to go away. You can start my Miller notes.
So excited. Yeah, was he rehomed? Yeah, it's wild the defense is calling him. I have a spring mix salad with olive oil, Gouda cheese, and some salt and pepper. I'm really excited to eat it. I know it sounds boring, but I promise it's good. The whole chat rejoices. Yes, justice for all. This is apparently that guy, but the state seems to, dispute the notion that he was rehomed because of his analysis. So we'll have to see. I'm sure that will be a topic of questioning. Well, maybe the digital forensic.
Detective Miller.
Good afternoon.
Can you please state your name and spell your name for the court reporter?
Yes, my name is Brendan Miller, BrendanMiller.
And where do you currently work?
Fairfax County Police Department.
And what capacity do you work in the Fairfax County Police Department?
I'm a detective in the child exploitation section.
Okay. During your, were you involved in this case as an investigator at any point?
Yes.
Okay, and what was your capacity as investigator?
I was the digital forensics examiner for this case.
And when did that change?
About a year ago.
Sorry.
The computer.
Almost there.
No. No. Come on.
Yes, ma'am.
No. No course indulgence. Well, thank goodness we have a Judge Penny emoji for these occasions.
In child exploitation, do you utilize the same skills that you had when you were at digital forensics?
I do.
You should
Okay.
probably have worded
And
that
so
better.
when you left digital forensics, did you leave of your own volition?
I did not.
And was the transfer to child exploitation?
Yes, the transfer was to child exploitation.
Okay. How long had you been in digital forensics prior to being transferred?
Since roughly 2019, so about 5 years.
Okay. And how long, how many cases had you handled in digital forensics prior to that transfer?
I don't recall the exact number.
Okay. Were you the person who did the digital forensics in the Fairfax County Police?
One of them.
How many others are there?
There were 6 at the time, I believe.
And now when you were transferred out, this was in the middle of the investigation of this case, correct?
I don't know if I would classify it as the middle or where it was.
It was during the pendency of this case.
Yes, this case was still going on.
Okay. And in your capacity as digital forensics examiner, I'm going to ask you to look at a document. Okay, do you see anything on the screen?
Just your screensaver.
Okay.
The screensaver. Oh no. What his computer screen looks like right now.
My apologies, Judge.
That's all right.
Right, this is his time to shine. Let's go. Contempt
Sir, can
of
you see
court.
that on the screen?
Yes, sir, I can.
Okay. Do you recognize that?
I do.
Okay, and what is that?
That is an executive summary.
And this is an executive summary that you wrote as digital forensic examiner for the Fairfax County Police?
Yes.
Did you want to mark that as a?
Yes, Your Honor. 85, please. Offense
85 for the
85.
record? Just thank you.
And sir, this is your personal digital forensics executive summary, is that right?
I created this document, yes.
Okay. And now, in arriving at these conclusions, this was related to your work as a digital forensic examiner, correct?
Yes.
Okay. Your Honor, I move this in as Defense Exhibit 85.
Any objection?
Yes, Judge. At this point in time, I think this would qualify as an expert report. This witness has not been qualified as an expert, nor has any foundation been laid for the report.
Okay, so foundation is the objection, so I'll sustain that objection if you want to lay.
I can do that.
Sure.
So, sir, tell me about your experience in digital forensics.
In what regard?
From the moment you got into digital forensics, what kind of training did you have?
I've received training in a variety of forensic tools and training specific to computer systems, specifically the International Association of Computer Investigative Specialists, IASIS. I've also been trained with Cellbrite and I'm current in both of those certifications and training with Magnet and X-Ways and various other forensics platforms.
Okay. And did you receive additional training beyond that within the Fairfax County Police?
I'm also certified for BERLA, which is the vehicle forensics. Various other trainings at different times.
Have you ever been qualified as a witness in the courts of Fairfax County?
Judge, I
I mean,
object to the question.
qualified as an expert, I'm sorry.
Yes, I have.
Okay, how many times?
2 that come to mind.
Okay, and was that in your capacity when you were a digital forensic investigator?
Yes.
Okay. Your Honor, I move Detective Miller in as an expert in digital forensics.
Any objection?
No objection.
All right, so moved.
All right.
Now, sir, is this report the report that you created?
Yes, I wrote this.
And when
Asked
was
and
this
answered.
report created?
I don't recall the exact date.
Okay. Was it prior to October 25th, 2024?
I don't recall exactly, but that sounds about the right time frame.
Okay. And that's a significant date because that was the, if I can remind you, the first recant for Juliana Perez Magalhaes. Does that give you a better idea of when this would have been done?
If memory serves, this was done prior to that.
Okay, that's all we can rely on is your memory. And Your Honor, I don't have any further questions.
All right. You have cross-examination.
I mean, Judge, I would note that, no, I have no questions at this
Okay.
time.
All right.
Those are all the questions, Judge.
Is this witness subject to recall?
Yes.
Okay, so since you're subject to recall, you cannot discuss your testimony with anybody. You do not
think
need
we
to
have
stay
another
here today, but
witness.
just be on call for that, okay? And you're still subject to the rule of witnesses, okay?
Yes, Your Honor.
All right, thank you. All right, your next witness?
Harry Lidsky.
I think this is going to be the guy from the university. Now, guys, the reason I think this is happening is I think this officer might still be afraid of his job position. So there's been others that have looked through the same forensic information and come to the same conclusion. And now that this report, this executive summary is admitted, you can, it's in evidence. So I think he's going to have someone else testify to this information.
Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
This is the guy that's been waiting. He's been in the court like every day, I think.
Sir, can you please state your name and spell it for the court reporter?
Harry Lidsky, Harry, LID as in David, SKY.
And how are you currently employed?
I'm currently a private investigator and digital forensic examiner, self-employed at my company, 4DIS.
Okay. And how long, what's your background in terms of digital investigations and investigations?
Here we go.
Prior to starting my own company, 4DIS, I retired after 20 years in federal law enforcement, 7 years with the DEA, the Drug Enforcement Administration, the remaining 13 years with the U.S. Department of Justice, Office of the Inspector General. For the last 11 of those 13, I was in the Cyber Investigations Office, where I progressed as a senior special agent to the assistant special agent in charge and retired as the special agent in charge of that office. The Cyber Investigations Office handles, as the name would imply, digital forensic examinations. We're responsible for supporting the entire agency nationwide with mobile and computer forensics, basically anything with an on-off button, anything that was electronic in nature, is where we came, our services were brought to bear. On top of that, we ran our own investigations, those specifically which were digital forensics centric.
And in terms of issues, have you ever heard of catfishing?
Yes, I have.
Please define it correctly.
Investigations where it's alleged or it's found to be catfishing?
Yes, I have.
So do you understand the elements necessary for catfishing?
I do.
Describe for the ladies and gentlemen of the jury what that exactly is.
It's a form of misattribution in terms of who's performing what activity. So at its core, it's somebody pretending to be somebody else, usually designed to lure somebody else to do something. It can be employed in a scheme to defraud. It can be employed to get somebody to show up to get them in trouble, to get somebody to show up to an event they had not intended to show up at, to misdirect somebody to show up for something, a case that I worked, it was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike this particular case. And in fact, they were there to serve a different purpose, to be set up as a victim, as a utility or a tool in that particular investigation.
So in that particular investigation, was that from the prosecution side or the defense side?
That's when I was a criminal investigator, a federal agent for the Department of Justice.
Okay. Now, in terms of your investigative experience, even beyond digital forensics, can you tell the ladies and gentlemen of the jury what kind of experience and what kind of responsibility you had while being a federal investigator?
Well, in addition to the digital forensics, again, 7 years with the DEA, it was drug law enforcement, pretty straightforward, what you'd think, what you'd expect, I guess, between the street level version of it, domestically, always working our way up towards the source, back to the cartel sources and usually overseas. But through that, I gained experience with interviewing witnesses, interrogation of subjects, obviously arrest tactics and things along those lines. But there was also a strong money laundering component involved with that. There was surveillance skills were heavily employed during my time with DEA. I did a lot of undercover work with DEA. At the DOJ OIG, the Department of Justice's Office, the Inspector General, we were the watchdog for the Department of Justice. So we investigated both administrative and criminal waste, fraud, abuse type misconduct that occurred within the Department of Justice, that is, employees of the Department of Justice, or also from external actors affecting the business of the Department of Justice. And through that, we did a fair amount of investigations, to the extent that makes sense. There was a number of high-profile investigations. Fast and Furious might be one of those, where our investigation was aimed at the investigation or the operation conducted by the ATF in that particular instance. And we would often find, we would make assessments, recommendations, and even punishment recommendations for employees that acted either out of malice, ignored or abused policy, whether they engaged in misconduct inadvertently or maliciously. Those were the type of findings we would have. So if we found that an investigator failed to adhere to policy, we might have a finding. If we find an investigator lied to us, or in an investigation, somebody within the purview lied to us, we would find they lacked candor. So we, our reports, our investigations resulted in terminations of employees. Sometimes they were.
Judge, at this point in time, I think we've launched into a narrative that is not responsive to the question, nor is it relevant.
All right, if you want to ask the next question.
Well,
continue on that.
It was a question about your investigative background, so please continue.
Yeah, so that was the gist of what we did. So it's pretty broad spectrum of investigative experience. That added component from the OIG of having the investigative oversight and being the watchdog to include over investigations and other police officers, other federal agents, other prosecutors, was a nuanced twist, I suppose, in my experience there. In addition, there was the more traditional, straightforward investigations we conducted to include everything from white collar, bribery, catfishing, international money laundering, conspiracies, and the normal type of white collar crime.
And in terms of your investigating the investigation, you were actually dealing with law enforcement people who came.
Objection leading.
All right.
Explain what you did in terms of the investigation of the investigations.
Sure. DOJ is huge, the biggest law firm in the world, as we like to say. DOJ includes the FBI, the DEA, the ATF. U.S. Marshal Service, Bureau of Prisons, U.S. Attorney's Offices, Interpol, and about 40 other smaller components, tax division, civil rights division. So we're a massive agency far and wide. So we were made up of federal agents, FBI, DEA, ATF, and the Marshals. But we were also made up of attorneys. We were made up of auditors. We were made up of all sorts of employees. We had IT employees engaged in inappropriate network activity where they were reading other employees' emails improperly and illegally. So whenever somebody was accused of misconduct, whenever an allegation of misconduct came our way, we would take that on. So it can take all forms.
Now, going back to the digital forensics investigations, you indicated you were there for 11 years?
Yes, sir.
Okay. And during that period of time, were you ever qualified as an expert in the court of law?
Yes, I have been.
Okay. How many times?
I say 3 or 4 at the federal level, and once since retirement here in the Commonwealth.
Okay. Your Honor, I'd move Mr. Lidsky in as an expert in the fields of digital forensics and general investigation.
All right.
Judge, I'm not familiar with general investigation as an expert field, but certainly digital forensics we would accept.
I'll move him in as for digital forensics expert.
Yes.
Okay.
Sir, you became involved with the Banfield case. What was the first thing that you did when you started reviewing evidence?
The first part of my evidentiary review focused on the digital forensics. I was provided with a rather large, volume-wise hard drive, 8 terabytes, I believe.
And the digital forensics, and I guess, Your Honor, I would just state that the digital forensics that are the foundation have all been stipulated to in the stipulation document in terms of
In terms of a report or digital?
In terms of the data that was taken from the devices.
Yes, Your Honor. We have stipulated that the raw data pulled from the devices does not need to have a chain of custody or foundation.
So he can talk about the raw data from the devices. Okay.
Yes. And so, sir, what's the first step in your analysis of digital forensics when you get involved in the case?
Well, in this particular case, it was atypical because I didn't have to perform any of the acquisition phase of it. Detective Miller had already performed all of the digital forensic acquisition. So what I was provided was generally the derivative elements of his work, which allowed me to just jump right in and review the various artifacts. When I'm performing a digital forensic exam that's derivative of somebody else's work, I make it a point not to review their findings. The reason being, digital forensics is somewhat analogous to solving a big math problem. So to perform it accurately, or at least the way I like to perform it accurately, I like to do the work myself, see what answer I come up with before I see the answers of somebody else's work. Digital forensics is a science such that we're all trained similarly. We all take the same training. We all operate the same way. If we perform our actions as we should under the guise of best practices, we should do the same thing, each one of us, and come up with the same results. Digital forensics is repeatable. Digital forensics, it should be, it's binary. The data is the data. It's not subject to interpretation. It's not subjective. So what you see is what you get. There are nuances in understanding it and what it means. Assigning attribution is a different phase of it, but and we'll eventually get past this boring stuff and see some of it. It does reveal what's going on behind the screen, typically on either a phone or a computer.
Now, in terms of the digital forensics in this case, how do you arrive at certain conclusions?
So Digital forensics, like most of the forensics, and we've heard a fair amount here so far in this trial, it's supportive. It can be informative. You can draw certain conclusions, but they're based upon the results of the digital forensic analysis and its impact on other items of evidence or other items of investigative nature. And what I mean by that is, for example, if somebody says, if we're investigating a crime that took place in Boston, and somebody says, I have an alibi, I was in Miami, and I look at their phone and there are artifacts that reveal location information in Miami, that is an informative piece that says this individual, based on their phone, might have been in Miami at the time. Now, phones can travel without, are traveling with them. So was the phone there? Was the person there with the phone? So that's a lead, that's a pointer. The follow-up to that would be, okay, do we have airline records? Do we have video surveillance from an airport? Do we have video surveillance from a hotel in Miami? Do we have credit card transactions from a restaurant in Miami? Other indicia of location. So digital forensics is informative. I guess if there's enough digital forensic pointers that can, I think pass a test, then it can be conclusory as well, and we can draw conclusions from it.
And in your example of something in Miami, when you arrive at a certain number of artifacts that say the person's in Miami, is that it?
It can be. That's probably a bad example in terms of being conclusory. If somebody says, there's no pictures of a red sports car on my phone, and I find 100 pictures of Ferraris that are red, that's conclusory to say that the witness information or the interview subject information that they provided to the investigator, whether it was me or somebody else, is clearly wrong. Now, that doesn't get to whether they misremembered, whether those photos are old, whether they were taken by somebody else. So there's still an attribution aspect, but it can be conclusory or informative in that regard.
Okay. Now, in the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at, after things had developed. The theory had already been assigned. Catfishing was already, Mr. Banfield had been charged already, and indicted under a catfishing theory when I was brought in. So that was my immediate focus. So confirm or refute that theory. As an investigator, whether I'm in my law enforcement capacity or now in my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So for me, just because I'm hired or asked to investigate one particular theory, it doesn't mean...
Judge, I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
You don't answer your question.
Sir, in terms of what you did when you started this investigation into Christine Banfield's devices, what did you do?
So I started evaluating the devices, but at the same time, I reviewed other evidence that was available to me provided in the discovery. That would include witness interviews. That would include subject or co-defendant interviews. That would include social media type event like email, Instagram, Facebook, things of that, WhatsApp. So it's not all a device centric. It can be evidence provided by a service provider like Google or Apple. I reviewed all the photos from the crime scenes, the autopsies, the digital, the forensic science and Office of Medical Examiner. I reviewed all of the facts available to me. The best way to perform what I do is through all source
Judge,
analysis.
objection, non-responsive.
I sustain the objection.
Okay. So in terms of the items that you were just telling the jury that you review, Did there come a time where you were reviewing and were able to arrive at conclusions?
Yes, I was.
Okay. And specifically, what date range or what period of time were you looking at?
So the window of time was from January 9th, 2023, specifically with regard to the catfishing, was from January 9th, 2023, obviously through the time of the event on February 24th, 2023. It did extend back a little bit further. For example, the discussion about the windows, that dated back prior to January 9th. There was witness testimony or subject interview, transcript information about planning that predated January 9th. So I don't just look at it at a time for digital forensics. It's important to look backwards for a certain relevant period to ensure that,
Objection, non-responsive.
Sustain the objection.
Why would you look backward in a digital forensic analysis?
You know, a single artifact, as we refer to them in digital forensics, it may not be informative, right? A single text message on this day may lack the context, but the 50 prior exchanges might help that context, right? That's relatable, and the communication after that might also help inform. So it's important to look backwards. It's also important to look forwards in digital forensics. And when we're talking about, in this case, the allegation of a conspiracy that lasted a period of months, I find from an investigative perspective that it's important to look at everything. Digital forensics, like any, I think, informative piece of evidence.
Objection, non-responsive.
Sustain the objection.
In the context of certain behaviors that come up through the investigative process, like, for example, when someone may have had their phone and their laptop and when someone would have been away from that, are those things that you look at?
Especially for events like that, what was happening immediately before the event is vital in determining attribution or who might have been performing what activity on a device.
Or in saying in another way, would there be...
Objection, leading.
I haven't heard the question yet.
What would you do if there was a pattern of time that needed to be analyzed, or a time of day, or a certain day? How would you go about doing that?
Well, with the digital forensic tools that we have, the software that we have, we're able to visualize things in a timeline fashion. So I'm able to look at, or folks in my profession are able to look at what happened, both what the user was doing and what the system was registering, the computer system. So we're able to generally create a granular timeline that helps inform a decision or conclusion about whether a device might have been removed, from one person and used by another.
Okay. Now, can you see the document that's on your screen?
I see Detective Miller's executive summary.
Here we go, Aaron. Where's Adventure Aaron?
Have you had an opportunity to review that?
I have.
Your Honor, can that be published to the jury?
It was not admitted into evidence.
Here we
I'd
go.
move it into evidence. As
Objection,
Exhibit
Judge. It's a
85.
hearsay document at this time.
I'll
There you
sustain
go,
the
Aaron.
objection at this time.
Detective Miller testified to it.
If you want to approach.
So Aaron had noticed this. I had it up on the screen. So they had moved to qualify Miller as an expert, but then never came back around after the objection to the report to get the exhibit itself. 80, what is it? I wrote it down in here. 85? Yeah, 85. Admitted. But the problem is...
So I'll sustain the objection.
Uh-oh. This, to me, would be a huge ineffective assistance of counsel claim. So, I mean...
Mr. Lidsky, I'm going to go to... Sorry.
And no, he wasn't subject to recall. But I don't know why the state would want this, because like this seems like huge on the appeal. So John Carroll wanted this witness to talk about the report, but failed to actually get Defense Exhibit 85, the executive report from Detective Brendan Miller, admitted into evidence.
Can you see something on your screen there, sir?
Wait, so
Okay.
everybody's saying he was subject to recall? I said no. I thought he said no.
There's evidence in this case regarding window replacement that was communicated by Juliana Perez Magalhaes. Do you remember that?
I do.
Did you do a digital examination? Did you do a digital examination as to the allegations that she made with regard to window replacement?
I performed searches relating to that particular topic. I'm able to perform keyword searches as one of the search criteria. So I did perform searches related to that particular part of testimony, yes.
So he is subject to recall.
And was this part of the information that you'd received from our discovery and the data that came from the devices?
So here's my call. He's going to go through other topics that he can talk about today and might not have wanted to go into in this order and finish off the day. And then tomorrow we might see Brendan back on the stand, and then we'll get this guy back on the stand to talk about whatever's in the report and relevance. So I think that's what we're going to see, because, you know, Penny likes to keep things moving.
Yes, it is.
Okay. I'm going to have you look at the document that's on your screen.
This could evoke sympathy for the defendant,
right,
too. Like, their
identify this as
counsel's bumbling.
Exhibit 86.
All right.
Can you look at Defense Exhibit 86 and explain what we're looking at here?
Judge, I'm going to object to any statements regarding what's contained in the document.
Are you moving it into evidence, Mr. Carroll?
Yes, sure.
Any objection?
Yes, I would object to foundation. We have not been given any information about this
Sustain as
document.
to foundation, if you want to lay a foundation.
Sir, how did you find these documents, and what processes did you use in order to find this information?
So based on the derivative evidence provided to me in discovery on this case, I analyzed this particular one. This came from Ms. Banfield's cell phone.
Judge, I'm going to object to that conclusion. Again, there's been no foundation laid, and we can approach and I can explain further.
There you want to approach.
Oh, boy. Yeah, this is a former prosecutor. John Carroll is a former prosecutor. And yep, thank you guys for all the verification that Brendan Miller is subject to recall. So, and again, I do think that he's probably going to try to fill out the rest of the afternoon with other topics and try to get Brendan Miller back in first thing in the morning. This is super struggle bus.
Sir, what was the raw data that you used in order to get this, and what system did you use to arrive at this?
This was from an Axiom portable case created by Detective Miller. An Axiom portable case is a derivative product from Magnet Axiom for digital forensic software, which performs mobile and computer device review, or facilitates mobile and computer device review and cloud review and all things digital. So the software is baked in. It's an executable program that comes from the main Magnet program. So Magnet permits digital forensic examiners in this case Detective Miller, to create a derivative subset of his work that that is able to be open on any Windows computer. So you don't need to have a software platform. It is a software platform.
And if you can tell the ladies and gentlemen of the juror, or Your Honor, we move that in as Cummels or defense
If we could approach, please.
Oh my gosh, here we go. Yeah, they need to qualify this guy as an expert, finish, then bring Brendan back in, get the report, and then bring this guy back. And yes, it's going to look unhinged. But for what it's worth, I think if the jury thinks that this guy is a bumbling buffoon, I don't know. And if this doesn't get sorted out, like say the trial just moves on without this report coming in, that just screams ineffective assistance of counsel to me. So, I mean, if the state wants a conviction to stand the test of time, I guess they don't care about something being on appeal because it buys them some years. Worst case scenario, they have to do a retrial. Whoop-de-doo. They're not the ones that really lose their own resources or run out of their own resources. I know, Dizzy. I love digital data. Just want to get to the good stuff. Yeah, and I think we're seeing the difference. No resources from the DA's office. Well, I love watching even though we can't hear. I feel like I can tell like the vibe of what's going on. Well, interesting. So, on Lawyer You Know, Peter Trago said on his show that he was told Brendan will be testifying. Well, if this stuff can't come in, he might have to for sure. Also, this guy whose name is M Queen staring at the back of Brendan's head is kind of ironic and iconic. God, tomorrow's gonna be a time, isn't it? We might have the chaos of trying to get this report admitted. Brendan might take the stand. And remember, tomorrow's like this court's Friday because they don't do Friday court. It's a long one. I think this is the longest sidebar so far, right?
All right. So the objection is sustained.
Sir, did you work with the raw data that was provided by the Fairfax County Police?
Just
through
gotta raw
search
dog
warrants
it.
and other providers, things like that?
For search provider, for service providers, yes. The records I had were responsive from Google, Apple, Facebook, and Instagram, FetLife, and others, Discord. For the computer and mobile devices, I was not provided the raw data. I was provided the derivative work, the portable cases, the Celebrate readers, which to my understanding, is the complete device. Nothing is filtered out, but I wouldn't characterize it as raw data.
Your Honor, may I just request a 10-minute recess?
We want to do our afternoon recess? We can do that.
Yes.
Okay,
Oh my
let's go ahead and take
goodness.
our afternoon recess for 15 minutes, ladies and gentlemen. And we will get right back to you. Again, don't do any outside research.
Please say it's because Brendan Miller just got back in here or something. What are we doing? What are we doing? Whisper, whisper, whisper.
Yeah. Correct.
Oh.
All right. Sir, since you are in the middle of your testimony, you can't discuss your testimony with anybody to include the defense at this point, okay?
Of course, thank you.
All right, we'll be back at 3:15. All rise, please.
Oh, what a day. We'll time travel a little bit. Yeah, this is how this attorney's feeling right now down here on the seal. All right, so we are caught up in real time. Guys, that's all I've got. My commentary is just, this is a mess. I might need the assistance here with my favorite header, my new favorite header. Just a time. Just a time. This is all I wanted. I am so let down. This is the evidence I wanted to hear. And I was so excited. Oh my goodness. What a mess. A waste of the day. Yeah, please let this be because Brendan is back. I don't know. I hope so, but also maybe he just needed that 10 minutes to collect himself because we kind of got everything else sustained. All right, the raw data. Let's see. Yeah, was he on Discord? Guilty. Speaking of Discord, if you guys want to join the Discord, chat with us. Let me drop a link in the chat. We have fun over there. Trenton keeps us busy with plenty of memes. Aaron is doing great work on Canva. Bringing true courtroom moments to life. All right, so there is a Discord link in the chat. If you aren't already in there and you use Discord, please feel free to join us. If you're new to Discord and you're afraid of using it and think you don't understand how to use it, that's okay. That's like 75% of us in our Discord server. So just come on in and figure it out together. We'll be better at it than this defense is doing with the critical evidence in their case. You will not be worse at Discord than we are with the handling of this critical evidence here. So, yeah, ultimately he needs a paralegal. Needs somebody else on this case. Oh, I mean, the question, why doesn't the CW want the data in? I mean, I think that's an obvious answer for me. But the problem now is it's gonna be so convoluted. It's gonna be so far detached that this was their own person. This was their detective that initially did all of this work on the digital forensics and came to the conclusion, what we're supposed to be hearing is that Detective Miller came to the conclusion that Christine never lost control of her accounts and that it was Christine having the communications with Joseph Ryan and not Brennan Banfield and quite frankly not Juliana either. So yeah, and good point. Miss Good Janet Demeanor says, to be fair, I know how difficult it is to run a live stream. I can't imagine standing in a courtroom in front of live people trying to think on the jump. Same. And you probably can't just do the old, like, it's lagging, which is what I do when something's going wrong. So, yeah, get it. Just get the witness on the stand to help you with your tech problems. Yes, good notation here from Aaron. Says, Adam Abate, you are not invited to the Discord. He would be so, like, into the tea. I don't really think we have tea in the Discord, but if we did, he would be the source and the guy to go for it. Let's see. And my salad was really good, you guys. That's why I was off screen for so long. I take a while to eat salads. Very different than a cheese sandwich, which is like just a couple bites. Easy to eat. And yeah, so Moxie says, weird question, but when a case brings ineffective assistance of counsel, does it go against the lawyer's work history and follow them legally? I mean, it might if they do something ridiculous and it's something that people become aware of. But I would say I think it's kind of a good thing when an attorney is an advocate for their client and knows that something at trial got in the way of a constitutionally fair trial and, constitutionally competent representation. And you can have an attorney that does very great work in like 99.9% of what they do on a case, but if they mess up on a critical issue, then that could still be ineffective assistance of counsel. An IAC claim isn't necessarily like, bro, your attorney is ass cheeks. It could just be, hey, they made a critical misstep, and that deprived my client of a right to a fair trial. So, I mean, maybe if the issue was like the defense attorney was binging, they never showed up, they didn't even go to court, like they were rude, like maybe that's something you don't want to hire that attorney. But if it's just something like, hey, they were under-resourced and forgot to raise an issue or forgot to challenge an expert witness, sometimes that's an issue of pragmatics and not like a personality trait or flaw of that attorney individually. So, all right. So, lawyer, this tidbit, and thank you for going back and looking on episode 67 about day 4 of, referring to day 4 of this trial at the 11-minute, 10-second mark. So, yeah, I mean, I would love to watch the defendant take the stand, even if I might say like, oh, I think it'd be a bad idea for a defendant to take the stand. Do you guys remember who in here watched the Nick Casotis trial? We were like, all right, some of these tools, like the state in that case tacked on a bunch of tools, and can they get all charges? Can they get every single charge to stick? Maybe some of these charges, the jury will be like, you know what, get them on these, but this one we don't really think that there is sufficient evidence. Then we have Nick Casotis take the stand, and any damage, any advocacy that Doug was able to do just goes out the window. Out the window. Oh, and what a time. And, just as a matter of trial watching, that was certainly a trial to watch. Would I want to have been in Doug's shoes? No. No. No, 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 no. I would have liked to be the prosecutor that day. And the way the prosecutor's voice tone would work, like the inflection, the way she would ask questions, kind of just grated me. Like certain things I just have a instinctual reaction to, and that just kind of to me. But I didn't think she did anything like shady. One of the things that made that trial a bit refreshing to watch, it was still in Georgia, but it was Liberty County, right? We're getting away from Fulton. And it was like, I don't think there was shady moves by this prosecutor. I thought that was really refreshing. But again, yep, I'm sure they were very happy to see Nick take the stand. So, yes, I submit that the prosecutor was salivating. Yeah, what was that, like 43 I submit to use in opening statements? Just a lot, just a lot. Maybe Megan, maybe not is definitely green now and says thank you for the gifted membership. Probably came from Sheriff Chuck or EDW Raptor. So big thank you to them. Yeah, Your Honor, my client wishes to testify. Please help. Brooklyn likes the short, fast, and messed up trials. You know what was really funny is right after that trial, we ended up watching the Lawrence Doherty trial for the shooting death of Adrian Payne. And the defense attorney, and in that case too, he takes the stand, and like, I think him taking the stand ruined it for him too. It sealed the deal on his own fate, Lawrence Doherty. But the defense attorney in that case, to demonstrate like the size difference between Lawrence Doherty, his client, the defendant, and Adrian Payne, was an NBA player, brings in this giant, like plain cutout, like a cardboard cutout. And all I could think of is Jim McIntyre. Jim McIntyre. Oh my goodness. So we are still in the defense case in chief. You just missed a cluster F, Sheriff Chuck. So they call Detective Miller, and that's the digital forensics guy that got transferred. We heard about the lateral transfer, which I do think it was an important thing to get in front of the jury. And the state objects to him being qualified when John Carroll, defense attorney, tries to introduce his executive report. So they go through all of this foundation and then move to qualify him as, being qualified, but they don't move the report into evidence. And now there's an issue, because it seemed to me, and I still think, that John Carroll wanted to get Brendan Miller off the stand and have his own private investigator, who's on the stand right now, Mr. Lidsky, testify to this report, because Brendan Miller is still employed by Fairfax County Police Department. He's in another division, another department, but he's still employed there. So he could be nervous about his testimony and whether he'll face retribution or some type of retaliation. Again, especially if he already feels like his first transfer was retaliation for him thinking differently. So it makes sense to me strategically to want to shift, and we have pictures of the judges on the screen. So we're getting the tour here from Court TV. I love this pose. And now that John Carroll, we're back in court, tries to get this exhibit entered for this next witness to talk about, it's pointed out, the judge already knows, and the state's standing up to object, because the report was never actually admitted into evidence. It was never published as an exhibit. So a hot mess. A hot mess. And again, selfishly, it's the thing I wanted to hear the most. So, and hope that was a good summary there for Great Granny 2, who also stepped away. Oh, prosecution looked happy.
All right, ready for the jury?
Yes, ma'am.
Okay.
Yeah, it's weird. There were issues at the other days of the trial where the state wasn't admitting things to the jury. I mean, entering things into evidence the right way either. But I believe Judge Penny actually, is this going to be an exhibit? Oh, sleuthy goosey, we just had a hot mess mistake by the defense attorney, not properly getting evidence admitted and then trying to use the same report with the witness they called after.
All right. See, your next question.
Judge, I don't have any further questions for Mr. Lidsky.
All right.
I would ask to recall him at a later time.
Okay, well, cross-examination?
Not at this time, Your Honor, no, thank you.
Okay. all
There we
right.
go. We're going to fix
Sir,
it.
since you are subject to recall, do not discuss your testimony with anybody, and you may be recalled, okay? But you can have a seat. Thank you.
All right, so we're going to get Brendan
call
Miller back on the
Detective Miller.
stand.
Detective
Yay! We're fixing the problem, chat. This is so crazy.
He was just sworn.
They're going to swear him again or no? Okay, so we initially called Brendan at 4 hours and 22
he's already
minutes in the stream. We are 3 minutes away from an entire hour being devoted to this cycle.
All right. Detective, just a reminder, you're still under oath, okay, sir? All right, thank you.
Detective, can you see the document that you had created? Digital forensic summary? And when you obtained the data in doing your forensic analysis, describe for the ladies and gentlemen of the jury what you do.
Make sure the green button's on there.
Okay, I think it's on now. In obtaining data from a device, the first thing we do is stabilize it, and that method depends on whether it's a mobile device or a computer, whether the device is on or off. So an example of a computer, what I would do is the device, if it's already coming to me in a powered off state, I would remove the hard drive, connect it to a forensic machine with a write blocker. A write blocker is a device that prevents writing to that evidence device. Therefore, no bits are changed, so no zeros, no ones, nothing gets altered. And then I take what's called a forensic image of that and create an evidence file from that, which is then loaded into another forensic tool that will parse that data and create it into a readable format for me as the examiner or anybody else to read down the road.
And would you draw your conclusions that are the conclusions that are on this digital forensics executive summary after doing that through different artifacts?
Yes, I would draw any conclusions off of data that had been obtained from a device.
Okay, and what you just described to the jury is what went into this document, the digital forensic executive summary.
Everything that was used to compile that came from data that had been extracted from the digital devices.
Okay, and specifically relating, and I'm referencing this document, January 9th, that was an important day in terms of who was using devices.
Objection, counsel's testifying.
What's the significance
I'll
of
state the objection. Go ahead.
Yes. What's the significance of January 9th, 2023 in this investigation?
Creation of the account.
That was a date that a Gmail account was created.
Okay, and in your investigation, were you able to determine who created that account?
Who in particular? No.
Yes. Were you able to investigate using your tools to determine artifacts such as such as other lifestyle type matters as to who was home, who could have been there, things like that?
Judge, objection is to form.
If you want to state that question again.
What are the things that, so when you're honing in on who was using a device, what things do you look at?
I would look at a variety of things. Pattern of life would be a term that would be used, but you would explore all that the data has to offer and see if there's enough artifacts there to support or provide enough information as to who may have been using that device. But barring external corroboration, it's impossible to put somebody behind a screen.
Now, in terms of reaching conclusions in digital forensics, you have to make determinations based on a number of factors, correct?
Yes.
Okay. What, if anything, did you do to arrive at the conclusion that
Objection, leading.
on January 9th,
Sir, sustained as to leading.
what, if anything, did you take into consideration in arriving at your conclusion on January 9th, 2023?
For that particular date,
Yes.
I took into account all the information I had at that time as to what was the more likely scenario based on what I had at the time.
Okay. And what was your determination based upon this particular executive summary?
That based on what I had at the time, it indicated that the device owner was using the device.
Okay. Now, you've put in this summary January 17th. Is that a significant date?
Yes.
Okay. What's the significance of that date?
That was another date that an account was created.
And was that the FetLife account?
Yes.
Okay. And what's the relationship, if any, between the Gmail account that was created on January 9th and the FetLife account that was created on January 17th?
The Gmail account that had been created on January 9th was the email account that was used in the creation of the FetLife account.
Okay. And were you able to determine through your expertise who had control of the device, Christine's devices on that day?
I was able to determine that it was her phone involved in creating that device. I was able to determine that it was her phone used in the creation of that account based on a variety of returns.
And did you make any conclusions at that time that she had not given up her devices?
I had nothing indicating loss of dominion and control at that time.
Okay, and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Yes.
When did that change?
A co-defendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
No, the zeros and ones did not change.
Okay, so, and zeros and ones, that's binary, right?
Yes.
So your conclusions based on zeros and ones are still the same?
Yes.
The only additional factor is the co-defendant adopted a different story.
I was provided additional information that had to be taken into account, yes.
Okay, meaning she told the story that she told the other day here?
Yes.
Okay. Were there any other conclusive digital artifacts that were different in the creation of this report other than the co-defendant testifying differently?
I'm sorry, can you ask the question again?
It wasn't a very artfully worded question. Were there any, so we were just talking about digital analysis, the ones and zeros, right?
Mm-hmm.
And that's the thing that you oftentimes work with, correct?
Yes.
And what your testimony was is that the co-defendant's testimony was the thing that changed relating to the January 17th that we were just talking about.
Yes, context is important.
Okay. And was there something other than her accepting other than her telling the story that she told that day, was there anything about the traditional digital forensics that you had analyzed that had changed?
Not that I recall.
Okay. And that was January 17th, correct? Or was it the entire report?
I was speaking to it as an aggregate.
Okay. And did you have an opportunity to be part of the questioning of Juliana Perez Magalhaes?
No, I was not part of that.
Okay. were there items within that interview that was in conflict of your findings in digital forensics?
Objection, foundation.
Are you only a foundation?
Okay.
He wants to
You
ask about
heard
those
the-
5
The
messages.
testimony, correct?
Yes.
And I'm speaking of the first time she told the story on October 25th, 2024. You heard those interviews, correct?
Yes.
Okay. And so my question is, did you see conflict? What, if any, conflict did you see with your digital forensics findings and her statements on that day?
Nothing is immediately coming to mind.
Uh-oh.
Would you have seen her video where she's talking about, where Eric Klingon is asking if anybody was on FetLife on a certain day?
Yes, I've seen that.
And your knowledge of digital forensics, you knew why he was asking that.
Objection, leading.
All right, I'll sustain as the leading.
Did you, in fact, did you have any idea why he asked that question?
I can't speak to why people choose to ask the questions they do in an interview.
In terms of your digital forensics findings, though, did it make sense why he asked that question?
I think it would be relevant information.
Okay. And she didn't answer it correctly, correct?
Objection, leading.
Sustain as the leading.
What, if anything, did she strike that question?
Okay.
After you heard that she had recanted and told this story, did you see an opportunity to be involved in the questioning of her?
I think I know what you mean by that. I would have liked to have been involved, but I was not involved in questioning her at all.
Okay. Looking back on the interview, if you had been involved, could you have assisted them?
I believe so.
Okay, and who were the people that were in the interview room?
Objection, foundation.
Let him answer.
If you want to have a foundation, if he knows.
There were, when she was interviewed, there were a number of detectives in there, correct?
I believe so.
Do you know any of the detectives that were in there?
Yes.
Okay, and did you have an opportunity to talk to them about your ability to assist them in her story?
Prior to that?
Yes.
No, I did not have an
Were
opportunity.
you aware that she was doing that prior to her story?
I was not aware until after it had already taken place.
Okay, so they didn't and were you the digital expert for this case at that time?
Yes.
Okay, so what, if anything, did they do to get information from you to make it a more accurate questioning of Juliana Perez Magalhaes?
I wasn't able to provide them anything because I didn't know what was happening.
Okay, and no one told you that?
Correct.
Okay. The digital forensics, no, so you were transferred, correct?
Yes.
When
Let's
did
talk about
occur?
that.
Roughly a year ago.
Okay, okay, and what you're doing now is a different form of digital forensics?
Objection, asked and answered.
Yep. No, it was asked.
I'm using the same skill sets, yes.
Okay, but you don't get involved in cases like this anymore in digital forensics?
No.
Okay. When you were still within digital forensics, were you ever asked to change your executive summary that we've looked at?
To change it?
Yes.
Uh-oh.
I was asked to review it in light of the proffer.
Okay. Were you ever asked to go line by line and fix the conclusions?
Objection, leading.
What, if anything, were you ever asked regarding your digital forensics
He's not going to
executive
answer that.
summary?
To review it in light of the proffer and ensure I could explain what I had put in that executive summary.
And did you do that?
I reviewed it.
Okay. Was there a change in this document based upon that review?
Like I said, the zeros and ones did not change.
Okay. Is that why you were transferred?
I can't speak to the exact motives behind a transfer.
So
At one point,
Okay.
did you think it was
So you
retaliatory,
were
but you
never
can't
told why
leave?
you were transferred?
There was a discussion about the transfer, yes.
Was it related to your executive summary?
It was related to my work in the Banfield case.
Okay, and your work in the Banfield case.
You
is
did
it
an
fair to
executive
say
summary,
that it
right?
Objection leading.
Was there any other work in the Banfield case other than digital forensics for you?
For me, no.
Okay. So let's go through that document if we can.
I'd stop having sympathy for this guy. I have a client to represent. Like,
Can you still see it?
Yes, sir.
Okay. Looking at the January 18th to until February 23rd discussions in your report. Do you stand by those same conclusions in those bullet points?
As far as the activity of the devices, yes.
Okay, and the ones and the zeros?
Yes.
And so the only thing that changes that section, and I can keep scrolling if you need to see it, is the fact that...
Judge, I'm sorry, can counsel explain where specifically in the document he's referencing?
The section of January 18th until February 23rd, 2023. Should be on the screen. I scrolled up to it.
Judge, I see a section titled 1219 to 224.
At the very top of the screen, he has the dates.
I see. Thank you.
Okay.
I was just trying to include that whole
That's
section.
fine. I think she was just looking on her laptop, too.
Okay. Is there anything of the ones and zeros, the binary language, that's changed in that portion of this summary?
No, the data extractions remain the same.
Okay. So the only change is that the co-defendant gave a different story.
Additional evidence came to light, yes.
Is that the additional evidence?
Yes.
Okay. Do you see the section that says February 18th, 2023?
Yes.
It says starting at 22:44 hours, Christine utilized her
Judge, I'm going to
CB.
object to reading from the document. He can question the
All
witness.
right, I'll sustain the objection.
Okay, do you, that statement that I was just starting to read, is that still the same?
As far as what the device was doing or the account was doing, yes.
Okay. And the only change that would change that would be that Juliana Perez Magalhaes changed her story.
Yes.
Okay. Let's look at February 19th, 2023. Have you read those 3 bullet points?
Yes.
Okay. And same question. Is there anything that has changed regarding the ones and zeros, as we talked about, in that section?
No, the data remains the same.
Data remains the same. And have you ever heard the term digital forensics don't lie, people lie?
I've heard it.
Have you ever heard it?
Yes.
Okay. Now, talking about February 19th, the only thing that's changed is Juliana Perez Magalhaes has changed her story, correct?
Pause.
Yes, the data remains the same.
Data remains the same.
He didn't want to.
2023, February 19th, until February 24th, 2023. This references Telegram communications. Do those items remain the same?
Yes, the data did not change.
Okay, so I don't want to put words in your mouth, but pretty much everything is the data hasn't changed, correct?
Correct. Context did.
Context, and the context is in the form of recantation of Juliana Perez Magalhaes.
Yes.
Okay. And your conclusion? Same thing?
Yes, sir, the data still hasn't changed.
Okay, and that hasn't changed except for the recant of Juliana Perez Magalhaes.
Yes.
Is that correct?
Yes.
So you were asked by the person that transferred you to go line by line and change your...
Objection calls for hearsay.
I'll sustain the objection if you want to rephrase.
Who were you asked to change your executive summary by?
Again, I don't believe I was asked to change it. I was asked to review it in light of the proffer.
Okay, and so when you reviewed it in light of for the proffer, was there ever another executive summary created after that?
No, I did not create another document.
Okay,
So you
so you
changed
just
it.
reviewed it as you were asked to do?
Correct.
But there's no actual executive summary like you did in this situation?
Correct. I did not create another document.
So at the end of the day, all of this again hinges on Juliana's credibility. I don't think the state delivered what they said with their blood spatter. I think the defense is struggling with what they said that they were going to show with the digital forensics, but I guess we'll see with Lidsky called back.
Other than listening to the interviews that Juliana Perez Magalhaes gave, did you ever deal with her directly?
No, I had Only when I got her phone from her when she was arrested.
Okay. So is it fair to say that you were never in a position to challenge any of the things she said?
I conducted no interviews with her. That's correct.
Were you able to observe whether she was ever challenged on any of the things she said?
Only with the interviews that have been recorded.
Okay. And do you believe that she was challenged on what she was said?
Objection, I'm not sure that that is relevant. His belief.
I'll overrule as to relevance.
Raise a
I'm
different
sorry,
basis.
could you ask the question again?
Do you believe she was challenged in those interviews?
I think that's a relative term. I can't speak to what the person asking the questions was thinking at the time.
Let me see if I can get us to a point where we're understanding each other. As an investigator, if you think that something may not be right, whether it's based on digital forensics or anything, you challenge them, correct?
Yes.
Okay. And that's what you would do if you were in a situation where you were interviewing based upon your work, correct?
My questions would have likely been different, but I can't speak to why somebody would ask what they would ask in an interview they're conducting.
So if somebody says something, generally, if somebody says something that's wrong, you don't challenge them?
I think I would.
Okay. In watching those interviews, were they ever challenged? Was she ever challenged?
Judge, objection calls for speculation. Again, he's testified already that he doesn't know what was in their minds when they were asking questions.
Speculation.
Well, I'm asking him about his review of the videos. It's not, it's essentially, it's his.
I'll overrule the objection. Go ahead. If you can answer.
Yeah. Re-ask the question, sir, please.
Watching the interviews of her recant, you weren't there, correct?
Yes, I was not there.
Did you think that she was challenged when she gave the story that she gave?
It appeared to be more of a free-form interview. I did not see direct confrontation on things in that interview.
Okay. And when you say free form, you mean she was just able to tell what she wanted to?
Well, they were going through the details.
Okay, so she was asked about a detail, and then she was able to give a story?
Pretty much it was a question and answer format.
Okay. And I guess my question is, I use the term challenge. Were there people questioning what she was saying?
In light of?
Any of the topics?
I don't remember anything specifically.
Okay. What were your conclusions in your executive summary that you wrote before?
All right, is he going to ask to move it in? This is the time. Here we go.
That based on the digital evidence I had at the time and the facts known at the time, it indicated that the device owner was responsible for the activity on the device.
And that device owner?
Christine Banfield.
I have no further questions.
Cross-examination.
Thank you.
Let me just put this down. Or do you need it?
Or just put it down. It's fine.
Did we not admit the thing? Did I miss it?
Good afternoon, Detective Miller.
Afternoon.
All right, so you stated barring external corroboration, it's impossible to put someone behind a screen. Isn't that correct?
There needs to be corroboration of some sort, yes.
All right, and in this case, when you dug into Christine's phone, Christine's laptop, the information that you received from the external sources, Google, Apple, were you able to put someone concretely behind the screen?
At times, yes.
But throughout the context of all of the conversations that you saw occurring, the activity that you saw occurring on Christine's phone, could you conclusively opine as to who was behind the screen?
No.
Okay. And when you wrote this report that Mr. Carroll has referenced, you used the phrasing, Christine did this, Christine did that. Is that correct?
Yes.
Okay. And after additional information and further investigation, you would have changed that to Christine's phone or Christine's laptop. Is that correct?
Correct.
Because again, you can't put someone behind the screen in this case, can you?
It sounds like a
Not for
defense
everything,
attorney
correct.
argument.
Okay. The evidence itself did not change, correct?
Correct. The data did not change.
You did not change the evidence, correct?
No, I did not change the evidence.
You reviewed how many terabytes of data in this case?
A lot.
A lot, okay. And in all of that, there was no ability to reach a conclusion that one person was always operating on FetLife, was always operating on Christine's phone when interacting with the Google account that was created to manipulate the FetLife account. Is that correct?
Correct.
All right. There are no artifacts contrary to Juliana Perez Magalhaes' statements regarding the creation of the account, are there?
Not that are coming to mind, no.
And the only changes that you would have made here is, again, to clarify that there are points at which you cannot tell who is operating the device.
Yes, I would have clarified. It's very difficult to speak about devices constantly saying this person's device, that person's device. I did it with Joseph Ryan's devices, Brendan Banfield's devices, Juliana's devices all throughout. I just called it the person who owned the device using.
All right, so in this case, I got louder. The digital forensics may not lie, but they didn't provide us with any conclusive evidence of who was operating Christine's phone when the Google account used in conjunction with the FetLife account was created.
Correct.
Okay. You were also asked about your review of Juliana Perez Magalhaes' original proffer that occurred on October 25th. Is that correct?
Yes.
Okay. Were you aware that there was another interview with Juliana that occurred in February?
Yes.
Okay. And did you receive information from watching the October proffer about what was going on in the room between the detectives and the attorneys that were present? Did anyone show you the notes that were passed? Have you had the opportunity to talk to those individuals about what they might have whispered about when they stepped out of the room?
Compound question.
I did not discuss that with anybody.
Okay, so you have no idea what, if anything, went into the questions that she was asked and whether or not there was effort made to confirm that her story had additional corroboration, do you?
Correct.
Okay. Judge, I don't believe I have any other questions. Thank you so much.
Enter the report.
Sir, do you know why you as the expert,
Wait till you get to the microphone, please.
do you know why you as the expert in digital forensics was not called in the Commonwealth's case?
Oh.
I don't.
Were you ever told anything about that?
Objection calls for hearsay?
Overruled.
No. Were you ever? Not what was said.
I just know that they were not advertising it, that they were having the proffer at that time. I found out afterwards it had already taken place.
No, I'm
Wrong
talking
question.
about for the trial, for this trial.
I'm sorry, ask your question again then.
So it started with, do you know why you weren't called when you were the expert in digital forensics for this case?
Again, I can't speak to somebody's motivation for not including me.
Okay. It's not a hard question to say when you're not watching someone on a device to say digital forensics can't conclusively determine who it is behind the device, correct?
Can you ask it again, please, sir?
Sure. It's not a hard question to ask someone like yourself, you don't know 100% who's behind that device. Isn't that correct?
Objection leading?
I'll sustain as to leading if you want to ask.
What is the likelihood of being able to say someone is using their device with 100% certainty without seeing the person?
Well, that's difficult to do.
Okay. And that's one of the reasons why digital forensics is a valuable tool, correct?
Objection, counsel's testifying.
Overruled, if you can answer.
Yes.
And it's because of, well, the factors that you've described for the ladies and gentlemen of the jury. That's how you arrive at conclusions, correct?
Yes.
But they're not, how many times that you've arrived at successful conclusions where you were 100% certain the person who was behind the device?
I would say only in circumstances where somebody admitted that they were using the device.
Okay. Or you had a camera on them or something like that?
Correct, some kind of corroborative factor.
Okay. Do you have any idea why you were excluded from any of these meetings regarding the Juliana's recant?
I can't speak to people's motives to not including me.
Okay. Was there anyone else who was covering the digital forensics arena in your stead?
In general or for a meeting in particular?
For this case.
No, I was pretty much the one who did the analysis.
So you were the expert?
Yes.
And who would rely upon your expertise in the ongoing investigation?
The lead detectives.
Okay. And are you talking about Detective Bryant?
Yes.
And Detective Goodell?
Yes.
Okay. And what was the flow of information as you found digital forensics? Did you give it to them?
Yes, everything that I processed was ultimately provided directly to Kyle Bryant and other detectives involved in the case.
And did you ever, so I'm asking in the context of like a math equation.
Oh, no.
Did you ever show your
no.
work, or did you just show your conclusions?
I went through the artifacts with the detectives.
Okay, and that would be Kyle Bryant
Yes.
and Tom Goodell?
We're going to
Yeah.
call Bryant and Goodell to
Any
the
other
stand.
detectives?
There were a lot of people in meetings.
Okay,
about
so they
this
were,
case.
okay, so you're talking about meetings, but did you ever go in and just talk to them in a granular level as to why you arrived at the conclusions you arrived at?
Yes.
And how often would that happen?
There were multiple occasions that I got to a granular level.
Okay. What about the command staff? Did you ever get into the granular level with the command staff on the digital forensics?
There were multiple meetings where command staff was present, and I outlined why I came to the conclusions I came to. But as far as sitting down and going over every artifact, no.
Okay. And would you have been invited to do that by the command staff?
Objection calls for speculation.
I'll sustain that.
Were
Were you ever invited to come in and give the granular details, no matter who they were?
I don't recall providing granular details to command staff.
Okay. In granular, we're talking about to the nitty gritty, right?
Oh my
Just so
God.
we're using the same terms.
Judge, objection is to form. I'm not sure how nitty-gritty is different from granular.
I'll sustain that objection.
How would you describe granular in the way we're talking about it?
Painstaking detail, like getting into why that artifact is the way it is, how it came to be there, going through that way. So some of them were down to that level, but not the entirety of the case, no.
Okay. And when you say some of, you're speaking to the people when you say some of them?
Yeah, there were different times throughout this investigation where I would sit down with various different people, and depending on what was desired, I would go through exactly how I arrived where I was. Some people wanted overview, some people wanted to see down to the detail.
Okay.
All right, is this witness subject?
Oh, so, sorry. Court TV did that thing where it refreshes. So let's go back and make sure we didn't miss anything.
Other detectives involved in the case.
Did you ever show your work, or did you just show your conclusions?
I went through the artifacts with the detectives.
Okay.
Oh my gosh.
So
I'm pulling a John Carroll.
I'm asking in the context of like a math equation. Did you ever show your work, or did you just show your conclusions?
I went through the artifacts with the detectives.
Okay, and that would be Kyle Bryant?
Yes.
And Tom Goodell?
Yes.
Any other detectives?
There were a lot of people in meetings.
Okay, so they were, okay, so you're talking about meetings, but did you ever go in and just talk to them in a granular level as to why you arrived at the conclusions you arrived at?
Yes.
And how often would that happen?
There were multiple occasions that I got to a granular level.
Okay. What about the command staff? Did you ever get into the granular level with the command staff?
All right, now they're gonna do the nitty gritty thing.
There were multiple meetings where command staff was present, and I outlined why I came to the conclusions I came to. But as far as sitting down and going over every artifact, no.
Okay. And would it
And
be,
this is where it jumped
would you
us
have
right
been
after
invited
this.
to do that by the command staff?
Objection calls for speculation.
I'll sustain that.
No matter who they were? In granular, we're talking about,
Nitty-gritty is different from granular.
I'll sustain that objection.
how would you describe granular in the way we're talking about it?
Painstaking detail, like getting into why that artifact is the way it is, how it came to be there, going through that way. So some of them were down to that level, but not the entirety of the case, no.
Okay. And when you say some of, you're speaking to the people when you say some of them?
Yeah, there were different times throughout this investigation where I would sit down with various different people, and depending on what was desired, I would go through exactly how I arrived where I was. Some people wanted overview, some people wanted to see down to the detail.
Okay. I have no further questions, Your Honor.
All right, is this witness subject to recall again, or?
Sure, why not?
Okay, so you're still subject to recall, detective, so do not discuss your testimony with anybody, and you're still subject to the rule of witnesses, okay?
Thank you, Your Honor.
All right, thank you. You're free for today, though, I think, now. Yes, sure. He's free for today, though, right? Yes. Okay, thank you.
My brain is also mush. I just wanted to be able to like hear who was home when the devices were being used, who wasn't home when the devices were being used. Because the devices were used at the home. Exhausting. Exhausting. Look at Judge Penny. If this was Judge Glanville, he would have explained to the jury why we had to call this witness back. Oh. Oh, let me show you the boots. Look at the prosecutor's boots. Kick the jury out so we can listen. Two different Mavs in the building here. I'm so nosy. I want to hear everything that happens at the bench. Show us the bench. Yeah, we are caught up all the way. This is the type of day. Okay, it looks like they're done.
All right, ladies and
The
gentlemen,
transcript's going to be like way shorter.
We try the best intentions to get everything lined up as we can, but it appears that the defense at this point doesn't have any other witnesses that are available today. All right. So what I want to do with you is if tomorrow we can start at 9:30 and possibly go to 5:30 because I got to make up this hour because I'm chasing a snowstorm. Okay. So 9:30 to 5:30 tomorrow, if that's available for everybody. Can we do that tomorrow, 9:30 to 5:30? And I know we had talked about no Fridays. Attorneys wanted me to float with you if you were available for this Friday. If you're not, that's fine, because I told you no Fridays. But if you get back there and you can let the deputy know if all of you are available for Friday, we could do testimony on Friday. Just this snowstorm is just, I'm trying to chase it. I really am. And I want to get as much in as I could before that occurs on Saturday night. So allegedly. So we will see, but you never know around here, but I just a little concerned about it. So if you just let the deputy know, and if you don't know tonight or you'll know by tomorrow whether or not Friday's an option, just let her know. And if it's not, I understand because we had told you no Fridays, okay? So anyway, but you're done for tonight.
We risk the following week after February 6th?
No, we don't risk it. We are definitely ahead of schedule. We will have this case to you next week, depending on the snow. That's what I'm worried about, is if we get 12 inches of snow in this area, we might be out for 3 days next week, and we might not be back till Thursday or something like that. Hopefully not. Hopefully we can get the roads cleared and get you in here as quick as possible. It's my decision whether to close the courthouse, so believe me, I will be trying to get it done as we can, okay? But I just want to keep that in the ballpark, so that's why I'm trying to get the Fridays done, just in case, because I just don't know about next week, okay? But even if we come in Thursday next week, we will still be done by February 6th. I'm pretty confident.
Juror is over it.
All right, so have a good night. Don't talk to anybody about the case, and don't do any outside research, please. All right, thank you.
I don't think Penny was saying she's worried about a storm like on Friday. I think she's trying to say she's chasing the storm in terms of keeping the court calendar going in case there's closures next week.
Good night.
So. She's puttering. Thank you, Sheriff Chuck. Oh, I see some green. Shout out to Sheriff Chuck for the 5 gifted subs in the chat.
So we'll do 9:30 to 5:30 tomorrow. Are you working on jury instructions? Are we getting those done?
Yes, ma'am.
Okay, so maybe even if they can't come in on Friday, maybe we can do jury instructions on Friday. Okay, figure it out. All right, thank you. See you tomorrow at 9:30.
All rise.
So I don't get what we're doing here. I'm a little confused. So maybe they didn't want to call Lidsky back up. Like, they could have had him talk about raw data for an hour, right? Oh, did they just run? Do you guys want to watch the run?
9:30 to 5:30 tomorrow. Are you working on jury
Today
instructions?
was a
Are you
mess.
getting those done?
Yes, ma'am.
Okay, so maybe even if they can't come in on Friday, maybe we can do jury instructions on Friday. Okay, figure it out. All right, thank you. See you tomorrow at 9:30.
All rise.
All right, now we're on the seal. Now we are on the seal. So guys, I don't know if, I mean, I would hope that they stream whatever happens on Friday if they're going to do jury instructions. That's going to be a kind of hodgepodge day if there's going to be a stream for jury instructions or whatever they do in court on Friday. because there's also a Courtney Clenny hearing on Friday, which I said that I'd want to watch. So it might be a hodgepodge stream on Friday. We'll see. The Courtney Clenny hearing, that's also East Coast. That's Florida. So that's 9 a.m. is when that's supposed to start. So we'd have like an hour of room there. And sometimes it's not streamed live. Sometimes you only get it in the evening after Law and Crime has posted something after the fact. So who knows? We'll see how that shakes out. Tomorrow, I don't think there's cameras that are going to be present, but it is Cardi B hearing in the Imani Ellis case. Kind of just want to hear how that goes, but it might just be something where we look for the minute order. And other than that, a long day. They're going to try to go to 5:30 tomorrow. So planned for same start time. Or did they say 10:30? Whatever start time, we'll start at the same time. You know, I never catch that. I never catch when they say they're going to start. I always miss that. And then they're going to go till 5:30 tomorrow, which is like an hour and a half later than they went today. So yeah, this is a wild day. I have no thoughts. I thought the blood spatter expert, I liked that they didn't have LeAnne Singley go into conclusions. I liked that they kept it to, hey, we can't make conclusions about that. I thought that was pretty refreshing. I thought it was going to be a bit more of, well, I think the spatter says this. Well, I think the spatter says that. That's a little bit different what we got. Then we have this hot mess that I don't have words for. We don't get this report admitted. I can't be the only one that thinks this digital forensics is critical. And any momentum that could have been had, well, the state didn't ask you to testify here. And this witness, Detective Miller, acted confused about that. He was like, oh, about the proffer? No, the state didn't call you as a witness for this very trial. I don't feel like that oomph was pulled out in front of the jury. So the two things that I think are big deals, the state did not want to talk about the digital forensics, and they also didn't collect fingerprints from the electronics. That's not something that the defense has an equal opportunity to do. The defense, John Carroll was not at the crime scene. He didn't have the opportunity to say, hey, you should probably collect fingerprints from those things. It's the state either does it or they don't. It's not something that the defense can go back in time and redirect and change. And then we don't have the state calling this digital forensics person. I think that really speaks volumes about the state's case. We hear, although it was like tug of war to get it out of this witness, any change after a review to the executive summary, the only different information is Juliana's words. So again, sure, if we want to say the digital forensics, we can't determine who was physically on a device at a given time, but we have some information that maybe he used to change his opinion. That information isn't hard facts. That information is Juliana. So again, it comes down to her credibility. Like, I just don't know. Nina says maybe the report is damaging for both sides. Now, the thing is, it's not damaging in the same way if something can't if you can't pull a conclusion for sure from data. What that could hurt is the party with the burden of proof, right? So I would say maybe the report isn't exactly helpful for the defense because it's not going to show definitively a conclusion that Christine was on this device all of these different times. But it's also on the flip side, the state can't determine that it wasn't Christine and that it was Brendan and that it was Juliana at Brendan's direction. And again, the issue for me comes down to Juliana lying in her proffer. And that's what I think the defense really needs to get out with Lidsky. These specific messages, not just Brendan used the devices sometimes. Juliana pointed out, here's something that was specifically Brendan. And my guess is the data shows that Brendan wasn't at the house at this time, so it just could not have been him because these devices are only used at the home. So, I don't know. I mean, all of these things say reasonable doubt, but I think this mess, if a juror is like, hey, I think this guy's really guilty, but I'm open to hearing what the defense has to present, and then this is what the defense is presenting, I don't think that individual juror is going to, be persuaded here. So, oh man. Yeah, Mavka says, what is the other, so Lidsky he has other stuff that it seems like he's going to talk about that isn't part and parcel. It's not intertwined with Brendan Miller's executive summary. But I think he wants to be able to challenge what seems to have changed in the executive summary. And I would imagine we're going to hear about those 5 specific statements that Juliana identified in her proffer. So, I don't know. Do you guys want to do a quick poll before we get out of here? Let's see. Start a poll. Has the state proven their case beyond a reasonable doubt? And the reason I do this question, has the state proven their case beyond a reasonable doubt, is I think that should be the question. Like, it's not just, do you think someone probably did it? All right, so the poll is live. There's only 2 choices. I know that's hard. I know that's hard. I'm very disappointed because this is what I wanted to hear. Now, don't get me wrong, we still have tomorrow. But I think they're very, very lucky that, let's say, for example, what happened today actually happened tomorrow, which is the Friday for court for the jury, right? They go home. They don't come back for Friday court. The jury goes home. They have a long weekend. Imagine if this mess was the last thing we had for a weekend. And you're just like, so I don't know. Yeah, and I do really think this DNA and I think the state overpromised on the blood evidence, and I think the defense, in the way that they opened, if they can't get this report in, and they can't show us that, because I think what we're ultimately going to see is Brendan would be at work, and these devices would be in use, these accounts would be in use from the home, which would mean it probably had to be somebody other than Brendan. Now, the state can solve that problem by having Juliana testify and proffer that, well, we both use the devices. That can get us around the digital forensics issue of how Brendan supposedly did things where he wasn't home. But if there's any data points that show that Juliana wasn't home either, Brendan wasn't home, and these accounts are being used, that this data is being used, I'd imagine we have a problem. And I don't know if there's data that says that. We simply haven't gotten there. And I don't really know that that's specifically been hinted to. But it's something that I'd want to hear. Yeah, I really think this could have been a home run day for the defense. Again, not in proving that XYZ was definitively using the device, but in really hitting it out the park with reasonable doubt. And I agree that they just whiffed it. They whiffed it. So, I don't know, you guys. I don't have answers. Again, I still think that there's 5 different possibilities in play here. They could have plotted this thing, and Taco Supreme 7000 could have also been out for more than what Christine expected, or what Anastasia 9 expected. There's a lot here. My opinion. I think there's plenty of possibilities. What I do not think this is a situation where one partner's up to no good. The mistress, or the guy version of a mistress, whatever, finds himself in the wrong place at the wrong time. I don't think that this is a scenario where Juliana just ended up in that crime scene and it was planned only by Brendan and she had no clue. But You know, I think it could be possible that maybe both of them are innocent and Juliana lied because she wanted to get out of prison. I think it's possible it was his idea and she went with it from the start. I think it's possible it was her idea and he went with it. I don't know what to think of Taco Supreme because we don't really hear much evidence about him. I mean, he's a victim for the purpose of this trial, the way the state's alleging it. So we just don't have any evidence on the record of, like, was he of a stable state of mind? We got to hear that maybe he smoked some weed. Like, but did they test for other substances? You know, we didn't really get to hear what exactly they tested for or didn't test for. What was the channel you suggested something? Do you mean, was it related to this case? Or are you thinking of Everything They Missed? The podcast. Let's figure out. I'll drop the link to Everything They Missed anyway, even if that's not what Miss Good Janet's talking about. And again, that is about the wrongful conviction of Andrew Hayes, the Shelby County, Tennessee case. Yeah, Factual Lie says, I want to see Taco's records. Heck yeah. Mr. S, I like that. Mr. Stress. Oh, I love the chat. Yeah, is a guy version. It's got to have another name, right? Side dude. We'll just say side dude. Hey, Gloria, good to see you. Yeah, was Anastasia 8 taken? Yeah, Nina says they missed to show that Christine couldn't have used the devices at certain times. And so that would be like, if the state could show that, you would think that they would call this witness. That it had to have been somebody else. But Juliana, if you listen to Juliana's testimony and think she's credible, she has a justification for that. She says they only used the devices when she was actually home. So it was Your Honor. I don't know. Did someone in the chat mention it? Let's see. Yeah, I don't know. Sorry, Miss Good Janet Demeanor. And I feel like if I just search YouTube for Your Honor, it'll be like a million results. So it was me. Clipped videos. Earlier videos of when I went backwards and looked at Iris's testimony from yesterday. Yeah, I don't remember clipping. So yeah, and I'm gonna link to those timestamps that I clipped in case anyone wants to go and revisit this whole thing about the button and the different testing. And again, big thank you to Adventure Aaron for giving us some extra context about, you know, the process of, you know, trying to make sure you're doing the testing with integrity. So Eslo says, I'm on the edge of my seat. What is the data? Why isn't he being more clear? I'm so confused. Is it that lawyer just asking bad questions? Bad questions. I think frazzled. Also, he called witnesses out of order, so maybe he's dealing with a little bit of being frazzled, but still bad questions. So there we go, guys. I am not any closer to figuring out what exactly I think, and I'm hitting the end button on the poll, and we're gonna close this out. Hope to see you guys somewhere else in the YouTube streets. The poll results are for, has the state proven their case beyond a reasonable doubt? Again, very different question than do you personally think somebody's guilty? We have no at 87%, yes at 13%. So I think that's pretty similar to how the poll shaked out yesterday after the motion to strike, what we would think of as a motion for a directed verdict. Remember when that poll first launched yesterday? That was like, I never expected a disparity between the two choices like that yesterday. It was like 98 to 2% for a good 5-10 minutes. So, okay, and then Factual Lie says, Your Honor is a series starring Bryan Cranston as a judge. It's a great watch if you haven't seen it. And guys, I recently watched the show The Jury, which is like a reality version of a show. Like the whole trial is fake, but it's meant to be believable, and they have one guy that doesn't know that it's all fake. I thoroughly enjoyed. I watched all of the like extras and bonus footage and behind the scenes. It's really entertaining. It's funny. It's great acting. But it was really cool to hear the perspective of the guy, the guy that they chose. So if you guys have not seen The Jury, I believe I watched that on maybe Amazon. But it was good. I totally recommend it. It was it was really funny. It was so interesting and so funny. It was like the perfect blend of what you'd want to just like decompress, but you still want to watch something courty. You can get it in there without having to deal with like some of the sad stuff that we hear about in these cases. So yeah, okay, it must have been Prime then, because EJF says I have to go watch that before I cancel. So there we go, you guys. Thank you guys so much for all your thoughts, your conversations, pointing out different things that are going on, and of course, for helping fill the dead air between the slow questioning today. Big, big thank you. Thank you to Sheriff Chuck and to EDW Raptor turning the chat green today. And see you guys at 10 or 10:30 in the morning. You'll see when this YouTube gets scheduled. Bye, guys.